All right, good morning, everyone. We're back on the record on case CR 2221-1623, State of Idaho versus Tylee Daybell. We are continuing with jury selection, including small group and individual voir dire this morning. Court will note that the state is present, represented by the prosecution. The defense is present, represented by the defense attorney, Mr. Pryor, as well as the defendant here present. Are the parties ready to proceed with voir dire this morning, beginning with the state?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor. Thank you.
Okay. We will go ahead and have the bailiffs bring in our jury group. I'll please remind everybody in attendance here today that we are subject to the court's courtroom conduct order, so please make sure any of your devices are silenced or turned off. They'll be taken by the marshals if they cause an interruption. And counsel, I'll just also remind you to please not have, well, never mind. We'll go through the voir dire individuals once the jurors are brought in here, and I'll confirm that we are broadcasting at this point. Is that correct? Okay, so we're on the record broadcasting. I'll advise the jurors of that when they come in, and so we'll have the jury.
All right, please. Hands off, present, Your Honor.
All right, thank you. Please be seated. All right, good morning, everyone. We are on the record on the case CR 2221-1623, State of Idaho versus Tylee Daybell. The court will note that the attorneys and defendant are present. Is the state ready to proceed?
Yes, Your Honor, thank you.
Is the defense ready to proceed?
Yes, Your Honor. Thank you.
All right, before we begin with the voir dire of this group of jurors, let me inquire from the state. Is there any objection to the manner in which the jury panel has been recalled and seated today?
No, Your Honor, thank you.
Any objection from the defense?
No, Your Honor. Thank you.
Okay, thank you, counsel. Ladies and gentlemen of the jury, thank you for returning this morning. You've been recalled as prospective jurors in the case now before us. I'll reintroduce my court staff again and myself. I'm Stephen W. Boyce, the district judge for Fremont County, Idaho, and I'm in charge of the courtroom in this trial. The court clerk assisting me today, Shannon Holstein, is here, and she's keeping minutes of the trial proceedings and will also administer oaths to you as jurors. We have our courtroom marshals here also assisting in maintaining courtroom order and helping the jurors move about where they're supposed to go. Our court reporter is Mary Fox, who is taking a stenographic record of all the proceedings today, and she's seated down here to my left. And then over against the wall to my right, Courtney Stallings is my staff attorney, and she assists me with legal research and administrative issues that come up throughout the day. Each of you has been qualified to serve as a juror of this court. You've each filled out a questionnaire that's been reviewed by the court and the attorneys, and it's been determined to recall you for further questioning today. The first thing we do in a trial is to select jurors, in this case 12 jurors and 6 alternates for a total of 18 jurors from among the group we've summoned. The clerk will now call the roll of the jury using your red card. So you each have a red card. As your name's called, please raise that and indicate that you're present verbally for our record, please. Madam Clerk.
Juror number 823.
Here.
Juror number 1198.
Here.
Juror 1204.
Here.
1242.
Here.
Juror 1251. Here. Juror 1320. Juror 1332. Juror 1358.
Here.
Juror 1365. Juror 1378. Juror 1379. Juror 1389. Juror 1392. Juror 1424.
Here.
Juror 1535.
Here.
Juror 1541. Juror 1585. Thank you.
All right, thank you for returning. The court will advise the jurors that we are broadcasting this proceeding on the court's official YouTube channel for public access. Also, the courtroom is open. However, there are no cameras pointed towards or making any photography of you as jurors. However, your voices are subject to that broadcast. I'll next introduce you to the case and the parties at this time. In this case, the case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. Counsel, as I list your names, you may stand briefly. So the state is represented here by Lindsay Blake, Fremont County prosecutor. Rob Wood is the Madison County prosecutor. Ingrid Beatty, a specially appointed prosecutor in the case, and Rocky Wixom, a deputy prosecutor for Fremont County. The defendant in this case, Mr. Chad Guy Daybell, is represented by his attorney, Mr. John Pryor. This case is a criminal matter, meaning the defendant is charged by the state of Idaho with a violation of the law. I previously read to you a summary of the charges in the amended indictment when you were here last week to complete your questionnaires. With regard to the defendant, the state of Idaho has alleged that Chad Guy Daybell committed the following crimes. Count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. Count 9, insurance fraud. Mr. Daybell has pled not guilty to the charges. Please remember, that's simply a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is, what the law should be, or what any lawyer says the law may be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including any use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I am going to ask our clerk to administer an oath to the jury panel. The jury panel will be sworn for a voir dire examination. If each of you would please stand at this time and raise your right hands, I'll have that oath administered.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon your qualifications to sit as a trial juror in the cause now on trial, so help you God? Yes. Thank you.
All right, thank you. Be seated. I'll note for the record, each one of these jurors did take the oath just given by the clerk. The clerk's now impaneled 17 prospective jurors this morning for questioning in a small group today. Will the state stipulate that these jurors have been properly called and impaneled?
Yes, Your Honor, thank you.
Will the defense stipulate as well?
Yes, Your Honor, thank you.
All right, thank you, counsel. The court will also note that the jurors, each 7 of the 17 has completed a juror affirmation indicating they've not, or they have followed the court's admonishment to not look into the case between now and the time they filled out their questionnaire last week. And I will just confirm that with the bailiffs. I am told that all of the questionnaires, or I'm sorry, affirmations were returned. Is that correct?
That's correct, Your Honor.
Okay. In this part of the jury selection process, then you're going to be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. Voir dire is an ancient Anglo-Norman term dating back hundreds of years to the origins of common law, and in Old French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge you may have concerning the subject matter to be tried. The object is to obtain 12 persons who will impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand this questioning is not just for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, please hold up your red card. And when you're called upon to speak, you may identify yourself with that red card number. We won't be using your names through any stage of these proceedings. Because this proceeding is being reported by our court reporter, please make verbal responses to any questions such as yes or no, and try not to just shake your head or say or because then we don't get a clear record of what's stated. In addition, try not to talk at the same time as any attorney that may be questioning you in the court, again, so we keep a clear record. If you have any response that you think is too personal or would be embarrassing to discuss in public, or for whatever reason you don't want that to be addressed publicly, you can tell us and we will discuss that in a more private setting outside the presence of others in the courtroom and individually. Also, if you have answers to any questions that you think may prejudice any other prospective jurors or any of the participants in this trial, please refrain from those comments until we can arrange again to have you discuss that outside the presence of other jurors. Also, if you have knowledge of this case from pretrial media coverage or publicity, please don't start talking about any facts of what you may know. We'll discuss that with you individually again so that other jurors don't hear the information that you may already have. I'll now read to you a special instruction that's being given in this case as follows. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and or Alex Cox. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I'll instruct the attorneys to please avoid repeating questions already asked in efficiency, and the attorneys do have the right, however, to direct follow-up questions to a juror's responses. The jury should be aware that during and following the voir dire examination, one or more of you may be challenged. Each side has challenges, what are called for cause, which means that each side can ask that a juror be excused for a specific reason. In addition, each side has a certain number of peremptory challenges, by which I mean each side can challenge a juror and ask that he or she be excused without giving a reason for the dismissal. If you are excused by either side, please do not feel offended or don't feel like your honesty or integrity has been questioned, because it has not. And in addition, I'll note that if you are excused and you are approached by anyone after your excusal that wants to talk about the case with you, once you're dismissed, you are excused from your service and you can do that. However, please bear in mind that we are in the process of trying to obtain impartial jurors. You don't have to talk to anyone who may question you. And if you do so, please respect the opinions of your fellow jurors. And also bear in mind that we're trying to keep down publicity in the case until a jury is selected. At this time, I am going to begin the court's phone voir dire, after which the attorneys will be given an opportunity to make their own voir dire inquiries. When I'm questioning jurors, please pay attention to what's being asked, because you may be recalled to answer those same questions. The first question I'll ask of the entire panel is as follows. Is the information provided in your juror information forms still true and accurate? And in addition, are your responses in your questionnaire true and accurate as well? If you believe that's all still true and accurate information, please raise your red card. All right, thank you. We've got juror 1332 that did not raise your card. Is there something that you would need to correct or clarify in your
I
questionnaire?
wasn't feeling very well when I got this paper and they asked me to fill it out. Looking back, yeah, there were a few answers.
Okay, that's fine. It was a long questionnaire. I understand. We can talk to you about that probably individually or maybe further in a group, but we'll return to that. Thank you for notifying us of that. The next question.
Judge?
Yes.
I apologize for the interruption, but I saw 1378 did not raise his card, and I thought maybe he has some issues as well.
Oh, thank you, Mr. Pryor. I didn't notice that.
I just wanted to state that my work is to say that I would get compensation for being on jury if I have to. I answered that I couldn't because of that. I wasn't sure, but they said that I could, so.
Okay, well, thank you for that follow-up information as well. That will lead us into the next question, and I'll ask if this applies to you, you can raise your red card. I want to discuss the time commitment required for jury service in this case. So if you are required to serve as a juror, it's going to be for a period of approximately 8 to 10 weeks. The question is whether or not that time frame or amount of time would create a serious hardship upon you or your family or your business or profession or occupation, so as to prevent you from rendering service as a fair and impartial juror in this case. If you think you may suffer a hardship based on the length of the trial, please raise your red card. Okay, if you could keep those held up for a moment, we'll note down who we've got. All right, we're going to go through individually and talk to each of you about this at this time. And the court in this stage of the proceedings will allow for attorney voir dire also on the issue of hardship. So the first juror we'll speak to is juror 1535. I may have written that number down wrong. Do we not have that?
Got it right, 1535.
Okay, thanks. I was in a different order here. Let's talk to you first then. Juror number 1535, you did raise your red card. Let's discuss the length of the trial. What's your concern about a possible hardship if you had to serve?
The provider for my family. If I take that much time off, I don't know if I have enough money to pay the mortgage or any of that, and I don't have any vacation time at the end of the summer.
Have you had a chance to discuss with your employer the possibility of serving and whether or not there's any way that you receive any compensation if you are serving?
I haven't asked him about compensation, but he knows that I'm here today, obviously.
We don't need to get into too many details, but is this a small company, a big company? How many employees total are in your
I
company?
would say there's about 20 of us.
Okay, so small business.
Yes.
And you are concerned then, if I'm understanding, that if you're required to serve, you may just be going without a paycheck during that period?
Yep.
Are you a sole provider or is this your sole source of income?
My wife works part-time.
All right. Follow up from council, please, beginning with the state.
No follow-up, Your Honor. I think given that information, the state would challenge this juror for hardship.
All right, Mr. Pryor.
Judge, I would agree that this is a hardship.
All right, juror 1535, if you're in that kind of an employment situation, given the length of this trial, I do believe that would create a hardship for you to be out of work that long. So the court will grant the state's request without objection to strike 1535 on the basis of a hardship. Thank you for returning this morning, and thank you for filling out your questionnaire last week. You can submit that questionnaire, please, to the bailiff on your way out, and you are excused from jury service. You're welcome. Apologies for being a little out of order here, but we'll next talk to, I believe, 1541 also. Okay,
The only concern I have is that I'm a team of 3 and we are just hiring a new administrator and a temp, and I have a coworker that's going out for surgery. So my hardship would be my team at work. For that long period, and she has surgery on April 18th, be out for about 3 weeks. And we'll be training a new administrator and a temp, training the temp on April 8th.
okay, and again, without going into detail here, your employer is the county, correct?
Ada County Highway District.
Okay. And could you repeat, please, the information that's beyond the employment concerns?
My team is considered of 3 of us, and our administrator left us. We're hiring one. Hopefully we'll find out the new administrator at the end of this week. My coworker, the other procurement contracting technician, has had a back surgery on April 19th. She'll be out for 3 weeks. We're hiring a temporary employee to help and assist us, and she starts April 8th. So they'll be really shorthanded if I'm here between those 8 to 10 weeks.
All right, let me ask for any follow-up or dire from the state.
Your Honor, given that information, the state does not have any additional questions. We would actually make a challenge to this juror based on hardship, given the information she provided.
All right, Mr. Pryor, response from the defense.
And Judge, I know it's not relevant because she probably won't even be on jury service before that, but I understand her stepdaughter has a graduation Friday as well.
Oh, yes, that is correct.
That-
Yes, that is correct. And it's in
That's right.
Twin Falls in the morning
So
as
Judge,
well.
given that, I think it's appropriate to excuse her.
All right, considering the request for an excusal for hardship and a motion to strike made by the state without objection, the court will grant the request, and juror 1541, you're excused from service. Please leave your questionnaire with the bailiff. Thank you for taking the time to complete your questionnaire. Let's next go to juror 1585. So I know in your questionnaire, you did raise some concerns, but also didn't think it would be a hardship. If you'd like to explain why sitting here today, you believe it's a hardship, you can do that.
So previously I didn't think it would be a hardship, to be here because I thought I could finish my semester online. But my instructors let me know that that wouldn't be possible. I'm a full-time college student and I would like to finish this semester, so I only have one more to go. And, obviously being here would delay that and leave school for another semester. So
Okay, where are you in terms of progress through the you're currently in a semester right now?
yes,
And when is that scheduled to be done?
beginning of next.
All right, if you were out for these 10 weeks, then you would essentially lose the semester. All right, any follow-up questions from the state?
No, Your Honor, we also had a note here to follow up on that hardship. I think given that additional information, the state would make a motion to remove this juror for cause based on hardship.
All right, response from the defense?
And Judge, in addition, if I'm not mistaken, she also, and I'm not trying to expose information, you have a 7-year-old son, from what I understand.
3,
I'm
Yes.
sorry?
yeah, 3 years.
Oh, it's a 3-year-old? Oh, I'm sorry. That more, I guess, more of the case. So not only does she have her education that she has to be concerned about, also having to, I was under the impression it was a 7-year-old. My memory must not be as I thought. A 3-year-old son, so I would just move for hardship as well, Judge.
All right, I've considered that. Noting in the questionnaire, it wasn't initially listed as a hardship, but I guess upon further consideration, the jurors thought about that and the prospect of losing a whole semester of school, in addition to these other issues brought up without objection from either side, the court would agree, juror 1588, that would constitute a hardship. So thank you for coming in and filling out your questionnaire. You can be excused with thanks to the court. Let's next talk to juror 1198. Okay, you did list some information in your questionnaire about the hardship. If you'd like to explain what information you have in addition.
I've started a job recently in the last few weeks. I guess twofold concerns. So just recently starting a job, I only have access to the person who I am replacing for just a few weeks. So just concerned that a lot of the knowledge that I should be learning will leave with the person that I'm replacing. So that's the first concern. Speaking with HR at my company, I'm only compensated for 2 weeks of jury service, and I am a sole parent of 4 kids.
All right, follow up from the state.
Your Honor, the state also had a note to follow up on that hardship and specifically what he'd indicated. I believe there was also an indication of a soccer tournament in May, the triathlon in April.
I have since not done a triathlon, but yes, I have 2 children doing so.
Is that still a concern for you as well?
Yes, because I believe there will be some Fridays.
Your Honor, I think given the work hardship as well as the obligations to the family hardship, the state would make a motion to remove this juror for cause based on hardship.
All right, request or response from the defense.
Judge, I would have also moved for excusal based on hardships also.
All right, the court's considered that with the explanation from this juror that may only receive pay for a 2-week period and given the length of the trial and that he's a sole provider of income for the family, the court does find that there's been an expressed hardship requiring your excusal. So juror 1198, thank you for coming in and completing your questionnaire. You can be excused.
Thank you, Judge.
You're welcome. Juror number 1242. In your questionnaire, you didn't list any type of hardship. Can you explain?
Yes, Your Honor, I think when I had taken the test, I didn't really fully realize the implications of the time involved. As well, I've got two concerns. Number one is the hardship of work. I did have a chance to speak with my HR department, and although they grant me the time off to attend and participate in the jury, I would receive no compensation. 8 to 10 weeks of jury duty would cost me in excess of $25,000 in income. I'm 63, single, and that would have a high impact on both my potential retirement as well as my personal savings. My second concern is that last year in June, I was diagnosed with systemic lupus erythematosus, which is an autoimmune disorder. And part of the circumstances of that disease is that they have certain triggers and things like that that cause flare-ups. Flare-ups during lupus can result in hair loss, full body rashes, extreme fatigue and nausea, inability to participate pretty much in anything. And so my concern with that is that I believe that the stress and the anxiety that I've experienced in this involvement in this case would potentially impact my disease. And that could make me unable to participate at all. I could, a bad day for me could last 3 to 5 to 7 days. Since my diagnosis last June, I've had 3 flare-ups. First one lasted over 2 months. That's the first time I lost all my hair and such like that. Second one was in October and November of last year, and the last one I experienced was in February of this year, and that was about a 5 to 7 day stint. It's something that I have no control over, and I manage my diet and my lifestyle to avoid stressful situations. I also have to avoid sunlight and heat and exhaustion. And so between the loss of the income, I am a sole provider in my house. I don't have a family, but at this time I also have an elderly dog who's been diagnosed with a large part, and she is on her last, probably her last year with the family. She requires medication 2 times a day. And so I basically am the sole care provider for her. I work from home because of what my disease now. Had I needed to report to an office, I would need to go onto disability because I'm just too inconsistent. I approached my doctor on Monday to write a letter to the court explaining my circumstances. And unfortunately, I was not able to get that this morning. They were not open on my way in. But I would be happy to provide that written doctor's notice to you regarding my disease as well as the hardship of my loss of income.
All right, Juror 1242, thank you for the explanation. Does the state have any follow-up for Dr.?
No, Your Honor, I think given all the information provided, the state would make a motion to have this juror removed for cause based on hardship.
All right, response from the defense?
I also move for exclusion of cause.
All right, thank you. Juror 1242, for the reasons you've explained on the record, the court does find that would constitute a hardship of service for both the medical issue as well as financial. Court will excuse you from service. Thank you for coming in and completing your questionnaire.
Thank you, John.
You're welcome. Oh, we have a card going up on juror 1204.
I would like to add my number as possible hardship as I did enter information on the question about possible hardship.
Okay, we'll come back to you then in a moment. Let's talk to juror 1332 next.
Does he have a question?
Yeah, I'm looking at your questionnaire, juror 1332. You filled out on that part of the questionnaire and did talk about a potential hardship here. Would you like to explain that to the court this time?
Well, my hardship is basically my husband. He's a sole income for our family. We live here together. We don't know anybody, and he works in the middle of nowhere. He's on a specific diet, and I have to prepare and pack all of his food for however long he's gonna be gone. And he works on somewhat of a fireman's schedule. When the machine breaks, he has to go. So it gives us not much time, and it's kind of like being always on call.
All right, if you were able to be home each day late in the afternoon, would that give you adequate time to help prepare those meals for your husband?
You know, it's not something I can say definitely, because he could get a call at 9 o'clock at night, he could get a call at 6 o'clock in the morning, he could get a call anytime. He doesn't only work in Idaho. He works in Oregon, Washington, Nevada, and California, and Idaho. And travels through the whole Pacific Northwest, he works on giant inverter machines that transfer power to the utilities. And they're not happy when their machines go down, but other than the 2 plants he takes care of in Idaho, all the other plants are 6 hours at least one way.
All right, during the course of the trial, do you think there's a way that if you were unavailable to prepare his meals, he might be able to prepare some of those meals on his
No, he
own?
would take whatever's in the refrigerator, throw it in his lunch pack, and who knows, because he's in the middle of nowhere where he's working, he can't just hop in the car, or it's time for lunch, go to town and get a sandwich. Like, he's on a special diet and he can't eat out. So he gets really sick when he does. And I work really hard to keep him healthy and keep us going. And, he's older now, and it would be nice if he could really retire when he turns 65, but that's not the case anymore.
All right, any follow-up, Board Member from the state,
I have no follow-up, Your Honor, thank you.
from the defense?
And ma'am, from what I understand, and again, I'm going off memory, but 41 years of marriage. So
Coming up on 42, we've
Please-
been together almost 45.
please
So
forgive me, we're about disclosing we're about the same age, and this has been a lifelong partner.
our whole adult life.
And one of the concerns is also in the event that you're sequestered, and you understand what that means, locked up and having to consider something.
Couldn't handle it. Couldn't handle it.
You basically have been inseparable for 41 years.
Absolutely.
And not only would that cause you a distraction and not be able to process what needs to be processed in this case.
Absolutely.
Would there be a concern? I don't even have to ask. I guess there would be a great concern about how your husband was doing it.
Absolutely.
And that would be a significant distraction.
Absolutely.
Given that, Judge, I'm going to move for cause to have this juror excused. I think this is a significant hardship.
All right, I've considered the hardship expressed with juror 1332. I'll grant the strike from both parties here. So 1332, you're excused. Thank you for filling out your questionnaire and coming in. Uh, 1204. I believe you also have something you want to discuss. Is that correct?
I just have a family vacation, June 15th, which I think it's odd. I know the time frame, depending on when the trial starts.
All right, I'll defer more to counsel. They are the ones that would know best on trial length. It's my understanding we should be done by June 15th, but if the state has any follow-up to address any concerns about that time frame on this June 15th, vacation, we can follow up with that juror 1204.
Is this trip, if I can ask, is it paid for, pre-planned?
Pre-plan is paid for.
And would you be able to get any, money back if you weren't able to? Right now, at least the trial is set to be, I think what was advised is an 8 to 10 week trial. So that shouldn't put you into that time frame. Do you have concerns sitting here today if it is close to that 10-week timeline even?
March out. Straight up.
Okay, the state has no additional questions at this time.
Any further board data from the defense?
I'm not anticipating going to June 15. I guess what I'm concerned about is what if we do? I don't think so. I don't want to speculate, but by the same token, Judge, I'm concerned about the distraction, and that would be a distraction if you were still doing this on the 13th or 14th. That'd be fair. And that's what, then you just answered my question, which is, if, for instance, we stop and then there's deliberations, we start on the 13th, you're going to be highly motivated to be done by the 15th, aren't you? Like, Judge, and please, sir, don't take this personally. We're just all trying to be fair. So, Judge, I think given that, I think I'm going to move for cause with this.
All right, response from the state.
Judge, the state would just submit on the information provided to the court.
All right, the court is at this point going to overrule the challenge for cause on 1204. We have to try to fit in this trial around everyone's schedules, including jurors, and I'm in good faith going to tell you I do believe the trial will be done not to interfere with that schedule. We can't all predict the future with certainty, so we're trying our best to move things along, and from what I see so far, it does seem to be moving along on schedule. So, Juror 1204, appreciate your concern. We're going to have you remain in the jury pool for further consideration. We go through another step of peremptory challenges after this. So, with that, the court will allow 1204 to return for peremptory challenges. Thank you. All right, the next question we're going to go through would be on knowledge of the case. And several of you, I'm sure, in reviewing your questionnaires have indicated you do have some information or knowledge about this case. If you do have any information or knowledge other than what you've learned since you've been summoned as jurors in this case, would you please raise your red card? Okay, none of you have heard anything about the case other than what was told to you in court when you got here last week? Okay, thank you. Let me next discuss the subject matter of the case. This case involves charges the state's filed, including charges of murder, conspiracy, and insurance fraud. Is there anything about those charges and the nature of those charges that you think would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and render a fair and impartial verdict?
Your Honor.
Okay, no one answered affirmatively. I'll next ask some questions that seem like they might be very obvious, but I'm required to ask them pursuant to some Idaho statutes and law. Are any of you related by blood or marriage to the defendant or know him from any kind of business or social relationship? Okay, no one answered affirmatively. Do any of you have any kind of legal relationship with some of those involved in the court here. So does the relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, boarder or lodger exist between any of you and any of the attorneys involved here? Okay, everyone answered no. Are any of you a party in any kind of civil litigation or lawsuit against the defendant, Mr. Daybell?
No.
All answered no. Have any of you ever brought a criminal complaint against the defendant or been accused by any of the prosecutors here of any crime? All right, everyone answered no. Do any of you have any kind of attorney-client relationship or previous attorney-client relationship with Mr. Pryor or his law firm? Okay, all answered no. Do any of you have any kind of a relationship by blood or marriage to any of the lawyers, or do you know any of the lawyers from any kind of professional, business, or social relationship?
No.
All right, everyone answered no. Have any of you ever formed or expressed an unqualified opinion that the defendant is guilty or not guilty of any of the charges in this case? And if you do answer yes to that, we'll talk to you individually. Have any of you formed an opinion already about this case?
No.
All right, all answered no. Do any of you have any bias or prejudice for any reason, either for or against the defendant, Chad Daybell, in this case?
No.
Everyone answered no. Are there any of you here that would be unwilling to follow the court's instructions to you as the jury?
No.
Everyone answered no to that. Do you have a religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict in this case?
No.
Okay, everyone answered no there. Would any of you be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the laws instructed by the court?
No.
Okay, everyone answered no there. One final question I call the catch-all question. Do any of you have any other reason you haven't discussed here already why you could not give this case your undivided attention and render a fair and impartial verdict? All right, everyone answered no to that. With that, that will conclude the court's voir dire examination. I'll next let the state proceed with their voir dire. After that, the defense may. Who's going to be conducting voir dire?
I will be, Your Honor.
All right, Ms. Blake, you can commence.
Hello, ladies and gentlemen. Thanks for being back with us this morning. I know this process has been long. You all had to come in last week and fill out a questionnaire, so we appreciate you sticking with us through this. As you may know, we want to just be thorough as we're selecting a jury. Both the defendant, Chad Daybell, and the state of Idaho have the right to a fair trial. So we're going to ask you some questions today. None of them are meant to offend. I don't really want to put anyone in a hot seat, but I will be asking some of you questions and I will be asking for responses. So I just want you to know why we're doing that. If I were to use the term brutal honesty, I'm going to ask some people what comes to mind. Juror 1392, if you hear the term brutal honesty, what do you think of? So just telling the truth, saying it how it is that fair? Okay, and juror 1379, same question.
I think I would agree, just honesty without that fear of consequence, just being honest regardless of what the consequence might be.
And would you all agree that it can also mean not holding back, not trying to spare someone's feelings? Would everyone agree with that? And the reason I bring that up is we're going to ask you to commit to being honest or brutally honest, both today as we go through these questions with you, and also at some point, if you're selected as a juror, you're going to go back once you're instructed by the judge and start deliberating with each other. And we want to ensure that anyone serving on the jury can be brutally honest, both here today and further into the process. And we all may know someone that we feel like we can go to get just the honest, how it is answer. So for me, I had my first niece, I found out when she was pretty young, she wouldn't filter her answers. So if I really wanted to know how something looked or how I was looking that day, I could go to her and she did not hold back. And so I don't know if some of you have someone like that in your life, but that's what we're asking for today. Don't hold back. Just tell us how it is. You've also heard from the judge what the charges are in this case. We have multiple counts of conspiracy to commit murder, and we also have multiple counts of first-degree murder. You had a question on your questionnaire regarding seeing graphic images. This case does involve the murder of 2 children, as well as a mother of 5. There will be some images shown, most likely. Does anyone here have concerns if they were to see images that are graphic in nature, maybe unpleasant to look at? That, and you're 1365. I think you have some children, they're older now. Does it cause you any concern of the idea of looking at images of maybe children that are graphic?
No, if it's in a court-related environment and you have to do that, and if it's going to allow more truth to come out and the facts to come out.
Thank you. And you're 1320. I think you also have children. Looks like they're adult children now.
Yes.
Does that cause you any concern, the idea of looking at images of children that may be graphic?
No, as long as it goes towards facts of the case.
And do you feel that you could look at those images and give them the weight you feel they're due in relation to other evidence presented in the case?
Yes.
Thank you. Has everyone here been on a plane before?
Yes.
When you get on the plane, you get the instruction at some point, they say, you know, sit back, lay back, enjoy your flight. We're going to arrive at our destination at such and such time. If instead you got on a plane and the pilot came on and said, hey, I'm going to try to land the plane. I think we'll get there at this time and I'll do my best to land. Would any of you feel comfortable staying on that plane?
No.
I'm seeing that shaking of the heads, and you're 1389. I saw you shake your head no. Would you want to stay on that plane? And why wouldn't you want to stay on that plane?
Experience a pilot has to have in order to fly an airplane. If he can't even make a guess as to when he's going to get in the air, you put the boat wheels down on the ground again. Sorry, what else is he going to make a mistake on?
Thank you for that. And you're 1358. How about you?
Would be my first choice. But as you mentioned, he should have, or she should have some idea of when they will land, how to land. So no, I'm not.
And the reason I ask that is because, again, when we talk about the trial and the right to a fair trial, we want to make sure that the jurors selected can land the plane. We want to make sure that the jurors can commit to being impartial, to weighing the evidence and rendering a verdict that they believe is the correct verdict. Does everyone here feel like they could commit to that?
Yes.
Thank you. So I have a little boy, and in the mornings when he gets up, if I ask him what he wants for breakfast, 9 times out of 10, it's cheesy eggs. But there's a very specific way he wants me to make his cheesy eggs. There's a recipe I'm supposed to follow. So that recipe includes milk and eggs and cheese and salt and pepper. Sometimes he likes them a little extra cheesy too, so we got to throw that in. But he doesn't want me to vary that recipe. Have any of you had that experience, whether with a kid or someone else, that maybe there's a recipe and they like it done just so? Juror 823, have you ever had that experience?
Yes.
Somewhat, okay. And juror 1204, have you had an experience like that?
Not to that extent.
Do you have kids? Are there any specific ways they like their food made or cut up or that they used to? They're pretty easygoing? Okay. And your 1251, how about you?
I'm okay with deviating from the recipe.
Okay. If you were given a recipe and told this is how you have to do it though. So, and what I'm talking about is the judge is going to give you some jury instructions. And those instructions are going to say how you have to handle this case. And he's going to give you an instruction that includes the elements of each offense that the state would have to prove. And there's going to be specific elements or ingredients. So you may look at them and think, well, and kind of like a recipe, you may think, well, if you added this or if you took this away, I think it would be better. But in the courtroom, you wouldn't be able to do that. Could everyone here commit that even if there was something that you wanted to see and you wish was an element or an element that you didn't think should be there, can everyone commit that you would actually follow exactly as that recipe or instructions written out?
Yes.
Does anyone have concerns with that? And with that, one of the things is when we get to the crime of homicide, does anyone have concerns that if it reads an actor did something that caused the death of another person, but the actual cause of death is not an element? Meaning if it is the state has to prove that a murder occurred, but one of the elements isn't the cause, does anyone have concerns with that, with following that instruction? Thank you. So today, as you headed to court, if the sky had started to turn gray, and then you got into the courthouse and we closed all those windows and we closed the blinds, and when you went outside, it was wet, your car was wet, the grass was wet, the pavement's wet, you start driving home, everything's wet along your drive, are you gonna be able to determine what happens?
Yeah.
And your 823, what would you determine had happened? And your 142, how about you?
4.
Oh, sorry, 1424, I apologize, yes.
Yeah.
And you didn't have to see it rain to make that determination, correct? So in this case, you'll hear different types of evidence, and some of the evidence you'll hear referred to as circumstantial. Does anyone have concerns that with the type of evidence presented, you would have concerns weighing that and giving the weight it's due? Do we have any football fans? I see some people nodding their heads. Juror 1358. I think Kansas City Chiefs won this year. Does that sound right? And even though it may be unfortunate, would you agree that everyone on that team should get a ring? So even though the quarterback may have played a bigger role, would you agree the punter should still get a ring? And the coach? So all those involved in that victory should get the ring. So you'll get instructions in this case, and again, kind of talking about that recipe that will say what the elements of each crime are. And it may include elements of aiding and abetting, commanding another, being involved that way. Does anyone have any concerns in following those instructions? And the judge gave you a bit of an instruction on, and it involved other co-conspirators or other individuals involved. And he's instructed you, you're not to concern yourselves with anything that's happened to them or cases. But in this trial, you may hear evidence or testimony regarding what those co-conspirators did and actions they took. In a conspiracy, if the state proves to you that there was an agreement to commit a crime, and then an additional element would be, and then one of the persons involved in that agreement took some action to further that plan to commit the crime. Does anyone have concerns if person B is the one that went out and committed an overt act or some act in furtherance, but the crime itself is the agreement to commit that crime? Does anyone have concerns holding person A still accountable? if you're following that recipe and that instruction. Thank you. I have no further questions.
All right, thank you, Ms. Blake. Mr. Pryor, Board for the defense.
Judge, would the court prefer to take a break or would you rather?
Let's go ahead and move forward at this point, given the time.
Ladies and gentlemen, I introduced myself before. I'm John Pryor. I'm the attorney for Mr. Daybell. And we're going to have to ask, some questions. And I don't want any of you, please, to imply that Chad is guilty of anything, because I'm going into areas of concern, and it's just part of the process. What we're really trying to do is to get your feelings and your honest feelings about a variety of subjects. And the reason we do that is because this is an important case. It's a serious charge against Chad. And we need to get as much information about your opinions about bias, about knowledge of different topics, about how you feel. And in order to do that, we're given a very short window of time to do that. Ms. Blake asked you to be brutally honest. I'm just going to ask you to just answer the questions as best you can. I'm going to ask you to tell me how you really feel, and remember that there really isn't any wrong answer. All of us think differently. If I were to poll you on an important issue, I would imagine if there were several ways to answer it, we'd get several answers. And not everybody answers things the same way. And what's more important than anything else, each and every one of you have a very important idea and perception of how you feel about different issues. And that's what we're really after. So when I ask you questions, again, I can promise you if you ask me questions, I'd probably have different answers, and all four of us here, the four prosecutors here, and myself would probably have 5 different answers. So again, there's no wrong answer. I've spoken to some of the other jurors before, and I talked about a story how when I was a young man and I wore smaller clothes, how I was on jury service. And the lawyer at that time asked the jurors, is there anyone who just really doesn't want to be here? Now, I struggle with that because as a citizen and having been raised by an absolutely wonderful mother, an amazing father who taught me the importance of doing your constitutional duty and your civic duty, and that we live in what I think is the greatest country in the world, that you don't shirk that duty. But he also said, and I remember this, and I've continued to do this for the almost 30 years I've been practicing law. And I ask all the jurors this. I do that because all of us have a lot of things going on in our life. All of us have had issues, and some things are important. Previous juror has a dog, and that's a very big concern. To some people who are dog lovers, that's a really big concern, and it's very important. Some of you have other concerns. Some of you are in the military service and having to focus on our military and protecting our country. Others have jobs where you're an accountant and you have responsibilities and potential hardships because tax season's coming up. And that's a concern. All of us have concerns. Some of us just don't want to deal with this because they find this very difficult. So I want to ask you, and I'm going to ask you to start off by just please tell me, and please be completely honest with me. This is our opportunity to share information and to kind of get an idea where all of you stand. So is there anybody who just doesn't want to do this? Just feels like, you know what, this is too much for me, or I have so much going on in my personal life that I just can't do this. And I would please ask you to be honest about that. Anybody at all? No? Okay. Now you've heard the charges against Chad. And you've heard the judge read the charges against Chad. And the prosecutors talked a little bit about elements, about a recipe, and I'll get to the the recipe part of this. But is there anybody, having heard the charges, immediately assumed that Chad was guilty because this judge read charges? No. Thank you. Thank you. Does everybody agree with that? No? Okay. All right. Okay. Is there anybody here who believes that Chad should have to testify in order to prove that he's innocent? No. Okay. No? Okay. Does everybody understand? And I'm going to ask you to get a little bit of exercise and raise your cards on this one. Does everybody understand that if Chad and I decide to, we don't have to put on a single piece of evidence? Does everybody understand that?
Yes.
And I'll try to limit the raising of cards. Thank you, folks. And does everybody understand that the prosecuting attorney must prove this case? And that if they don't prove the case, the verdict from you folks has to be not guilty. Do all of you understand that?
Yes.
Yes. Thank you. Thank you. That's okay. Okay. I want to go into a couple of, well, before I start that, I guess I'll go back a little bit. Again, if Chad decides not to testify, is there anybody here who's going to think that he's guilty because he chose not to testify? No. All right, thank you. Nobody? Okay. Now, I want to talk a little bit about bias. Does everybody understand what bias is? And would everybody agree that bias is you have an opinion about something, whether it's based on fact or truth, but you have an opinion about somebody and it may influence your judgment? Would everybody agree that? And I brought my mother up a couple of times and I'm going to bring her up again. Just a tremendous influence in my life. When I was a very young man, and please don't hold this against me, anybody, please, but I'm a transplant to the state of Idaho. I'm not quite born and raised here, but I've got 30 years in, so I feel like I've spent enough time in my life that I consider myself a true Idahoan. When I was born in the early part of my life was in the back east. And I lived in a neighborhood. And my mother's very best friend had a very close friend. And they didn't share the same beliefs, faith beliefs. And one day I was sitting there with my mother and it was a very hot day in back east. And back east, it gets incredibly warm. And this person at the time, and my mother was probably 40 years of age. And they were sitting there in the backyard. And I looked over at her best friend, and on her right arm were numbers. And there were about 5 numbers. And they had been tattooed on. So I asked her, why do you have numbers tattooed? And she said to me, well, I lived in Germany for a little while. And I stayed at a camp called Auschwitz. And I was surprised because I couldn't understand as a 7-year-old how someone would tattoo someone an arm and put numbers on there. And that was a good lesson for me because what it showed is that there are people who have feelings so strong that they would engage in that kind of conduct. And I can assure you, you can't count the number of people who have had that done to them anymore because most of them aren't here anymore. But that had a profound impact on me, and it was the best example of what bias was. And I want to ask you folks, is there anybody here who feels that you should judge somebody just because they may have different beliefs than you do? Please raise your cards. This is important.
No.
Saying no or saying yes?
If you say no, raise your cards. Okay, unanimous. Thank you. Do all of you understand that it's important not to judge somebody because of their beliefs? Okay. Do all of you know that we all may have different beliefs? That we all may believe some things that are different? Do all of you agree that regardless of how unusual or how unrealistic those beliefs are, we have to respect people for their beliefs? Would everybody agree that? And that we can't judge someone just because they may have unusual or beliefs that we just don't find realistic. Would everybody agree? And would everybody agree that you're not going to judge a person just because they may not conform to what you think is normal or average or standard beliefs about various topics? Would that be fair to ask that of you of that? Thank you. I'm going to move on a little bit. Have any of you watched any video, audio programming regarding this case or anything associated with this case? No. Not read any newspapers about it? Yes, I have. You have? Would you talk to me a little bit about that?
So, Mr. Pryor, if we're gonna go into detail here, I'd like to do that individually.
Okay, all right, thank you, Judge. Then I'll move on.
And which juror was that,
That was 1242, I think.
Okay. thank you.
1424, forgive me. Now, I'm going to give you an expression. And I want to know if anybody can give me an explanation. And if you can, and you want to, raise your card and I'll ask you individually. I listen to all kinds of music. I try to be open-minded about that, but I love country music. And that was developed because when I moved here, that seems to be a natural, maybe the way we live, at least from where I live anyway. And there's a really great song that I love, and when I listen to it, it always moves me a little bit. And the song is from a guy named Dan Seals. I don't think he's alive anymore, but he wrote a wonderful song, and it says, "Everything that glitters is not gold." Is there anybody who doesn't understand what that means? Is there anybody who understands what that means? Raise your cards if you understand what that means. Okay. And I'm going to pick on 1389. So why don't you talk to me a little bit about what you think it means when you say everything that glitters is not gold?
In the physical world, there are a lot of things that can glitter. For example, light striking off a crystal.
Okay.
Glitter off a crystal with a diamond. And the other is reflective surface, so it stands to reason that it's not going to be gold no matter what.
Okay. Okay. And I'm going to go to 1379 because you've got the biggest, finest smile I've seen for at least 2 or 3 days, and it's refreshing to see someone smile like that. So talk to me, because I think you're thinking about something else.
No, I loved the very definite
Right.
description he gave. I mean, I was thinking more in not quite such a literal sense that
Okay,
just
what were you
because you
thinking?
see, just because something is shiny and sparkly doesn't mean it's necessarily valuable or gold-like. So
Does anybody look at that? Because the song really goes back to talking about relationships. And juror number 1365, boy, was that a strong nod. And I'm not going to get into your past or your history or whether you've been in the situation where something was glittery but it wasn't gold. But you talk to me a little bit about that.
I look at it more, I guess I think of like the perfectly dressed couple and they're in the perfect house and you think, my gosh, they're making, all this money and then you find out that just because it's on the surface, that deep down inside, it doesn't mean that it's glittery on the outside, but everyone always has issues on the inside somewhere.
Right. And sometimes you may be tricked into believing that something is gold when it's just glitter. Or like in our city of Idaho City. And there's and we'll go, in fact, I'm going to jump to 1378. Where am I going with this?
All the fools that's up there.
Right.
Yeah.
And we have a wonderful ski resort called Boise Basin, right? And we all try to enjoy that when we can. Getting to the end, I think that we've got about another week or two, probably. Yeah. But that is where they believed that there was gold up there. So when you evaluate information and look at information, it's important that we really decide, is there really gold here or is it just glitter? Would everybody agree that we should be doing that? And I'm gonna move over to juror number 1392, because you haven't had a lot of reaction. You had a couple of things. What are your thoughts on this? Everything is glitter is not gold.
I just take it you can't judge a book by its cover.
Right. But all of us struggle with that. Would you agree with that? All of us have been in situations, whether it's a personal relationship, or whether it's a business relationship, or whether it's any kind of relationship, and we have to gauge somebody. And would everybody agree that we've made mistakes in terms of judging people who we thought may be gold, but reality is they may be glitter? Would everybody agree with that?
Yeah.
Okay. And sometimes it's too late, isn't it? Okay. Now, we're here today, and you know that you're supposed to, part of your job as jurors, if you're selected, is to evaluate the evidence and make a determination. And with respect to Ms. Blake, she talked about a recipe. But when you're looking at things and trying to make a decision, in the important decisions in your life, is there always a recipe to follow? And that's 1358. And I want you to talk about that.
Very few things have recipes. She mentioned a cooking recipe. Those have to be a little more exact, especially if you're baking. But I'm an accountant by trade. I have rules I have to follow. I have yet to find a situation that falls with those. Everything is in the gray area. So yes, recipes are black and white, but I do believe there's a lot of gray.
Right, and then I am dumbfounded how we got two accountants next to each other. With all the people here, we have two accountants. Are you folks going to be okay sitting next to each other? No, I'm trying to be a little, probably not much. But you're right, there's a lot of gray area in major decisions that we make, right? And we just don't check off boxes before we make a major decision about something that's extremely important to us. Does anybody do that? Raise your hands if you check off boxes and follow a recipe before you make a major decision. None of you. Okay. Do all of you take some time and balance things and look at things before you really make a major decision in your life? Is that what most of you do? Raise your hand if that's what most of you do. All of you do that. Okay. Now, Ms. Blake also talked about, she talked about the plane situation. And one of the jurors, and I think it was 1392, where are you, 1392? Oh, back there again. I'm going to pick on you again. All right. Are you okay with that? Good. And I think I'm going to move to 1424 in a minute because he's sitting there very quietly. And we'll get to you in a minute. But 1392, Ms. Blake talked about a plane and that you were going to make think really twice before you get on a plane if you're not sure it's going to land, right? But if you're thinking about whether a plane is going to land or not, it's kind of a guess, right? And another word for guess is a word called speculation. Do you understand what that word means? I try not to use big words because I'm not that bright. Okay? And I try to use simple words and talk very simply because a lot of times, would everybody agree that a guess and speculation are pretty much the same thing? Raise your hand if that's what you believe. Not everybody, oh, looks like it, except for number 12. Oh, you did. Okay, thank you. So when you're making a major decision in your life and you're trying to determine which direction you're going to go, is it a good idea to speculate about things? Ever? Raise your hand if you think it's a good idea to speculate when you're making a major decision in your life. You do? Okay, all right. And again, there's no, thank you, 1251. There's no wrong answer. So talk to me a little bit about when you speculated making a major decision.
I've had to make major decisions without having all the information.
Okay.
So I'm just thinking through how to go.
Okay. So you've done that. So if you've been given all of the information and you're told this is the information that you have, And that you have to make the decision based on all the information that you have. And that's the information you have to use to make your decision. Do you think it's a good idea to speculate about other things that, well, may affect it or may not affect it? Or you make that decision if you've been told you're only allowed to follow what's provided to you? Is that fair to speculate in that situation? Anybody? If you think yes, please raise your hands. Thank you. I'm going to go into two more areas and then I'm done, I promise, okay? And I'm going to go to 1424 this time. The prosecuting attorney, it was Ms. Blake today, talked about graphic pictures and seeing graphic pictures. And in the context of the media and these folks who, put things out on the media, would you agree with me that sometimes the media portrays images to get a reaction? Does anybody disagree with that? Does everybody agree that the media tries to sensationalize things to try to get you to get a reaction and to think something in a certain way? Is there anybody who disagrees? Raise your hand if you disagree with that. Nobody. So when you're showing these sensationalized pictures, the instinct is to react to them. And the instinct is to feel affected and to move in a certain way to do that, like in the media. Would everybody agree with that? You don't have to raise your cards, just nod your hand if everybody would agree with that. It's trying to elicit a reaction. So you're going to see very graphic pictures. And I told the folks yesterday that these pictures are going to hurt your heart. They're going to hurt your heart. And there's no way you're not going to have a reaction to these pictures. It's not possible if you have a heart. But what I'm asking for you folks to do is to look at the pictures and view the evidence, but don't allow it to sensationalize. Take the evidence as it is. But does anybody think it's fair that because these pictures are graphic, that you should automatically presume that Chad is guilty because of these pictures? Does anybody believe that by looking at graphic pictures, you should automatically presume that Chad is guilty? Does anybody believe that? No. Okay. And all of you can promise me, if there's anybody who can, please raise your hand. Please raise your hand. Can all of you agree that when you look at these graphic pictures, that you're not going to immediately presume that Chad is guilty because of these pictures are just so heart-wrenchingly graphic? Could everybody agree with that, please? Yes. Thank you. And this is the last topic, and I promise it's the last topic. I want to talk about people and honesty and how you judge honesty. I'd like to see if there's anybody here, and I'm going to put my hand down because I don't apply to this. Is there anybody here who's been honest 100% of the time in their entire life? Raise your hand if you've been honest 100% of the time in your entire life. I'm gonna hold my hand down. I'm sorry, you had a reaction. I'm gonna get to you now. You just prompted somebody back there too. I'm gonna start with 1320 because you had a big smile and I haven't had a chance to talk. We haven't had a chance to talk yet. Right, so what kind of instances do you run into? Do you find that someone has not been honest? What are the scenarios when you find people are dishonest? Business relationships, have you run into that? Yes. Where you're dealing with someone in business and they don't necessarily are honest. Personal relationships. Yes. Anybody been in personal relationships where people have not been necessarily honest? All of us, maybe most of us. Okay. And we're going to go back to juror number 823 because you had a reaction. I think it's from the gentleman by. Talk to me about your views on honesty.
I think most people try to be as honest as they can be. But sometimes people are a little more dishonest with their feelings or to get away with,
Get away with something,
yes.
or if they're trying to stop you from finding something out about them. Or if a guy says, honey, I was working late last night, and when in fact he was at a tavern with a beautiful young lady having a cocktail, he's not going to admit that, right? And people tend to be dishonest if they're maybe doing something in a personal capacity that they shouldn't be doing. Would you find that people are in that situation would have a tendency not to be honest about everything, to cover it up?
Tendency to, yes.
Okay, anybody disagree with that? Okay, we're gonna go back to 1378 because you're the one who caused 823 to have the reaction. So talk to me a little bit about honesty.
So I recently bought a car and it was a used car from a dealership.
Okay.
And someone, before they traded in the car, figured out some codes in the system, get a better trade value. Luckily, the dealership was working with me and taking care of those issues. They were not cheap issues. And I just think it's awesome that the dealership's being good to me, but I'm not very grateful. I don't have my car, but I were good loaners, so I'm happy.
But you think that people maybe, or instances, whether it's a business or people, if they're trying to protect something, and it could be something very simple, they'll be dishonest, right? We talk about people who have financial hardships. Juror number 1365. The couple shows up with the fancy suits and the sports cars and all the big house and all the other stuff, and then we find out that they don't have better watch my expression, right? They don't have a you-know-what to you-know-what in. And that's in a sense is dishonesty as well, right? But that's a simple thing. They don't want to be embarrassed, or they don't want someone to find out about it, so they may not be truthful about situations. And that may be a small white lie, it may be a big white lie, but it's because sometimes they're embarrassed about it, right? And that's why people lie as well. And then I'm going to go to 1379 because you keep smiling again and you're catching my attention with that smile. So please don't stop. So let's talk a little bit about honesty and what your thoughts are on that.
Well, it's a big topic. I think I agree with what's been said, though. I think most people do tend to try to be honest, but there are situations where maybe, budgeting the truth, there's very sensitive feelings or that type of thing, so.
Not being discovered about something they may be doing that they shouldn't be doing.
Right, or, through codes so they get a better deal, maybe they're motivated by that, but I think generally they're motivated.
Okay, and lastly, I just want to thank, I understand how difficult all of this is. And I understand how hard it is to sit there and have me pick you out and answer questions. I really appreciate it. I hope you understand the magnitude of how important it is I've been given this opportunity. The folks here, the prosecuting attorneys are giving the point at the same time in the court, because we need to be able to talk to you folks to get your feelings on a variety of subjects. So once again, thank you for bearing with me. Thank you for your time.
All right, that will conclude the defense for Dyer at this time. We're going to move on to some individual for Dyer with this group of jurors. This will be a logical point to take a mid-morning break. So we'll allow the jurors to be excused, and then we'll take a break for about 20 minutes or so. Come back in with our first juror for individual board Dyer question. I'll please rise for the jurors. All right, we'll take a break and return.
Okay, folks, we'll return at 5:00.
Thank you. Please be seated.
Judge, before you bring in the jury panel, the state was going to see if we may approach.
You may. Sidebar here with the white. Okay, let's go back on the record then, CR 2221-1623. We are going to now conduct individual voir dire of this remaining panel of jurors. And we'll be starting with juror 823. So if we could please have the marshals have that juror brought in. While we're doing that, I will note on the record that the defense is present as well as the defendant and the prosecution as well. All right, thank you, juror 823, for returning this morning. We've got some additional questions on individual voir dire. And I'm just taking a moment to review the questionnaire again. One thing I'd like to just bring up, because our schedule is set and everything's important here. I did note that I think you didn't appear when you were supposed to, but you did appear today, so we're happy you're here. And not to necessarily call you out on the spot, but I do think it's important we have jurors that are able to follow the schedule and be here dependably. And I would like to know if there was some explanation as to why you weren't able to appear when summoned. Was there some confusion there? Did something happen to prevent you from appearing before?
No, Your Honor, no confusion. It was just a honest mistake. I used my phone as my alarm clock and it came unplugged or something. I mean, regardless, my phone died overnight. Woke up already too late.
Okay, I understand. We had a couple of Delta peers and I guess just a bit of a follow-up on that. You generally consider yourself to be dependable enough that if you move forward in this, you'd be able to make it here when you're supposed to each day?
Yes, very. I'm in the military and it's we're on time.
Okay, that's all I needed to follow up on that. I just wanted to make sure we had some answer there. The other issues we would look at this time is whether or not there was any kind of a hardship or bias issue. And with this particular juror, I didn't see anything of concern as it relates to bias and getting no knowledge of the case nor of hardship. So I don't have any follow-up question on either of those areas. Does the state have any follow-up or dire for the juror on hardship or bias?
We do not, Your Honor. Nothing from the defense.
Okay, so there's one other topic we'll talk to you about individually then, juror number 823. In your questionnaire, you filled out and completed a section on your attitudes regarding the death penalty. And that is in your questionnaire starting on page 12. Do you recall when you filled out your questionnaire thinking through those questions and answering those?
Yes, I do.
Okay, are the responses you made still your feelings about the death penalty now that some time's passed since you filled that out?
Yes, sir.
Okay, I'll advise you that in this case, it might be necessary for you to make that determination in regard to the imposition of the death penalty or some other penalty. And as you're thinking about that, consider that that's not a hypothetical because this is the case before us. So you have to consider that as if any punishment you consider would be absolute and carried out in the case. So as you think about that, I'll go through your questionnaire responses, a few of those. And on the first one I'll address with you, the question is, do you support or oppose the death penalty? And you said you support the death penalty. Is that accurate?
Yes.
Okay. The next question I'll look at was on the following page. You were given a series of choices about what would most accurately represent the way you feel. And you picked choice C, which reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you recall selecting that answer?
Yes,
And does that describe your feelings about the death penalty?
yes,
Okay, I just have one more question for you then. Do you believe, or is it your personal belief that you would always be in favor of the death penalty in every case where a murder's been committed?
in every case, not necessarily, no.
All right. Thank you for your responses to those court's questions. Does the state have any questions on voir dire relating to the death penalty?
We do not, Your Honor.
Does the defense have any questions?
Just a couple questions. Certainly. This.
Mr. Pryor.
Oh, microphone.
Oh, my goodness. You said, in every case, no. Can you give me some insight into, is there a line there where you say, you know, this is an absolute for the death penalty, or this is not an absolute? Is there some sort of black line that you draw, or can you elaborate on that for me a little bit?
Well, it's, every case is different, obviously. Different circumstances, such as, right, it's not specified whether it's, an intentional murder or like an accident or, just all sorts of different things could be. You'd have to weigh in on, I think.
Okay. So if it's an intentional murder and there are children involved, is that an automatic death penalty?
No.
Okay. When you looked at the list and then you had the options from A through F, A, B, and you know what? Murder is death penalty. If you could refer to that, I think it's H. Bottom of page 13. Let me know when you're there.
I'm there.
Okay. So when you read that, was there any hesitation to choose between C and D? If there was and I'll ask you to answer that first.
Not really, no.
Okay. If there was one that said neutral, that I'm going to make up my mind based on each and every one individually and not just rubber stamp yes or no on the death penalty, would that be closer to your beliefs?
Yes.
So if there was a neutral choice where you would say, listen, I've got to hear everything, and then there's just there's no criteria for like a recipe, let's put it that way. That quite frankly, you have to look at the facts, and it's not just because there are kids or not just because it was intentional. You have to look at the whole story to determine whether or not that's where you're going to go. Would that be fair?
I'd say yes, yeah.
Okay. And sir, thank you for your time. Judge, that's it.
All right, thank you, counsel. Juror 823, then that will conclude the individual voir dire for you. You'll go ahead and return to the jury room and we'll have further instructions for you here after we talk to the other jurors.
Thank you.
Thank you. Next juror we'll have brought in, please, 1204. All right, juror 1204, welcome back. Thank you for returning for individual voir dire. At this stage, we're going to have a few questions beginning with questions about bias. We've already talked, I think, probably sufficiently about the fact that this juror also has a vacation partially paid for or paid for. They don't want to miss starting June 15th, but I think we're through that issue. So counsel, there is some indication this juror has previous knowledge of the case, and I'd like to have any questioning counsel requests relating to potential bias from media exposure. So I'll start with the state asking any questions and then allow the defense to report our individually this juror.
Thank you, Your Honor. Good morning, sir. I just wanted to briefly discuss with you the media attention in this case. And you indicated in your questionnaire that you had heard a little bit about this case from basic news. Is that correct?
That's correct.
And that you had heard from the news that Mr. Daybell was involved and that he would be going to trial at some point.
Correct.
During this trial, you're going to be instructed that Mr. Daybell is innocent until the state meets its burden of proof, and that is proof beyond a reasonable doubt. And that means that as Mr. Daybell sits here today, he's innocent. Do you understand that?
I do.
Do you understand that nothing that you've heard on the news is evidence? Now, when you learned on the news that there would be a trial at some point, did that lead you to form any conclusions about his guilt?
No.
Okay. And you indicated on your questionnaire that you had not formed an opinion on this case. Is that still accurate? And you also indicated on your questionnaire that you would be able to put out of your mind what you have read or heard about this case and render an impartial verdict. Is that still accurate? Yes. Thank you very much, sir. I have no additional questions for this jury, Your Honor.
All right, thank you, Ms. Beatty. Mr. Pryor for the defense.
Thank you, Your Honor. Which I have done as far as hardship.
Okay. All right, Mr. Pryor, could I get you to repeat that again with the microphone? We didn't catch it on our audio.
Judge, I have nothing on hardship and bias on this.
All right, thank you, Mr. Pryor. The next section we'll look at then is in your questionnaire, juror number 1204. Do you recall reading through and filling out questions relating to your attitude regarding the death penalty?
Do.
All right, and are the responses you made in the questionnaire still the way you feel about that as you sit here today?
Yeah.
All right, you indicated when given the option of support or oppose, question, do you support or oppose the death penalty? You said support. Is that correct?
That's correct.
In addition, there was a section that gave you some pre-written responses to choose from, and it's which one most accurately represents the way you feel. You circled in the questionnaire what's labeled as 6C, and that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty today?
It is.
Okay. Another question then. You are in favor of the death penalty. Do you believe that the death penalty should be imposed in every case where a murder has been committed?
Answer that. No.
Okay. Is there anything about your views on the death penalty that you think would either substantially impair or prevent you from following the court's instructions about the death penalty, whether that was to consider it or to not consider it in this case? Okay, thank you for your responses. I'll let the state continue with Ordar.
Thank you, Your Honor. Sir, you indicated on your questionnaire that you believe that the death penalty has its time and place and that it is not to be taken lightly. Is that how you feel still, as you said for today? And so you would be able to consider the state's presentation and anything presented by the defense during the death penalty phase and give that fair consideration before you make up your mind whether or not the death penalty is appropriate if the case should proceed to that point. Is that correct? Thank you, sir. I have no additional questions for this jury, Your Honor.
All right, thank you for the defense.
Juror number 1204, could I have you turn to page 13 of your questionnaire? Now, at the bottom of page 13, you circled number C. Right. At the time that you were reading that, would you take a look at number D? Let me know when you're done. Just number D. Okay. Okay, if there was a choice between number C and number D, and I will tell you that when I read that, the difference between C and D is C says I favor, D says I oppose, but both folks would look at the evidence and make a determination on the facts. Do you agree with that? Correct. If there was a choice that said neutral, and that I'm not going to make up my mind until I've had a chance to look at all the facts and not just prejudge it, evaluate the facts and circumstances, not one way or not the other way, and then make a decision. Could that represent your position?
It could. I would say I generally, I might lean more towards neutral, but I do still support the death penalty.
Okay. Certain circumstances. Well, in certain circumstances, and if the judge gives you instructions and say, listen, in the event we get to a sentencing phase, there are options that you have, and the two options are death penalty or life in prison. You will, before you make a decision, you'll look at all the facts and circumstances and remain neutral until you decide which one fits the facts and circumstances. Would that be fair?
Yes.
All right, Judge, I have nothing else. Thank you.
All right, thank you. Juror number 1204, then that will conclude your individual voir dire. We'll have you return to the jury room with the bailiff and you'll receive further instructions once we've talked to other jurors today. Next, talk to juror number 1251, 1251. All right, thank you for returning. Juror number 1251. Court is going to allow for some individual voir dire at this time. We've got a little bit of case knowledge, not much, and there wasn't anything in the way of hardship. If the state would like to inquire as to any potential bias, I'll allow that as well as the defense, and then we'll move on to our next topic after that.
Thank you, Your Honor. Juror 1251, just a reminder, there's no right or wrong answers. I just want you to tell us how you feel. So it sounds like you don't know much about Tammy Daybell. Is that accurate?
Yes.
So you haven't followed this case in the news at all?
No.
There is one thing on your questionnaire. You say you don't have a hardship. You say, I wish I could say yes. Tell me about that. Like, why did you write that on your questionnaire?
I think anytime you're involved in a difficult case like this, that takes a lot of time and emotional energy. And just, for me, I try not to even involve myself in dramas or news or things like that. And as I was thinking about that question, I realized that because of all those things, it probably makes me a good candidate. But I just want to be honest about my exposure and hardships and all of those things. And it's like, you can make things up, but if I don't have anything, then it's like, there's no reason why I shouldn't be serving this duty.
You just used the word energy, and in your questionnaire, you said, I have 0% energy for this process of.
Yeah.
Can you elaborate on that? And maybe you've already kind of answered that in what you just said. We just want to make sure we understand how you're feeling. So when you say you have no energy for this process, what does that mean to you in terms of actually serving on a jury in a case like this?
It's more connected to people who watch news and are into sensationalized things or just not really focusing on their own lives. And so they insert themselves in all sorts of stories and spend a lot of their time, I guess, reading news headlines. And I just don't do that. I don't live my life that way. That's why I don't watch the news. That's why I don't read articles and anymore.
So
I'm in communications. So it's like, I see when, let's say, trying to get my attention or trying to get me to think certain ways. So that's why I just choose to not involve myself in headlines.
And to be fair, yeah, when you said the 0% energy, that was for the media. And so, but going back to this idea that on page 19 of your questionnaire, I wanted to ask if you can put anything you have put out of your mind. You say yes. Whether you say, do I want to be involved? No, I do not. Does that mean you don't want to be on this jury?
I was being prosecuted. I would want an unbiased jury. And as someone who doesn't know anything about this, that's where it's like, I would hope that there would be people stepping up if I was in this situation, just to hear both sides of what was going on.
So even with what you wrote, can you commit to, if you are put on this jury, that you will fully engage in that process of weighing the evidence, listening to witnesses?
Yes.
You did have one other thing that I would need to check in with my work days on the trial schedule. Have you done that? Do you know if this trial schedule, you'd be able to accommodate your work with this trial schedule?
Okay.
Sure. Okay. I have no further questions at this time.
Okay, on that topic then of the potential hardship or bias, Mr. Fryer, you can inquire.
And ma'am, the reason I asked initially, and we made eye contact initially, is there anybody who doesn't want to be here? That's what I took from your questionnaire. And after you explained, I thought your honesty and straightforward answers. If I'm understanding what you're saying, listen, I don't have time for gossip. I don't have time for all of this sensationalized, and I'm going to look at this thing in a fair and balanced, neutral way. Is that fair?
Yes, and I would just say that it's more about if you're wanting to be here in a way that's kind of sick. So it's like, I don't know that any of us really want to be here, but are we here? And are we answering questions honestly? And yes.
And you could find that there are people that just don't, you could understand why I would ask that. Because there are people that are just saying, you know, we run across this all the time. They make comments about and make up things to avoid having jury duty. There are people that do that. And what I'd rather do is just say, you know, folks, just tell me the truth and just tell me you don't want to do it, because if you don't want to do it, there's no sense putting anybody who doesn't want to do it on a jury for it, considering it's going to be 8 or 10 weeks. But I applaud the fact that you say, listen, I don't necessarily want to be involved, but I will do what I'm instructed to do, and I will follow the rules and listen to the court and do all the things that are expected of me. Is that fair?
Yes, I trust that by answering honestly and letting the chips fall, that that's what is supposed to happen. And I can secure my integrity, but I wasn't trying to get out of something just because of my own uncomfortableness.
You weren't trying to skirt your responsibility. You're being forthright about things, right?
Correct.
I want to thank you for that, Judge.
All right, thank you. All right, juror 1251, there's another topic we're going to discuss here individually with you, and that relates to the questionnaire and your responses on your attitudes regarding the death penalty. Do you recall reading through that section of the questionnaire and answering those questions?
I do.
And are the responses you gave in the questionnaire still accurate in terms of the way you feel about it today?
Yes.
Okay, you indicated when given a choice of whether or not you support or oppose the death penalty, you checked the box that said you support it. Is that correct?
Yes.
All right, and I will advise you in this case that it may actually be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when we're discussing this, you need to consider this as not a hypothetical, but that it may be required to be considered in this case, and it may be absolute and carried out in the case. So with that in your mind, you said you support it. Also, in a response when you had choices on this section 6, there were like 7 different choices. You selected choice D and said, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Do you recall answering that?
Yes.
And does that generally represent the way you do feel about the death penalty?
Yes.
Okay, so in the one instance when just a yes or no, you said you support, then later you say you're generally opposed but would follow the facts, law, and instructions. So is there anything you want to clarify there, or are you just kind of in the middle on that issue?
I would just hope that the death penalty is reserved for extreme case.
Okay, so you are not of the view that it should be considered in any murder case. You wouldn't believe that.
Can you repeat that, please?
So the question is, do you believe that the death penalty should be considered or imposed in any case where a murder's been committed?
No.
All right. Is there anything about your views at all on the death penalty that you think could prevent or impair your ability to follow court's instructions if you had to consider that in this case?
No.
Okay, that concludes the court's inquiry. It's what the state like to inquire.
Just briefly. Juror 1251, so as I read your questionnaire and listening to your answers, just to make sure I completely understand where you're coming from. It sounds like you believe there are times when it is necessary, the death penalty.
Yes.
And, but you are willing to, if the court is to give you instructions, if this becomes an option, you will follow those instructions in law to make sure it's applied appropriately.
Yes.
I have another question.
From the defense.
No questions.
All right, thank you, Juror 1251. We'll go ahead and have you return to the jury room with the bailiff and give you some additional instructions once we talk to the other jurors. We'll next talk to juror 1320. You can be seated.
Okay.
Thank you. Okay, juror number 1320 has returned for some individual voir dire. We're doing this with all the jurors, so don't be concerned that you're here alone. There's some question in the review of the questionnaire about some knowledge of the case, as well as you did explain potentially a hardship here. Maybe I'll just address that with you and then allow the state and the defense to question on hardship or bias. On the trial length, where you were told that in the questionnaire, and also it was reiterated here, you said you did check the box, yes, you'd have a hardship. You said, I have a job and a life to live, but I'll serve if selected. So with that, could you explain a little more what impact that may have if in fact you are serving for a 10-week period?
Okay, yeah, I looked into it since then. The work will give me 2 weeks pay for 10 days. And then I'd have to take my time off and I've got a month of that. So the 6 weeks of pay and 4 weeks of no pay, I guess, as I would come out. Which I found. It's not like I'd be living on the street after that, but you know, it would be
Okay.
money.
I appreciate you doing the follow-up, looking into that with your employer also. If in fact this extended out, you said you are willing to serve, very much appreciate that, and you still feel that way, and considering that it could go beyond that 6-week time frame and cause some financial strain.
Yeah, I'm not living from paycheck to paycheck, and so yeah, it wouldn't be fun, but you know,
Okay.
I guess.
Well, thanks for your responses on that. On the bias, I didn't have any specific questions. The state can conduct voir dire on either topic, and then I'll allow the defense.
Morning, sir.
Yes.
So to follow up where the court just left off, I think I followed you that you'll get a couple of weeks pay, you've got some time off, probably paid time off, you can apply about a month.
Right.
That if this goes 10 weeks, you won't get paid.
Yeah, for the last few months.
Do you feel like there's anything about that during that last month, if you were chosen as a juror, that probably wouldn't be uncommon for jurors or lawyers or judges after 8 or 10 weeks to be tired of the case? Do you feel like during that last month where you're not getting paid, did that cause any resentment? Did that cause you to be distracted at all in terms of listening to evidence or resentful that you're still there?
No, not necessarily. My wife has a part-time job, so it's like I said, it's not like we'd be going hungry or living on the street, but maybe my 401k wouldn't get as built up as I want it to be. Maybe I won't buy that new video game or something.
Fair enough. Excuse me. And then just a couple of questions from some comments you made about the press coverage. You made a comment on page 415 of the questionnaire that it asked if you did follow these cases, has that caused you to already form an opinion regarding the guilt or innocence of Tylee Daybell in the case? You said no, but the media reports is not necessarily the truth of facts. You still stand behind that?
Yeah. They're there to sell newspapers or screen time. They're reporting on what we get noticed, not necessarily what is the truth.
So is it fair to say though you have heard some things about the case? You have some,
Yes.
okay. Anything about what you have heard that has caused you to form any specific opinions about the case or about Mr. Daybell?
No, not really. I mean, when it first came out, I read about it, and you know, it was interesting and so forth, but I didn't make an opinion on it because it's, you know, I know it's not the whole truth there.
So as you sit there, you feel like you could hear the facts and deliberate and be objective about everything?
Yes, I do.
Your Honor, on bias and hardship. The state has no further questions.
Thank you, Mr. Woods.
No questions from the defense, Your Honor. Thank you.
All right, juror 1320, then we'll move on to one final topic with you in relation to the part of your questionnaire you completed called attitudes regarding the death penalty. Do you recall reading through that section in the questionnaire and answering it?
Yeah, I did.
Okay, and if you would like to reference it, it's page 12 and 13.
Yeah.
So considering those responses you made last week, are those still true and accurate in the way you feel today?
Yes, I believe so.
Okay. I will advise you in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. So remember, this does apply to the case, and any penalty you're considering should be considered as if it is absolute and will be carried out in the case. So with that in mind, there was a box checked by you on the question, do you support or oppose the death penalty? Check the box saying you support it. Is that the way you feel?
Yeah, I think in some cases, it's warranted by the law. If that's what the law says, then, that's what should be done.
Okay. On the next page, there were some more detailed choices you had there out of 7, and this was the questionnaires words, not your own, but you selected a choice you thought most accurately reflects the way you feel. You checked a box that said, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case.
Kind of contradictory, wasn't I?
And that's fine. If you'd like to explain any more about your thoughts on it, this would be the time. And I don't know that that necessarily is contradictory, but do you have any explanation on that choice?
No, it's just that, I would, no one should have to die, but if the law, if the case says and the law states that that's what's to be done and that's the punishment, then that's what should be done.
So you don't feel then, as I gather, that the death penalty should be in place or considered in every case where a murder's been committed?
Not unless it's asked for by the prosecution or the facts being that it's advisable by the law or whatever.
Okay, so one final question then, is there anything about your personal views or thoughts or feelings on the death penalty that you think would prevent or impair you from following the court's instructions on that if you serve as a juror in this case?
No, I don't believe there is.
Okay, thank you for your responses. Let's have the state, if there's any follow-up or dire on that topic.
Thank you. We do, Judge. Sir, probably just a couple of questions. So on page 12 of the questionnaire, on the bottom, you had answered in a question, do you feel the death penalty is used too often? You X that box. Then you explained so much more costly to pursue than life in prison without parole. Surely not an uncommon opinion. As you consider that there, well, first of all, is that an accurate expression of how you feel about it?
Well, as far as do you feel the death penalty is used too often, too seldom? I don't know. Maybe I don't know is the right answer. I don't know. Seems like there's not a good choice there at all. Yeah, I've heard that it's more costly to pursue a death penalty.
Fair enough. And there's no wrong answers here. Where you're coming from.
Yeah.
So I guess my question is, if the case does proceed, if there's a conviction and then we get into a death penalty question, the judge will give you certain instructions as to how to evaluate the death penalty, whether it should apply. Will the fact that you think and believe that it's more expensive to society to use the death penalty than just life in prison, will that be anything that would dissuade you from otherwise following the instructions that the judge gives in terms of how you apply the facts and law. Will that still be a factor in the back of your mind?
No, because all the people, the prosecution, the judge and everyone has weighed out those facts and those, you know, the cost of it and so forth. And if they believe that it's viable, then, you know, and I'm given those instructions to figure that out, then do what the judge would ask.
Okay, so it's fair to say that you won't let that cost factor be part of your decision, is that fair?
Yeah, yes, that's fair.
No, I don't have any more questions.
All right, any questions for Vordire on that issue?
Just to follow up, my concern.
Yes.
You made a comment that if the prosecution asks for the death penalty, I take things sometimes literally. And in that situation, I was wondering, does that mean that if the prosecutor, and I don't want to imply under any circumstances that Chad is going to get convicted, but if that happened and the prosecutor asks for the death penalty, does that mean you're absolutely going to follow the prosecutor's recommendation and impose the death penalty?
No, I would follow the judge's advice and take the prosecution's arguments into fact and your arguments into fact.
So if the court were to instruct you that upon a conviction, you have a choice between the death penalty and life in prison, you would equally balance those considerations based on the facts and circumstances surrounding the case. Would that be fair?
If that was what the judge dictated and those are the choices, yes, I would balance those out fairly.
Okay. And at this point, based on what I understand, is that despite those choices, it's still your, and I don't want to use the word preference, you oppose the death penalty, but you're going to be fair. And you're going to look at both of the options before you make a decision based on your understanding of the facts, based on what the prosecutor tells you, based on what the defense tells you, and based on what this judge instructs you on the rules to follow. Would that be fair?
I'd like to think that's where I stand, yes.
Okay, is there any reason to suggest that you wouldn't stand anywhere else? Not that I know. Thank you for your time, sir. I greatly appreciate your time.
All right, that'll conclude the Vordire individually of juror 1320. We'll have you return to the jury room with the bailiff, waiting for their instructions as we talk to our remaining jurors. Our next juror will discuss individual Vordire with is 1358. All right, thank you for returning. Got a couple of follow-up questions for you here. All right, this court doesn't have at this point any individual questions for this juror in relation to bias or hardship. So I'll allow the state to make any inquiries on those topics, if any, and then the defense, and then we'll move on to the other topic.
And Your Honor, we don't have any questions for this gentleman about those topics either. Thank you.
On either hardship or bias questions, anything from the defense?
The only thing that caused me some hesitation is I'm pretty familiar with accountant's responsibilities. And the likelihood is that if you're picked, we're going to be 4/15 is a very important date for you.
So
I work for a private company. I'm the controller. The 15th deadline is for corporate, and again, we have some entities within that need to be filed. We made a lot of progress in the last week with, I won't use the word anticipation, but knowing that this was a possibility. So I think we're in decent shape. If I am selected, nights and weekends through the 15th, I'm good on that front. So I don't believe that that's a hardship. Unless there's sequestered between now and then it could be. What if you're sequestered in late May or June? Is that going to create any problems for you? Not at all. Okay, that's all I had, Jeff. I just want to make sure. Thank you, sir. You're welcome.
All right, the next issue we'll discuss then with this juror is in relation to your questionnaire responses on attitudes regarding the death penalty. Do you recall going through those questions and answering them last week in the questionnaire?
I do.
Okay, having thought about the questions and responses since then, are those still accurate, or is there anything you change about your opinions stated in that questionnaire?
Those are still accurate.
All right, you had an option of either support or oppose were the only choices, and the question was, do you support or oppose the death penalty? You said support. Is that accurate?
That is accurate.
Okay, you also, when given a range of choices, said what most accurately represents the way you feel. You selected a choice that reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the same way you feel about this?
Yeah.
All right, I will advise you that in this case, it may be necessary for you to actually consider this and make a determination in regard to the imposition of the death penalty or some other penalty. And you have to be considering this not hypothetically, but as if it would be absolute and carried out in the case. So thinking through that, does that change at all your opinion on those choices?
No.
Okay, one final question I'll have then is, do you believe that the death penalty should be imposed in every case where a murder has been committed?
I do not.
All right, that concludes the court's questions on that topic. I'll allow any voir dire from the state and then the defense.
And Your Honor, I don't have any additional questions for this juror on that topic either. Thank you.
All right, from the defense.
No questions.
All right, juror 1358. You might have set the record for the quickest individual voir dire today at least. So thank you for your quick and concise answers. We'll have you return to the jury room for further instructions and talk to the remaining jurors.
Appreciate it.
Juror number 1365 will be next. All right, thank you for returning, juror number 1365. The court's going to permit voir dire from the state and the defense on issues first, talking about any potential bias or hardship. I'll note this juror has indicated some knowledge and detail of potential facts relating to this case or the case itself. So with that in mind, who's going to be conducting voir dire?
I am, Your Honor.
All right, Mr. Wood, if you'd like to inquire, you may.
Thank you. Sure, 1365. Looking at your questionnaire, it looks like you do have some familiarity with the facts of this case. Is that fair to say?
I had heard over the years that when the children were found, it was on the news. And then I believe when Lori was convicted. That's when I heard those on.
Okay. And did you seek out the news on this particular case or?
No, it's just a matter of the news was on and I heard that.
Okay. So you mentioned that you did know that Lori Vallow was convicted. The judge gave an instruction earlier today. In this case, you will hear about Lori Vallow. She was part of this case. But the fact that she was convicted, the judge gave an instruction that you were not to consider that. Will you be able to put that out of your mind and not hold her conviction against this defendant?
Yes,
Because they're two separate people. And so you can commit to that 100%.
yes.
And similarly, just the other facts you've heard about this case. Can you commit to only making a decision based on what you hear in this courtroom?
Yes.
Your Honor, I don't have any further questions.
All right, thank you, Mr. Wood. Mr. Pryor.
Thank you, Ron. It sounds like all you've heard are a few stories that were on the news. That's about all the exposure you have, right?
Yes,
And you haven't made a decision one way or the other, even knowing that there may have been some issues with the Lori Vallow, correct?
that's correct. I kind of do believe that sometimes the news doesn't necessarily report all the truth either,
And
sensation.
one of the news, as I understanding, one of the news agencies.
Mr. Pryor, could you talk in your
I
microphone?
thought I was, Judge, I'm sorry. One of the news agencies was it East Idaho News you were looking
It would have been whatever was here,
at? Okay.
because it's the local.
Okay. All right. When you look at page 13 of your questionnaire. There are A through F as the choices, right?
At the bottom,
I think at the bottom, yes.
yes.
And you marked number C.
Mhm.
What I'm, and I don't want to put words in your mouth. But what it sounds like is you're saying that I have not made a decision yet, one way or the other. Is that fair?
It's fair.
That I'm going to look at all the facts and circumstances. Is that fair?
Yes.
I'm not going to take into consideration some of these media outlets that may or may not sensationalize things and give us an accurate picture. Is that fair?
Right.
Okay. And that in weighing all of the facts, I'm not committed one way or the other towards the death penalty. Is that fair? And if the judge gives you an instruction that says, yes, I will, you have two choices if there's a conviction for murder. Before I start, I want to make sure you understand Mr. Daybell's here today, and I don't want to imply that he's guilty of this in any way, but we have to talk about this so we get an idea where you stand. You do kind of understand that, don't you?
Yes.
Okay, so if I understand correctly, that if you look at item number C, and then you go down to item number D, and
Mr. Pryor, we're going to get into the death penalty qualifications here momentarily.
but in any event, you're going to base your decision just on the facts as you see them if you were chosen at the time of the trial. Is that fair?
That's fair. And the reductions.
Oh, thank you very much. Nothing else.
All right, thank you. All right, the next topic then the court will go through with you is on your responses to the attitudes regarding the death penalty section of that questionnaire. Do you recall answering that?
Yes.
Okay, and having thought about that, since you did your questionnaire last week, do you still feel like these are accurate representations of your attitudes on that?
Yes.
All right, I will advise you here in this case that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty in this case. And remember, any penalty you're considering should be considered as if it is absolute and would be carried out in this case. You understand that?
Yes.
All right, you had a selection here as one of your answers. Do you support or oppose the death penalty is the question. You said support. Do you recall that?
Yes.
And is that still your thought as you sit here today about that?
Yes.
All right, one other choice you made out of 7 choices in some more detail provided about what most accurately represents the way you feel. You selected choice C that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Does that still accurately describe your general thoughts on the death penalty?
Yes.
Okay, finally then, with your position on the death penalty, is it your opinion that the death penalty should be imposed in every case where a murder has been committed?
Absolutely not.
Okay, is there anything then about your views on the death penalty that you think could in some way prevent or substantially impair you from performing your duties in this case if you received instructions about the death penalty? All right, that concludes the court's order on that issue. Mr. Wood,
The state has no questions, Your Honor. Thank you.
Mr. Pryor, any board ire?
Yes, I jumped the gun. I apologize for that, Judge.
That's
I think it's just habit. So we're going to go back to item number 13, A through F, I believe. And I don't want to put words in your mouth, and I don't want to suggest an answer to you, so just. But what I think I'm hearing is that if the judge instructs you that the death penalty is a possible sentence and life in prison is a possible sentence, at this point, you're going to go into this process if you're a juror and you're not going to make or be favored one way or the other at that point, and you're going to look at both options. Is that fair?
Fair.
And then only after you've reviewed all the evidence and listened to what the state has said, listen to what the defense has said, and then listen to how the judge instructs us. At that point, you'll make a decision based on both of those options. Is that fair? Okay, so if there was an option between C and D on number 13 that said, I'm neutral and I'm going to look at all the facts, all the circumstances before I make a decision in this case, would that be closer to your position?
I think that would be more accurate.
Okay. And thank you for your honesty. I really appreciate allowing me to spend some time with you. Thank you. Judge, I have nothing else. Thank you.
Very well. That'll conclude individual voir dire for this juror. Thank you for answering those questions. We'll have you return with the bailiff to the jury room and talk to our remaining jurors. Next up will be juror 1378. All right, thank you for returning juror 1378 for individual voir dire. This time, I'll inquire as to whether the state has any voir dire in relation to hardship or bias issues. I don't think there was much at all in the way of bias here on any exposure, but potentially hardship. We got into that before. Once the state's concluded voir dire, I'll let the defense as well have questions for the juror. Who's going to be conducting voir dire for the state?
I will, Your Honor.
All right, go ahead, Mr. Roots.
Thank you. Great, sir. I really just have one question for you. On your questionnaire on page 20, you just made a notation under the hardship section. I'm only worried about my job because I started on January 2nd, 2024. Is that right?
Yes,
This is a pretty new job.
yeah, and they are willing to work with me. I talked to HR about it.
So whatever worry you had when you.
Yeah, I no longer have that worry.
So whatever worry you had, no longer have that worry.
No, I do not.
So then, is it safe to say that as far as you're concerned, if selected, you don't believe that being a juror would be a financial hardship or impairment to your job? Is that fair?
Yes, that is fair.
Your Honor, no other questions on this?
All right, thank you. Mr. Pryor?
There are no questions, Judge.
Okay, we'll next move on then. So juror 1378, when you filled out your questionnaire last week, there was a section in there called attitudes regarding the death penalty. Do you recall that section of the questionnaire?
You can remind me, but I do not, I mean, I remember answering, but I don't remember what I answered.
Okay, if you'd like to just refer to it, I think we provided you a copy. You could turn to page 12 is where that begins. So when you answered your questionnaire, right, kind of in the middle of page 12, there's a question that says, do you support or oppose the death penalty? And you check the box saying support. Is that accurate?
Yes, Your Honor.
Okay, and that's the way you would feel about that today as well?
Yes.
All right, and as we go through these questions, I'd like you to consider that in this case, it may be necessary for you to make a determination about the imposition of the death penalty or some other penalty. And when we're discussing this here, remember, you need to consider that as if it would be done and be absolute and carried out in the case, if that's what the jury determined. You understand that?
Yes.
Okay. On your questionnaire, you also on page 13, you'll turn there about 2/3 down. There were choices you had about what most accurately represents the way you would feel about it. You selected a choice C, which reads, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Do you recall looking at all those options and checking that one?
Yes, I do.
Okay, does that still then represent the way you think about and feel about the death penalty here today?
Yes.
Okay, final question I have then. Do you believe that the death penalty should be considered or imposed in every case where a murder has been committed?
I do not know.
Okay, so if there were instructions to either consider or not consider it, would you be willing to follow those instructions regardless?
Yes.
Okay, then is there anything about your views on that issue of the death penalty that you think prevent or impair you from performing your duties and following the instructions here in this case?
No.
Okay, thank you for your responses there. That concludes the court's voir dire. I'll allow the state to conduct voir dire and then the defense.
Thank you. Sir, for my question, it's based off a response you gave on page 12 of the questionnaire. And you were asked in question section A, how do you feel about the death penalty? And you responded, if guilty and required, I agree, but 100% without a shadow of a doubt, guilty verdict has to be the cap. Am I reading that correctly?
The case.
Yes, sorry. Could you explain what you meant when you wrote that?
When you come to a guilty verdict, you can't be 99% sure, and you have to be 100% sure without any doubt. And that's what I meant by that.
So is it safe to say that in your mind, you just are, would only be inclined to impose the death penalty if in fact in your mind there had been 100% proof that whomever Mr. Daybell had is guilty, is that correct?
If he was guilty, yes, and I did not know without facts.
So, sir, then my question would be, if the judge gives an instruction and explains that the standard to determine guilt in this case would be that the state would have to prove beyond any reasonable doubt. Is that an instruction, one, that you feel like you understand or would understand? And number two, would you be willing to follow that instruction?
Yes and yes.
So then you wouldn't necessarily hold the state to prove 100% without a doubt that he was guilty.
Yes. But he doesn't have to be like, he has to be guilty to the law. To what the law states.
So you'll follow the judge's instructions on what
Yes.
the law is.
Yeah.
Okay. You know, I don't have any further questions.
All right, thank you. Mr. Pryor.
Sir, if I could get you to turn to page 13 of your questionnaire, if you could, let me know when you're ready.
All right.
Okay, on page 13, you marked item number C. Is that correct?
Yes.
And what I'm hearing from you is saying, listen, I am going to listen to the judge's instructions and take those and apply those to this case, right?
Yes.
I'm not going to make a decision right now or not until I hear 100% of the evidence that's presented, correct?
Yes.
That you have not made a decision one way or the other, correct?
Yes.
That you haven't made a decision whether, and you don't favor the death penalty or not the death penalty at the present time, correct?
Yes.
But that decision won't be made until you've had a chance to look at 100% of the evidence, correct?
Yes.
And only if you feel that Mr. Daybell did something and all of the other jurors agree with you that there's a conviction, at that point, you will balance whether or not to impose the death penalty or not. Is that fair?
Yes.
And you won't prejudge or favor one position or the other before that time.
No, I will not.
So if there was a choice between item number C on page 13 and item number D that included a box that would say, I am neutral on this issue, and I will only make a decision until I have heard 100% of the evidence, and I am convinced that Mr. Daybell may be guilty. Would that be closer to your position?
That would be 100% my position.
All right, and thank you, sir. I appreciate your time. Thank you.
Okay, juror number 1378, that concludes the individual order.
Your Honor, I'm sorry to interrupt you.
Yes.
I know this is unusual to your course, but there is another issue on this questionnaire that I'm wondering if we ought to, that I had overlooked initially, and it might.
Judge, could we approach on this first?
Let's approach. All right, thanks, counsel. Juror 1378, you can go ahead and return to the jury room with the bailiff, and we'll question the additional jurors, then give you some more instructions after that. Thank you for returning. We're going to next talk to juror number 1379. All right, juror number 1379, thank you for returning. Court's reviewed your questionnaire and we've determined individual voir dire is appropriate on certain topics, including that of potential bias. There's some information the juror has from media surrounding the case and knowledge of the case. And I don't think we had any hardship issues. So if the state would like to inquire to discuss whether or not there is any knowledge of the case, and in this setting, of course, juror 1379, you can discuss whatever facts or knowledge you have in answering, since the other jurors aren't here. So who will be conducting voir dire for the state?
That would be me, Your Honor. Thank you.
All right, Ms. Beatty, you may proceed.
Good afternoon.
Hi.
Hi. So I wanted to chat with you a little bit about media exposure in this case. And you had indicated that you saw some documentaries and news about the case.
Yeah.
And I think you had indicated on a question about your knowledge of the victims, that you would just, your awareness was just what you'd seen on the news.
Yeah, exactly.
Sure.
Yeah.
Great. Can you kind of describe what knowledge you do have about the victims in this case, specifically what you have heard?
Like I said, nothing more than what's been on the news. Just I usually have the news on in the background, so just kind of snippets of the case here and there. But not much more than kind of headlines and news stories.
Okay, great. Would you be able to put aside what you've heard on the news and render an impartial verdict?
Absolutely.
And you'll be instructed during this trial that Mr. Daybell is innocent until the state proves him guilty beyond reasonable doubt. Are you comfortable with that?
Yes, I'm comfortable with that. Yeah. Sorry.
You would be able to follow that instruction.
Yes, I would be. Sorry.
And then you also understand that nothing that you've heard on the news is evidence.
Yes.
And that the evidence is what will be introduced at trial.
Yes.
Thank you very much. I have no additional questions for this jury, Your Honor. Thank you.
All right, as to potential bias, Mr. Pryor, you can inquire.
And I appreciate you being forthright about the articles, the news, and all of that stuff. And based on what you've seen on the news articles, and everything else, you haven't made a decision one way or the other.
No, I know that the news is just a very brief skim of, what's known. I understand that
And
that's not.
And something that you put in your questionnaire really drew my attention.
Okay.
Let's go to page 19.
Okay.
Down at the bottom, you have a sentence that starts with "I believe."
Yes.
Would you read that to me?
I just said that I believe strongly in the due process of law.
And in the due process of law, that means that you listen to all the evidence, right?
Yes, exactly.
And that you don't take into consideration or anything regarding the stuff that some of these media outlets or these podcast people who are making a living on something unfortunate.
Mm-hmm.
And we don't take any of that stuff into consideration. We just base it on what you hear in terms of what's been presented. And you'll be able to do that, right?
Yes. I will.
Okay, thank you, Judge. Nothing further.
All right, thank you, Mr. Pryor. There's another topic we'll discuss next then. So juror 1379, in filling out the questionnaire, there was a section in there called attitudes regarding the death penalty. And that was a section beginning on page 12. Do you recall thinking about the questions thoroughly and answering those last week?
Yes, I do. Yeah.
And are the responses you provided still the way you feel about that today?
Yes.
All right, in going through these questions about it then, I would like to advise you that it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty in this case. And remember, when you're considering that, you need to consider that as if it would be done in absolute and carried out in the case. So as you consider that, I'll note that when given a choice, you selected that you support the death penalty when asked if you support or oppose it. Is that correct?
Yeah, that is correct.
Okay. You've also selected a choice when you had a variety of choices about what accurately represents the way you feel. You picked the choice that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you feel about the death penalty?
Yeah, I'd say that's accurate. I'd actually, I kind of struggled between C and D. I remember, it felt like I had to have an absolute, but either way, if it is instructive, then I believe in following the instructions that the court provides, so.
Okay, and so you had considered maybe leaning towards generally opposed, but following the instructions and putting aside your feelings?
Yeah, I kind of wanted a neutral in there. Like I'm neutral, but I would follow it. I believe that it's necessary in certain cases and I will follow the court's instructions when it comes to part of it.
Okay, so given the way you feel about it, then do you believe that the death penalty should be imposed or considered in every case where a murder's been committed?
I don't think it's appropriate in every case necessarily, but I think based on the circumstances and when you're talking about especially egregious cases, that is probably an appropriate option.
Okay. Final question from me then. Will any of your views on the death penalty you believe either prevent or substantially impair you from serving as a juror in this case and following whatever instructions the court gives you on the death penalty, whether it's to consider it or not?
No, I don't think that I'd have any problem with that.
Okay, that concludes the court's voir dire for this juror. Any voir dire from the state?
I have no additional questions for this juror, Your Honor. Thank you.
Mr. Pryor.
And just briefly,
Yeah.
I appreciate you bringing that up between C and D. I've spoken about that before. And what I gleaned from your questionnaire, especially the comment on page 19 where you said, listen, I'm a strong believer in the due process of law. I saw some of your hobbies with the Ducks Unlimited and some of the other stuff. I think that you probably have a very patriotic sense to you. Would that be fair?
Yeah, and I think the first day that we were here, Judge Boyce likened this to serving in the military. If you hadn't served in the military, this might be the most patriotic thing you can do. And that really struck me because my husband did serve in the military. So I'd say we are very patriotic and yeah.
And it is all of our civic responsibility. And I appreciate the fact that you struggled with the choice between C and D. So I'm going to ask you again, just to reiterate, you haven't made up a decision at this point.
No, I don't.
You haven't, and as far as guilt or innocence, you understand that we have to ask you about these questions, even if we believe that belief from the defense is that Mr. Daybell is not guilty. We have to talk about this because it's important. It's a potential issue. The judge is going to give you a choice of the death penalty or not to impose the death penalty. And at this point, you're neutral on either of those.
Right, yeah, I don't have a preconceived notion about what the end is going to look like.
And at this point, before you make that decision and make that important decision, you're going to balance what the prosecutor tells you.
Yes.
What the defense attorney in my office and what I'm going to present to you. And then you're going to follow this judge's instructions. And you're going to remain neutral until you've had a chance to make your own decision, and you're not going to follow a recipe. You're going to do it based on your view of the facts and circumstances, correct?
That is correct, yes.
Thank you, Judge. I have nothing else.
All right, thank you for returning for the individual questioning. 1379 will have you return to the jury room and we'll talk to our remaining jurors and then give you further instructions. We'll next talk to juror 1389. All right, juror 1389, thank you for returning. We've got some additional questions for you here on board Dyer. One of the things we're looking at and can discuss here openly, since other jurors are not around, is whether or not your prior knowledge of this case might serve to cause you to form some sort of an opinion. I would note that in looking through your questionnaire, you seem to know quite a bit about the case. Is that accurate?
Only what's been presented in the media up until I was called for jury duty.
Okay, and let me just try to clarify that. Did you just sort of watch in passing what was reported, or have you actively gone out to, for example, watch any documentaries or look this case up on any commentators on YouTube or anything like that?
Well, only passively, basically anything that was a media push on various news aggregated websites, or my wife had the television going, for example, Channel 7, they've covered it extensively. Now it's kind of hard to miss when they have that as, their headline news for the night.
Okay, and sure, and again, there's absolutely nothing wrong with knowing about it, knowing as much as you know. That's what we need to determine. A lot of people do follow the news and get interested in stories. That's why they are in the news, is because they're interesting sometimes. The one response you had in your questionnaire was whether or not you formed an opinion regarding the defendant's guilt or innocence, and you said possibly, but only because some of the victims were young children. So on that issue of whether or not you've possibly formed an opinion, and we'd like you to be as honest as you possibly can here, with this defendant here in this trial, can you tell us if you do believe you have formed some opinion about his guilt?
Well, given what was on the news, I think it'd be extremely difficult not to have already formed some sort of an opinion. It just makes it more impactful that small children were victims in this case. And it, kind of hits you, it really hits you kind of hard. Something happened to those children. Who or what did it, I don't know. Just whatever's been reported.
Okay, and to follow up on that, not what may think or someone else, as you sit here, what is your opinion at this time?
At this time, I honestly don't know. I have to go in maintaining that. I don't know. The impact is significant, yes. But if I were to, if somebody were to ask me to make a judgment right now, this moment, I have to say I can't.
All right, but it's fair to say you're not completely without some opinion here. It does, and again, we can openly discuss this here. So if you are leaning one way or another, which way are you leaning right now?
Right now, just based on the news coverage, I have to say I'm leaning towards guilt.
Okay, and I do appreciate your responses. This is what we need to discuss. I'll let the state follow up with any additional voir dire if you'd like, and then the defense.
Your Honor. Sorry.
Thank you, Your Honor. Juror 1389, on your questionnaire, and again, there's no right or wrong answers here. And so please feel free to just tell us exactly what you're thinking. On page 19 of your questionnaire, your question 10D, it asks if any of your exposure to the media has caused you to form an opinion about Mr. Daybell's guilt or innocence. And you said possibly, which is pretty similar to what you guys said. And the question I want to look at is that 10E. Would you be able to put out of your mind what you have read or heard about this case and render an impartial verdict based solely upon the evidence in this courtroom? And you did mark yes, and you said possibly. So what do you mean by possibly?
Well, basically, I'll defer back to what's already been covered in the media. It predisposes you to lean toward, either this defendant is either guilty or not guilty. That's just how it's been presented in the media. If it were to come to trial, and I'm sitting here, I would have to set that aside and, bring your A game, bring everything you've got to show me that, yeah, whatever you heard in the media is either wrong or it's correct.
So, well, and that brings up an interesting point. When you say, show me what the media has said is wrong or correct, do you think that at some level, as you're sitting here listening to either evidence from the state or from this defendant, that you're going to be referring back to what you heard in the media?
It will be at the back of my mind, but again, there's going to be one side saying one thing, the other side saying something to either counter or present another facet. Those are the two most important sides to look at right now. It's only if there's some sort of nebulous gray area, and I don't think there will be. But let's say there were, at that point, then I would go back and look at, hey, this is what I heard. This is what I saw. This is what I was told.
Okay. And thank you so much for your honesty. We really appreciate it. Your Honor, based on Juror 1389's responses, I would move to excuse this jury for cause.
Okay, so you're moving to strike for cause based on bias. Thank you, Ms. Wood. Mr. Pryor, do you wish to conduct any further or dire or simply advise the court whether or not there's a stipulation on the motion?
Well, Judge, sir, there is no right or wrong answer. Judge, I concur in that opinion, but to avoid the court wanting its own analysis, the court's going to accept the stipulation. Otherwise, I can go through some analysis and further voir dire to support that. My belief, there should be, maybe some consideration of the cause.
All right, and I'm inclined to agree with the strike. So based on that, so Juror 1389, first, thank you so much for coming back today and taking the time to fill out your questionnaire. We appreciate your honesty today. We're trying to get the best, most impartial jury we can through this process. And with your knowledge of the case, I would find that perhaps the burden's been shifted improperly towards a presumption of guilt instead of innocence. And despite best efforts, I'd be concerned that Juror 1389 may have that preconceived notion. So we are going to excuse you as a juror. And again, thank you so much for your service coming in today.
Thank you, Your Honor.
You're welcome. All right, next up will be Juror 1392. While they're on their way in, counsel, maybe I'll just inquire. I don't see any type of bias or hardship presented at all in the questionnaire. Either side have any questions you think you'll have on that?
Judge, I just have one. And it was towards the end where he talked about the fact that because of his employment, not a lot of media coverage. Not what there was a concern there. I couldn't hear it. In terms of blocking the media coverage.
Okay, I'll allow that. Is the state going to have any individual voir dire?
Just one question on part 4.1a response was made.
Okay. Juror 1392, thank you for returning for your individual voir dire. This time I'll allow the state and the defense to conduct an individual voir dire on the issues of hardship or bias.
Yeah, Your Honor.
Yes.
Sir, I just have one question for you. On your questionnaire, on page 7, under part 4, paragraph 1A, there was a question, do you feel that a defendant should be required to testify? You marked X as in yes. What did you mean by that?
I might have misread it. I don't say they have to testify. I think it's just read it wrong or misinterpreted.
Fair enough. So would it be safe to say that if the judge instructs you that if the defendant chooses not to testify throughout this trial, that you shouldn't hold that against him, you're willing to follow that instruction?
Yes.
Thank you. I have no other questions, Your Honor.
All right, thank you for the defense.
I may have been mistaken, sir, but I thought in your questionnaire, there was some reference that you would not be able to block out the media because of your job position. Is there an issue with that? I don't
watch any media or do social media.
Maybe I made a mistake. Judge, if I could just have a moment.
Go ahead.
Nothing further, Judge.
All right, thank you, counsel. So juror 1392, there is one additional topic we're going to cover with you. In filling out your questionnaire, you went through one section that was called attitudes regarding the death penalty, and that was on page 12 and 13. Do you recall thinking through those questions carefully and answering them in the questionnaire?
I remember answering the best of my ability that day.
Okay. Let me advise you that in this case, it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And remember, when you're considering that, you need to think about it as if it would be done or absolute and carried out in the case. So with that in your mind, you selected a choice. First of all, when you were asked, do you support or oppose the death penalty? You said support. Is that still the way you feel as you sit here?
In the right circumstance, if somebody is proven guilty without a shadow of a doubt, then I don't have a problem with the death penalty at all.
All right. You also selected one choice out of 7 you had about what best represents the way you feel, and you said, and this is a quote written in the questionnaire, that I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. So given those choices you had there, is that still the way you feel about that?
Yes, basically I'm just saying I don't have a problem with the death penalty as long as the defendant is found guilty on reasonable doubt.
Okay, and is it correct for me to say then, well, I'll ask you just a question. Do you believe then that given your support of the death penalty in certain circumstances, do you think it should be considered or applied in every case where a murder has been committed?
No, not every case.
All right. So finally, I'll just ask you, is there anything about your views on the death penalty that you think would, for some reason, prevent you from serving or substantially impair your ability to be a juror on this case if you were required to follow instructions about the death penalty?
No.
Okay, that concludes the court's questioning on that topic. I'll allow the state any additional voir dire and then the defense.
Just one question again, sir. Not to mince words, but you had mentioned you would consider the death penalty if the state proves beyond the shadow of doubt. I'll just ask, would you agree to follow whatever instruction the judge ultimately gives you about the proof standard providing proof beyond a reasonable doubt. Will you follow his instruction when you get that? Okay. All right, thank you. You don't have no more questions?
All right, right.
And sir, we have to talk about these issues because they're very important issues. And I don't want you to assume that because I'm talking to you about this, that I believe that Chad's guilty or that we're not here for some purpose. But if I understand you correctly, that in the event there were to be a conviction to the charges, it's not an automatic in your mind that the death penalty would be imposed. Is that correct?
Not necessarily, I guess. It'd have to be without a shadow of a doubt that he was guilty, and if the death penalty was handed down, I have no problem with that.
Okay. So when you say without a shadow of a doubt, we're talking about two different things. You understand that the judge will give you instructions that in order to convict him, the evidence has to prove that he's guilty beyond a reasonable doubt. You understand that, right? And then we would go to a sentencing phase. And I guess what I'm hearing from you is that at the time of sentencing, although he may have been convicted of a beyond a reasonable doubt, it's going to need to be no doubt in my mind whatsoever before I agree to subject someone to the death penalty. Is that fair? Okay, so could I have you turn to number 13? And your choice is C. Is that correct? At the bottom? Right. And in reading C, what I'm hearing is that, I don't have any problem with the death penalty as a penalty if it's supported by the facts and circumstances. Is that really what you're saying?
That's how I understood it.
But if you look down to D, the only difference is you're saying, listen, I generally oppose it, but if it's supported by the facts and circumstances, I'll reserve judgment. Is that the way you would read D?
Yes.
Okay. So if there were one between the two of them that said, I'm neutral on whether or not to give the death penalty, but what I'm going to do is I'm going to listen to the prosecutor's evidence, I'm going to listen to the defense's evidence, and I'm going to follow the judge's instructions, and I'm going to remain neutral right up until the point that I make my decision. Would that be closer to what your opinion is?
100%.
All right, Judge, I have nothing else. Thank you.
All right, juror 1392, then that concludes your individual voir dire. We'll have you return to the jury room with the bailiff. We've got one more juror to talk to individually, then you'll return for further instructions. All right, our last juror we'll talk to at this point is 1424. All right, juror number 1424, you're returning for individual voir dire. We had some additional questions for you that you may talk about in as much detail as you want or as requested by counsel of the court about your prior knowledge of this case. The court does need to conduct an individual voir dire in relation to potential bias. I don't think there was any hardship issue. So you do have some knowledge or information about the case from prior reporting on it. Is that correct?
Yeah, just general knowledge. So I haven't really followed it closely for 4 years. I had court TV at one point, and so I'd seen some of that reporting.
Okay. Okay, apologies. Is there, well, let me just read one of your responses. You said the media portrayed him as guilty. The media has been wrong before. A concern we have, including me and the parties, would be whether or not he may have already formed some type of opinion about the defendant and his guilt or innocence with what you know in the case.
I have.
All right, let me allow the state some additional voir dire, and then I'll allow the defense as well.
Thank you, Your Honor. Sir, you indicated that you had watched some proceedings of, in this case on court TV, is that correct?
Yes.
Okay. And you indicated that you hadn't really followed this case for the last couple of years.
Correct.
But during the time you were watching news on this case, it sounds like you did get some knowledge of the case. Is that fair to say?
Yeah, it was, I think they were speculating still.
Okay. You described learning of a religious aspect to the case.
Yes.
And when you were asked what you knew about the defendant, Chad Daybell, part of your answer was that you had learned about a quote trail of death. Is that correct?
Yeah.
Okay. You described one of the victims in this case, JJ Vallow. You were aware that he had special needs.
Mm-hmm.
And thank you. And you described him as sweet-natured. Is that correct?
Yeah, I think it was his grandfather who might have said that.
Sure. So based on that experience, watching court TV, watching the news, learning about a trail of death and some humanizing facts about these victims, do you think that that contributed to your sense that you would lean toward guilty that you put in your questionnaire?
I think if I didn't know anything further, that's the way I would lean.
Okay. So when you filled out your questionnaire on page 19, there were a couple different places where you wrote that you were leaning guilty just at this point. That's fair to say. Okay. And as you sit here today, are those answers still accurate?
Yes.
Okay. Your Honor, I would move to excuse this juror for cause. Thank you, sir.
Mr. Pryor.
And so there's no right or wrong answer, okay? But obviously we have to evaluate. Judge, I'm going to stipulate the two answers.
Okay, the court's considered the responses here. I'll also agree there's a concern the burden may have shifted here where the juror's statement, if we didn't know anything further, that's what he would think, which may require more than his due process afforded to Mr. Daybell in this case. So juror 1424, thank you very much for your service and for taking the time to fill out your questionnaire. Due to some prior knowledge of the case, we'll continue to look for completely impartial jurors, and you will be excused with the sincere thanks of the court. All right, if we could have the remaining jurors who were asked for cause brought back in, then we'll conclude with this group.
All right, wait.
Counsel, here you are.
Thank you. Please be seated. All right, ladies and gentlemen of the jury who have returned here, we're dealing with a lot of numbers of jurors in this case, so I'm trying to give everyone a chance to make sure we're all tracking the same. If you don't mind, the first thing I could have you do is just please hold up your red card again and do that for a moment, and we'll all confirm who's remaining. Okay, thank you. You can put those down. Having considered this remaining group, then, does the state pass this small group for cause?
Yes, Your Honor.
Does the defense pass this small group for cause?
Yes, Your Honor, thank you.
Thank you. Ladies and gentlemen of the jury, you've now been passed for cause. We are continuing to question additional groups of jurors until we reach the necessary number to have the attorneys exercise their peremptory challenges. At this time, then, you are going to be released for the day. You'll be instructed to contact the jury commissioner on the way out, Randy Rutland, who will give you further instructions on when you're going to return. While you are waiting, and some days may pass, please follow the court's previous instruction to not do anything to look up this case, research the case, find out about the case. If you see the case reported in the news, etc., please try to avoid any exposure to that. Don't discuss any of the facts of this case or your jury service with anyone else. However, you may talk to friends, family, or employees, employers, etc., about the possibility of your service and when that may occur. Just avoid talking about the details of the case. That way we can maintain your impartiality and have you return for the next step of the proceedings. So thank you for the time you've committed so far. That will conclude your service for today. And again, you'll be instructed on when to return. With that in mind, is this small group allowed to be released today from the state?
Yes, Your Honor. Thank you.
From the defense?
Yes, Your Honor, thank you.
All right, followed, please rise. All right, doesn't leave a whole lot of time for lunch, but we've got our next group scheduled at 1:30. I understand that might start a bit late if we need to make arrangements and have lunch, but everybody try to, I guess, shoot for that time as much as you can, and we'll be in recess until then. All right, we're back on the record on KCR 22-21-1623. We are continuing through small group board dire with the second group here ready. Before we go on the record to board dire with those jurors, I'll note that the state's here represented by the prosecutors and the defense, as well as the defendant present here. We also have attending members in the courtroom of the public. And the court did have a concern raised and wanted to address that in this case on March 28th, the court issued a non-dissemination order, also commonly known as a gag order. Under the terms of that order, counsel has been prohibited from discussing this case with the media while this jury selection process is occurring in order to try to maximize our efficiency in obtaining impartial jurors. The order is directed towards counsel. However, it also does address if counsel is approached by or attempted to have communication with the media and to report that to the court if it occurs. Nothing at this stage has occurred, but the court is advising and admonishing members of the media in this case that the attorneys are currently subject to a gag order and are not permitted to talk to you about the matter while this jury selection process begins. And I'll remind counsel that if anyone persists or that occurs, you think outside of the scope of the order, please report it to the court, and the court will then address that individually with any media member that is trying to elicit a non-compliance with the order. So any questions about that or the court's order from the state?
No, Your Honor, thank you.
From the defense?
No, Your Honor, thank you.
Okay, thank you. With that in mind, then I believe we're ready to continue with board dire in this next group. Is the state ready to have the jurors brought in?
Yes, Your Honor, thank you.
Defense?
Yes, Your Honor, thank you.
Okay. So it'll be right before then? Yes, sir. Okay, we're gonna have a slight delay here before the jurors come in. Okay, counsel, we do have one extra juror in this pool as well that was either late or FTA yesterday. Juror number 1112, and they'll be included in the group. We'll see them on one end or the other of the front row, wherever the bailiffs think is appropriate, and I'll have them hold up their card numbers so we can confirm where that juror is seated. It probably makes sense to seat them on the far side, to the right of 1623.
And Your Honor, I would indicate on the chart we were given, we had a placeholder. It was just for the other juror number that we brought in this morning.
Yeah,
So
okay.
that most likely just be changed to the 1112.
Yeah, I think we'll go ahead and put them on that side, so we would have 7 on the front row. While we're waiting, also, counsel, on our juror affirmations, there's a couple of notes, and I'll share these with counsel when the time is appropriate, but just note that We've got jurors number 240 and 265. There's something else we'll address with them individually relating to their juror affirmations and some additional information. I'll get you copies of these affirmations so that you can see what they've noted on there, and we can address those in our individual board diary with those jurors.
All right, please. Kevin, go here you are.
Thank you, everyone. Please be seated.
11-12, the front row forward.
Okay, I will confirm. Thank you. Okay, we're on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. I'll note that the defendant, Mr. Daybell, is here present with his counsel, Mr. Pryor. The state's here as well, represented by the prosecutors, and they'll be introduced individually here shortly. Is the state ready to proceed?
Yes, Your Honor, thank you.
All right, is the defense ready to proceed?
Yes, Your Honor, thank you.
All right, at this time then, just to confirm, ladies and gentlemen, of the jury that have been brought back, you're all seated now. For us to just confirm on our seating charts, if you wouldn't mind, please take those red cards you have and hold those up, and then we'll confirm our seating chart.
I think I have the front row on third.
I think for purposes of going forward with the time we have, it might be easier to just get them rearranged. So if you're in the right place, 1112, and the rest of you, if you please stand up, we're going to have you change seats.
Yes. So all rows or
No, just the front row.
just any 1623?
Yeah, you can walk around.
Then 1624. 1640. 1747. 1747 to 1758. And the last one, last year's was 1761. And then this road needs to be one out around. It's gonna be 1793.
Okay, so we'll have the back road shift as well then.
Judge, I have 17.
Let's see, can we have the back row raise their cards? Yeah, I'm sorry, we've got that inverted from the seating charts also.
So you guys stand up. 1793, one around. Then 40. You good? Before we come down to your second seat. Did you 65? 1793, 240, 250, 265, 311, 328. Then 48, 512, 527, and 6517. Now I got him, Mayor. Thank you.
Okay, thank you, Mr. Bailiff, appreciate that. Thanks for moving around. We're tracking you based on your numbers with the charts we've prepared, so we'll do another confirmation here at this time. If everyone would hold the red card number up, please. Okay, thanks each of you. I think we've got it lined up with our chart at this time. Before we begin this portion of the voir dire I'll ask the state and the defense. Is there any objection to the manner in which this jury panel has been recalled and seated today?
No, Your Honor, thank you.
No, Your Honor, thank you.
All right, thanks, counsel. Ladies and gentlemen, thanks for returning this afternoon. You've been recalled as prospective jurors in the case now before us. I'll reintroduce myself and our court staff at this time. My name's Stephen W. Boyce, and I'm the district judge for Fremont County, Idaho, in charge of this courtroom and this trial. Our court clerk today is Shannon Holstein, seated to my right, and she's taking a record and minutes of these trial proceedings, as well as will administer oaths to you as jurors. Our courtroom marshals are here maintaining order in the courtroom and working with you jurors in where you'll be during the proceedings today. And our court reporter is seated down to my left. That's Mary Fox, who takes a stenographic record of all the proceedings. And finally, my staff attorney, Courtney Stallings, is seated to the far right, and she assists me with legal research and administrative issues that come up throughout the day. Each one of you is qualified to serve as a juror of this court, and you've all filled out a questionnaire that's now been reviewed by counsel and the court, and it was determined you could be recalled for further questioning. The first thing we're doing in this trial is to select a total of 18 jurors, which will be 12 trial jurors and 6 alternates from among you. The clerk at this time is going to go through a roll call of each of you using your red card number. And we'll start at the front row with juror 112. But Madam Clerk, at this time, would you please go through the roll call of the jurors?
I call your number, if you could say that you're here audibly. Juror 112. Here. Juror 1623. Here. Juror 1624. Here. Juror 1640. Here. Juror 1747.
Here.
Juror 1758. Here. Juror 1761. Here. Juror 1793. Here. Juror 240.
Here.
Juror 250.
Here.
Juror 265.
Here.
Juror 311.
Here.
Juror 328.
Here.
Juror 438.
Here.
Juror 512.
Here.
Juror 537.
Here.
Juror 657?
Here.
Thank you.
All right, thanks everyone for your attendance again. To assist you in understanding and participating in the jury selection process, I'm going to reintroduce you to the parties and their attorneys. I'd ask each as your name is called to briefly stand and face the jury panel, then retake your seat. The case has been brought by the state of Idaho, sometimes referred to by me as the prosecution. The state is represented at this trial by Lindsay Blake, prosecutor for Fremont County, Idaho, Rob Wood, prosecutor for Madison County, Idaho, Ingrid Beatty, a specially appointed prosecutor in this case, and Rocky Wixom, a deputy prosecutor for Fremont County, Idaho. The defendant in this case, Mr. Chad Guy Daybell, is represented by his attorney, John Pryor. This case is a criminal matter, which means the defendant has been charged by the state of Idaho with a violation of the law. Last week, when you completed your questionnaires, I read to you a summary of the amended indictment containing the charges. With regard to the defendant, the state of Idaho has alleged that the defendant, Chad Guy Daybell, committed the crimes of count 1, conspiracy to commit first-degree murder and grand theft by deception. Count 2, first-degree murder. Count 3, conspiracy to commit first-degree murder and grand theft by deception. Count 4, first-degree murder. Count 5, conspiracy to commit first-degree murder. Count 6, first-degree murder. Count 7, insurance fraud. And count 9, insurance fraud. The defendant, Mr. Daybell, has pled not guilty to the charges. Please remember this is simply a description of those charges and it is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the defendant has the burden of proving, first the state has the burden of proving the defendant guilty. The state has that burden throughout the trial, and the defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. I'll next discuss your duty as jurors. Your duty as jurors is to determine the facts and then apply the law set forth in my instructions to the facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be, or what any lawyer may state the law to be. During the course of this trial, including the jury selection process, you are instructed that you are not to discuss this case among yourselves or with anyone else, including through use of email, text messaging, social media, or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. Do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. At this time, then, I am going to request that the clerk place the entire jury panel under oath for the voir dire examination. Ladies and gentlemen of the jury, if you would please rise and raise your right hands. I'll have to do that now.
Do you solemnly swear or affirm that you will truthfully answer such questions as may be asked of you by court or counsel, touching upon the qualifications to sit as a trial juror in the cause now on trial, so help you God?
Yes. Thank you. Please be seated. In this part of the jury selection, you'll be asked questions touching on your qualifications to serve as jurors in this particular case. This part of the case is known as the voir dire examination. That is an ancient Anglo-Norman term dating back hundreds of years to the origins of the common law, and in Old French it simply means to speak the truth. Voir dire examination is for the purpose of determining if your decision in this case would in any way be influenced by opinions which you now hold, or by some personal experience or special knowledge which you may have concerning the subject matter to be tried. The object is to obtain 12 persons who can impartially try the issues of this case upon the evidence presented in this courtroom without being influenced by any other factors. Please understand that this questioning is not for the purpose of prying into your personal affairs, but only for the purpose of obtaining an impartial jury. Whenever you need to answer a question, you can raise your red card. When you're called upon to speak, please make a verbal response to any questions so we make a clear record, and try to avoid talking at the same time as anyone questioning you, again, so the record is clear. I'll note at this time also that these proceedings are being broadcast on the court's official YouTube channel. You are not being filmed or videoed. However, your audible answers are part of that public access through the court's channel. So with that in mind, if you have an answer to any question that you feel would be potentially embarrassing or just something you don't want to discuss open in the public, then please let me know and we'll arrange to have a more private setting where you can discuss that with the court or attorneys asking you. Also, if you have an answer to any question you think could prejudice or bias any of the other jurors here, please refrain from that and we will discuss that again outside the presence of other jurors. Additionally, many of you may have knowledge of this case from pretrial media coverage and publicity. If you do, please do not discuss in front of the other jurors any specific facts or details of the case. We'll talk to you individually about those as well. And that way we can try to maintain impartiality through what you know not being communicated to other jurors. I'm going to now read you a special instruction that I'm providing in this case, and that's as follows. The defendant, Chad Guy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Vallow Daybell and/or Alex Cox. The crime of conspiracy involves an agreement by two or more persons to commit a crime. You must only consider the evidence against the defendant in this case and should not speculate as to any other case or legal proceedings involving the alleged co-conspirators. You must remember that the defendant has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. That concludes the court's special instruction. At this time, I would instruct the attorneys for both parties to avoid repeating questions already asked and answered. The attorneys do have the right, however, to direct follow-up questions or questions answered by the jurors. Also, for the jury, you should be aware that during and following this voir dire examination, one or more of you may be challenged. Each side can challenge you for cause, meaning they can ask you to be excused for some specific reason. In addition, each side has a number of what are called peremptory challenges, and that means they can challenge you and ask you to be excused without giving any reason for the dismissal. If you are excused by either side, please do not feel offended or feel that your honesty or integrity has been questioned. It is not. I'll also mention that if you are excused and anyone approaches you or wishes to talk to you about the case, with your excusal, you're no longer a potential juror in the case. However, please be aware that we are seeking to obtain an impartial jury in this case. You may refuse to answer questions if asked by the media. Otherwise, please be respectful of your fellow jurors as well as our process in seeking to obtain an impartial jury if you do choose to make any comments. At this time, the court is going to begin its own voir dire of the jury, and after that, the attorneys for the state and the defense will be permitted to ask their questions as well. So the first matter I'll take up relates to what you've already filled out here. You were given both juror information forms as well as a questionnaire. So starting with the juror information forms, if I'm going to ask, is the information you provided in those forms still true and accurate? If it is, please raise your red card. All right, we have one juror that's a more or less juror 250. And this isn't necessarily the questionnaire yet, just the juror information form. Is there something that has potentially changed there?
I'm sorry, are we talking about, this?
That's the questionnaire.
Okay.
The form is just, where you live, et cetera, that you're a resident of Ada County. That was something that would have been filled out, I think, when the summons came.
My wife's title at her job is the one thing that I wrote down incorrectly.
Okay, we'll address that here in a moment on questionnaires. So in addition, of course, you completed this lengthy questionnaire last week. And I'll ask is, if you believe all the information in your questionnaire is still true and accurate, please raise your red card. Okay, and then juror 250, that was your only correction there you wanted to put on the record?
I suppose one more. I wrote that I would only have 3 weeks of PTO on my organization. This would actually be paid in full.
Okay, thank you for that further information. We'll note that as we go through our questioning. That will lead us right into that issue coming up next then. The time commitment in this case, if you're required. Okay. All right, the court just inquired on the accuracy of the questionnaires and information forms. There was a question for juror 328. Did you in fact raise your card, or is there something that needs to
I
be
did
changed?
not. I have an amendment to my medical condition has changed since I filled this out.
Okay, we will bring that up with you also once we get into more specific questioning. So thank you for that information. In this matter, then, the case is going to take from 8 to 10 weeks to go through trial. And given that time frame, the court recognizes that's a difficult amount of time. Therefore, we've asked you questions about whether or not that may create a serious hardship for you. So I'm going to ask you, would that length of time of service create a serious hardship upon you or your family or your business or profession or occupation to prevent you from rendering service as a fair and impartial juror in this case? If you think you would have such a hardship, please raise your red card. Okay, if you'll hold those up for a moment, we'll note each of those. Okay, thank you. All right, on the issue of hardship then, let's start on the front row with, if you give me just a moment to locate your questionnaire, 01747. All right, I'll note in your questionnaire, you didn't indicate there was a hardship. Can you explain what has changed that you think would be a hardship for you?
So we just discharged our last employee. And now I'm a owner operator of a single man company.
So at the time you filled out the questionnaire, you had help and now you don't?
Correct.
Okay, and is this business your sole source of income?
It is.
Explain to me what would happen if you were here doing this full time for 10 weeks, given that situation.
We lose contracts. no source of income to pay rent, utilities. Those kind of things.
And again, that's a change that occurred just in the last week here.
Correct, yes.
All right, let me ask the state if the state has some follow-up order for this juror on hardship.
No, Your Honor, given that information today, the state would move to strike this juror for cause based on hardship.
And Judge, the defense would move to strike him cause for hardship as well.
All right, well, juror 1747, I agree that would constitute a hardship preventing him from serving in this case because it is a very long trial. So thank you so much for taking your time to complete your questionnaire and to return today. The court thanks you as well as the parties. You can be excused with the thanks of the court, and please drop your questionnaire off to the bailiff on your way out. All right, the next juror we'll talk to is 1793. All right, this juror also did not indicate a hardship in the questionnaire. Can you explain what's going on that you believe would constitute a hardship?
My work will only do for 10 days of being on jury and being a single now, I don't have either covered my bills.
And you have confirmed that with your employer?
I have.
All right, and do you have any other source of income? All right, any questions from the state on board on the hardship issue?
No, Your Honor, given that additional information, the state would actually make a motion to strike this juror for cause based on hardship.
Judge, the defense would concur and also make a motion to strike the hardship.
All right, juror 1793, given that situation with your employer, that being your sole source of income, the court finds the length of this trial would constitute a financial hardship. So thank you also for filling out your questionnaire and returning. You can be excused. Let's next talk to juror number 265. You indicated three different things on the questionnaire. We wanted to follow up on some more specifics with those. So why don't you just indicate on the three items you listed in your questionnaire how you believe that would constitute a hardship if you were required to serve 0265?
And mainly because of my kids and their parents. So my parents are in care, they're in memory care and have severe dementia. I do check on them every day to help with activities of daily living. I also take them to medical, dental, vision appointments, and they do have a number of appointments coming up.
On that point, to interrupt, is there anyone else that would be able to step in for that length of time and potentially cover those responsibilities?
No.
Okay, and
So is it possible for me to reschedule that and then delay everything for several months? The answer is yes, although some of these appointments have been scheduled or on the books for months now, but no, there's nobody.
okay, and well, if there's no one else to cover, there's that. But do you believe this would also, if if you were worrying about that situation throughout the trial, would that potentially create a distraction for you where you'd be concerned enough about your parents that it would make it difficult for you to pay attention here during each day?
No,
All right. What was the other issue you had as well?
I think the other one that I put down was just that I have kids in elementary school and, so it would be a bit of a challenge, not insurmountable, but a bit of a challenge in terms of finding childcare and rescheduling their appointments as well. So some travel with them.
All right, I'll let the state inquire.
Your Honor, we actually had a note here to follow up with this juror based on some of her comments in the hardship section. Given her statements here today, the state would make a motion to strike this juror for cause based on hardship.
All right, from the defense.
And Judge, I would just like to inquire a few things. There's family travel plans, the 24th through the 30th, is that right?
That's May, so Memorial Day. And then there's one soccer tournament for the kids.
And obviously those probably can't be rescheduled. I know the answer.
Soccer tournament, no. Family travel, yes.
Judge, I'll concur with the state and move to strike this particular potential juror for causes.
All right, given the expressed hardship for those reasons, I think primarily for the care of the parents issue, the court will determine that juror 265 has expressed a hardship requiring excusal from the case. So thank you for coming in and completing your questionnaire last week and returning today.
Thank you.
Next juror will bring up will be juror number 311. Juror 311. I'm inclined to perhaps just have a quick sidebar over in the white noise area with this juror briefly on the hardship issues. If that's okay with counsel.
Yes, Judge.
All right, juror 311, if you don't mind, if you could just step down for a moment. Author. Stand by for me. Thank you. We can resume the broadcast if that was halted momentarily there. We're back on the record. The court reviewed in private with juror 311 the hardship issue. Counsel agreed, and the court does that would constitute a hardship. Is the state having an objection to 311 being excused?
No, Your Honor, we would stipulate to this juror being excused for hardship.
Thank you from the defense.
Defense is also going to stipulate her.
All right, juror 311, you are excused with the thanks of the court. Thank you for returning today and for filling out your questionnaire. Please drop that copy off with the bailiff and you may be excused. We'll next talk to juror 328. All right, juror 328, you've expressed a concern about plans you have assisting with the work camp and May 26th through the 31st. I wanted to confirm, is that still plans you've got?
Yeah.
All right, can you explain what would occur if you were to miss that?
I help plan and run that camp and I have for 23 years, so I just need to be there to do that, and I have people that count on me to be there, so I wouldn't be able to do that.
All right, and I won't keep pressing, but I'll just ask, have you thought about or determined if maybe somebody else in your absence would be able to cover that this time?
There's a group of staff there, so I'm sure they would find someone to lead my team in my place. It would become a fit, but I'm sure they'd find someone.
All right, let me inquire of the state if you've got any proposed regard for this juror.
Your Honor, we had a note on this as well, given the representation that there was this camp and the strong desire to attend it and the commitment that had been made to it. Given all of that information, the state would make a motion to remove this juror for cause based on hardship.
Defense would concur.
All right, well, sounds like a good cause you're involved in. Thank you for that. The timing is not probably going to work for that for this trial. So based on that, the court does find that will constitute hardship. And with the motion of both the defense and the state, you'll be excused for that reason. Thank you for completing your questionnaire and coming back today. I think that includes those that raised their red cards, but I may have missed one. Is there somebody else that raised a red card in response to that question? All right, thank you, ladies and gentlemen. I'll next go into the area of previous knowledge of this case, if you do have any. This case has been publicized widely. If you do have any knowledge of the case that you've obtained through radio, television, newspapers, podcasts, etc., will you please raise your red card? Okay, if you'll hold those up again for a moment, we'll take those up one by one. All right, for those of you with those answers, we'll simply address those individually with you during the next section when we don't have the others present for those discussions. I'll next move on to the subject matter of this case, and that involves, as you've heard, charges of murder, conspiracy, and insurance fraud. Is there anything about those particular charges that you think would make it impossible or difficult for you to fairly and objectively evaluate the evidence in this case and to render a verdict? Okay, no one answered affirmatively for that. Next set of questions I'll ask might seem overly obvious to you, but certain state statutes require that I ask these questions to make sure there's no connection between you and either the parties or the defendant in the case. So are any of you related by blood or marriage to the defendant, or do you know him from any kind of business or social relationship? All right, no one answered affirmatively. Do any of you have any kind of a legal relationship with any of the attorneys, including a relationship of guardian and ward, master and servant, employer and employee, creditor and debtor, landlord and tenant, or boarder or lodger? So any of those types of relationships between you and any lawyers? All right, no one answered yes to that. Are any of you jurors a party in any kind of a civil action, lawsuit, or anything else against the defendant, Mr. Daybell? No one answered yes. Have any of you ever brought a criminal complaint against the defendant, Mr. Daybell, or have any of you ever been accused of any crime by any of these prosecutors that are here present today? All right, no one answered to that. Do any of you have any kind of attorney-client relationship, either current or previous in the past, with Mr. Pryor or his law firm? No answer to that. Do any of you have any relationship by blood or marriage to any of the lawyers here, or do you know them from any kind of professional, business, or social relationship? All right, no one responded to that. Have any of you formed or expressed an unqualified opinion that the defendant is guilty or not guilty of the offense charged? Okay, no one responded to that. Do any of you have any kind of bias or prejudice, either for or against the defendant, Tylee Daybell? No one answered that question. Are any of you unwilling to follow my instructions to you as the jury to apply the law in determining this case? There's no response to that. Do any of you have any kind of religious or moral position that would make it impossible for you to sit in judgment of another or to render a fair and impartial verdict? No one answered that affirmatively. Are there any of you that, if you're selected as a juror in this case, would be unwilling or unable to render a fair and impartial verdict based upon the evidence presented in this courtroom and the law instructed by the court? No one answered that affirmatively. And finally, a catch-all question for you. Is there any other reason why you would not be able to give this case your undivided attention and render a fair and impartial verdict? Okay, no one answered that, so that will conclude the court's voir dire of this jury panel. At this time, I'll allow the state to proceed with its voir dire. I'll next have the defense follow up. So, Ms. Blake, you can proceed.
Thank you. Ladies and gentlemen, we appreciate you being back this afternoon and hanging in there with us. We know this has been a process. You were all here last week, and now you're here again today. Just to kind of talk to you a little bit about why we do this is, as we go through this selection process, we want to ensure that we get jurors that can be impartial and that can sit and hear the evidence and provide it the weight that it's due, and then ultimately render a decision in this matter. Both the defendant, Mr. Tylee Daybell, and the state of Idaho both deserve a fair trial. And so that's why we go through this process. As we go through it, I may ask some questions. I may ask people to give me some answers, and I may call on a few people as we go through this process. I don't want anyone to think I'm picking on you. That's just what we're trying to do, is select a jury. And for that reason, to ensure a fair trial to both, to everyone here today. So with that being said, I'm going to ask you to think about the term brutal honesty. And juror 1761, if I use the term brutal honesty, what comes to mind for you?
Being totally honest, whether it's good or not.
Thank you. And juror 1758, how about you?
I thought about a club.
And if you hear the term honesty, what do you think?
Fair.
Fair? Okay. And I don't know about all of you, but do you all have someone in your life that maybe doesn't hold back? They're gonna tell you the truth no matter what, even if it hurts your feelings. They're just gonna give it to you straight. Do we all have someone like that? So for me, I had my first niece when she was younger. I learned pretty quickly she could be that person for me. She was young, didn't have the filter, and did not hold back. So if I truly wanted to know how an outfit looked or anything, she was gonna give it to me straight. So to me, she was my brutally honest person. In this case, the judge has already talked to you about the charges. So we have multiple counts of conspiracy to commit first-degree murder, and we have multiple counts of first-degree murder. With these type of cases, oftentimes the evidence that may be presented can contain graphic images. And in this case, we have 2 children that were murdered, a mother of 5. So you may see photos, autopsy photos or otherwise, that may be graphic. Is there anyone here that would have concerns about looking at those type of photos? And juror 1758, you indicated you may have some concerns. Can you talk to me a little bit about what those would be? Rather not say. And I should have started out this way, and I know the judge said, if there's ever anything that you'd be more comfortable talking about outside of the group setting, we can absolutely do that. Is this maybe a situation like that where you'd like to talk outside of the group, or would you rather just not say in general? Okay. Can I ask you, if you were to be instructed by the court that you have to review all evidence, hear all testimony, and then ultimately it would be up to you to give it the weight it's due, do you feel that whatever concerns you have in seeing those type of images would be so great that you couldn't just give that type of evidence the weight that you felt it was due?
Maybe.
You do have concerns about that? Do you feel that your concerns are such that you don't believe that you could sit and be fair and impartial in the case if you were to see images that you found disturbing? Your Honor, I think with those answers, the state would make a motion to remove juror 1758 for cause.
And Judge, I would stipulate to that.
All right. I've considered those responses as well as responses in the juror's questionnaire. I do find there are grounds to support the challenge. So juror 1623, we appreciate your honesty and candor.
And Your Honor, I believe that was juror 1758.
Thank you for that important correction. We'll go ahead and sustain the strike for that juror. Thank you for returning today and for filling out your questionnaire last week, and that will conclude your service. All right, you can continue with Fort Dyer.
Thank you, Your Honor. And when I talk to you about brutal honesty, that's exactly what we're talking about, is we want to ensure that people can be honest and completely honest as we're going through this jury selection process. And then later on, when you're given instructions from the judge and you're allowed to go and talk about the evidence and deliberate if you're chosen to be on the jury, then you get that opportunity. But we need to make sure that anyone that's doing that can be brutally honest. So I appreciate juror 1758's very candid responses as we go through this. Juror 1640, would you have concerns about seeing those type of images?
I think seeing those images just on humanity side of things would be difficult. I don't believe it would impact a decision.
You feel that you could just weigh them in and give them the weight you feel they're due in relation to all the evidence presented? Would that be fair? Thank you. Have all of you been on a plane before? I see nods from everyone. So when you get on the plane, at some point, the pilot or the stewardess comes on and announces, sit back, enjoy the flight. We're going to arrive at our destination at such and such time. If instead of that, the pilot came over the intercom or the PA system and said, hey, I'm going to try to land the plane and I think we'll get there at this time. How many of you would feel comfortable staying on that plane? I see some people shaking their heads. No, I don't see any shaking their heads. Yes. So juror 438, would you feel comfortable staying on that plane? And why wouldn't you feel comfortable?
Just, it's unsure.
The uncertainty of it. And juror 250, how about you?
I wouldn't feel comfortable,
And why wouldn't you feel comfortable?
because I don't think that they'd be qualified for what they're doing.
I appreciate that. And I want to let you know where I'm going with that. And the reason that we give that analogy is as I've already talked about, we're trying to select jurors that can be fair and impartial, because both the defendant, Chad Daybell, and the state are both entitled to a fair trial. So similar to the pilot, we want to make sure that we get jurors that can land the plane. So jurors that can be fair and impartial, weigh all the evidence, give it the weight that they feel it's due, and then ultimately meet together to deliberate and reach a conclusion. And so, again, when we talk about the brutal honesty, if at any point someone has concerns about that, please just let me know. I have a little one, and in the mornings when we get up, one of his favorite things to do is he wants to make me a cup of coffee. But when he makes that cup of coffee, we have a coffee machine, and there's certain directions that you have to follow to use that coffee machine. So you've got to open the top, put the pot in, close it, and hit the button to brew the coffee. So he's learned how to do that. I don't know, do any of you have experience with that? Electronics or coffee machines? Everyone used them before? And they all come with a set of instructions or directions that we have to follow. And in everyone's experience, if you follow those directions, barring there being something wrong with the appliance, does it generally work? So in this case, as we go through things, at some point, the court has given you one instruction or a couple instructions, but one was given today. As we go through this process, the judge will give you even more instructions. And some of those instructions are going to deal with the crimes charged, and they're going to lay out what the elements are that the state has to prove. And the state has the burden of proof in this case, no question about that. And the court will instruct on what elements the state has to prove with each charge. So as you go through those, similar to the instructions to use an appliance, you'll follow those. Now, some people might say, well, maybe I could modify the appliance and make it work. Maybe if I add this to it, it makes the appliance work better. But here in the courtroom, we don't get to do that. So you may look at those jury instructions and you may think, man, I don't think they should have to use this element, or man, they should really have to prove this element. Can everyone commit that you would set any of those thoughts aside and only follow the instructions as given by this court? And could everyone commit that regardless of if someone tried to instruct you differently, or if someone tried to convince you that you didn't have to follow that instruction, that you would stick with whatever instructions given by the court and only follow that one? Thank you for that. With some of these charges, they involve the crime of homicide. And in those, and again, the court will be the one to give you the instructions, but you'll be told that the state has the burden to prove that a homicide happened, but one of the elements is not going to be that the state has to prove the cause of death. Would that cause anyone concerns in being able to follow the instruction as given by the court? Would anyone be concerned and say, well, I think the state should have to prove this, and so we're going to hold them to an additional element? No one would do that. Thank you. Does anyone here watch football? I see some people, kind of. Okay. Juror 1624. Or no, sorry, 1623. I think you're the one that was said kind of. So this year in the Super Bowl, Kansas City Chiefs won. And some people may be happy about that, some may not. But regardless of your feelings of who won, would you agree that everyone on the team should get a ring? A Super Bowl ring. So even if you look at it and you say, man, the quarterback did a lot more, would you agree the punter should also get a ring, and the coach, and even the second string that may not have even played on the field? Because they're all part of it. And I'll ask, I think, juror 240, you said you kind of watch football?
Yeah.
Do you feel the same way? Should everyone on the team get a ring? And why do you think they should all get a ring?
A lot of times it's not a player's choice if they're on the second string. I'm sure they would love to be on the field too. But I figure if they're part of the team, they deserve a ring.
Thank you. The judge has given you one instruction regarding conspiracy, and he's talked about two co-conspirators in this case, or two named co-conspirators, Rory Vallow, Daybell, and Alex Cox. And you've been told and instructed by the court that you shouldn't concern yourselves with anything that may or may not have gone on with regard to those two co-conspirators. And everyone has committed, you can follow the court's instruction, right? What you will hear about in this trial is some evidence and testimony regarding those co-conspirators. You may hear evidence and testimony regarding actions that they're alleged to have done. You'll also be given instructions regarding a conspiracy. And you'll be, and we'll talk about the fact that it involves an agreement between two or more persons to commit a crime. And then in addition to that, that one of those individuals, just one, has to do some kind of act in furtherance. So one person has to do something to try to further that conspiracy or that agreement to carry out a crime. Does anyone have concerns if you were to hear that person A, person A, B, and maybe C agree to something, and only person A does another act? Could everyone here commit to follow the court's instruction regarding what's required for a conspiracy? And that would include that only one of them had to do an act in furtherance. Does that cause anyone concern? If today you had gotten out of bed and come to court, and as you left home, the sky was turning a little bit gray, and you came in the courtroom and we shut all the windows and you couldn't see outside. And when you get outside, you notice there's rain all over your car, the grass is wet, the pavement's wet, you start to drive home and you see everything's wet. Would you be able to determine what happened? I see people nodding their heads yes. And juror 1624, now I'll come to you. What would you determine had happened?
Obviously, right.
Thank you. And juror 438, how about you?
Same thing. If it rained and hailed or something, you got one.
And juror 512?
It rained.
And would you be able to make that determination without actually seeing the rain? So in this case, you may hear different types of evidence, and you may hear the term circumstantial evidence. Do any of you have a problem with weighing all the evidence presented and giving it the weight it's due and reaching your conclusion? Would anyone here say, if I don't see this particular type of evidence, I'm not going to be able to consider everything in this case? Does anyone come in here today with a preconceived notion that if someone's charged with homicide, we have to see this specific piece of evidence? Nobody? And Judge, I don't have any additional questions.
All right, thank you, Ms. Blake. Mr. Pryor, you can commence with the defense or direct this time.
Good afternoon, ladies and gentlemen. We're here today because obviously we have a disagreement between the state of Idaho, the prosecutors, and the defense. Part of the process that you're involved in is for us to be able to ask you some questions, to talk to you about your feelings about a lot of subjects. And I understand it can be uncomfortable and can be difficult, but really this is our opportunity. The prosecutors, they want to get to know you a little bit better. And I'd like to get to know you a little bit better. And all of your opinions are important. Every single one of your opinions are very important to us, because that's the only way we can determine opportunity to be a fair, partial trial. All of you folks kind of understand that? And one of the important things, and Ms. Blake was kind enough to point that out, that we need to talk to you about trying to be as honest. Because there is no wrong answer. All of us come from many, many diverse backgrounds. All of us have many, many experiences. Most of you are a lot younger than me. And I have a much different experience than many of you who are still very young. Okay, so we all come from different backgrounds. We all have different ideas. And as you walk through this and see this process, you'll realize, oh, there's a lot of us that don't really agree on everything and we just have different views, but that doesn't make anybody's view less important. So if I could just ask you, please don't be afraid to express your view. And again, if you're uncomfortable expressing something to me, just say it and we can arrange for the judge to sit with us and we could talk about it privately, because this isn't supposed to embarrass you. This isn't supposed to make you uncomfortable. It's just a chance for me to spend some time with you, a little bit of time to get to know and see where you fit in terms of whether or not you might be a good juror for just this case. All of you, in going over this thing, I've realized that all of you would be great jurors in a lot of cases. But every case, like anything else, is always different. And that's kind of what we're going through, and that's what we're trying to accomplish here today, okay? So I'm going to start out with a couple of easy questions, and I'm not going to, and if you don't know the answer to anything, just don't answer. You say, you know, I don't know. I'm fine with that, okay? So all of you heard the charges. Judge Boyce was kind enough to read the charges and let us know what we're here for. And obviously, these folks know what we're here for, and I know what you're here for, what Chad's here for. But when you heard the charges read, did anybody assume right off the bat that Chad was guilty of the charges? Can I see your, just raise your hand if you said think he was? Nobody. Now, a good number of you have had some exposure to media. And could I see a raise of hands on the red cards of those of you who have watched any kind of media as it relates to this case? So 112, 24, and 438. So 112, tell me a little bit about the media you watched.
This prior, I'm sorry, I want to do this in individual voir dire, just in case it doesn't elicit any specific facts.
And I was going to go with a very general, but I think I'll defer to the court and do it on private.
All right, thank you. All right.
So let's move on from the media exposure, because I think I can handle that differently. Does anybody believe that Chad should have to testify to prove his innocence? The judge is going to give you an instruction that's going to say, Chad is not required to testify. It's not his job to prove that he's innocent of these charges. Does everybody understand that? Okay. Does everybody understand that the prosecuting attorney is required to prove that Chad is guilty of these charges? Would anybody require Chad to prove that he's guilty of any charges? Raise your hands if you think Chad should prove that that he's innocent of all of these charges. Anybody require Chad to prove that he's innocent? Juror 1112, you just hesitated.
Well, I was trying to, in my mind, understand what exactly you were asking, because it was like, I mean, he's here in court, so he has to somewhat, he's saying he's not guilty. So I was trying to decide how you were wording it. If I think he needs to be part of the versus.
And that's what's really great part of this discussion we're having tonight. It's because I kind of want to delve into that and see what you think he should have to do to be part of this process. What do you think he needs to do?
I don't know. I feel like we will see all of the evidence, and I feel like he's already claimed he's not guilty. That's what he's saying.
Right.
So I feel like we just need to look at the evidence and make a decision for ourselves.
Okay.
I don't think he needs to do anything extra than the evidence that was given, because I feel like that's what the court's going to give us, that we're supposed to use.
Okay. Okay, thank you. And do you think it's necessary in order to come to a conclusion that he should have to present evidence? Okay, and does everybody understand that if Chad and I decided to, the state could put on their case and I could say, I don't need to show anything. And if the state hasn't done what they're trying to do in this case, all of you, the verdict would be not guilty. You folks understand that? Everyone raise your hands if you understand. We just went. Now, do any of you jurors know each other? Anybody know each other personally, friendships otherwise? No? We're going to be sitting for long periods of time. And I happen to mention one of the older people here. I am. And sitting for these young folks here, sitting for a long period of time, sometimes it's uncomfortable. Is there anybody here who has difficulty sitting for long periods? Okay, thank you. And even though both of you are much younger than I am, tell me, is there a limit, or is it going to be a problem for you to have to sit for a long period of time? It is?
Basically, yes.
Okay, can you make it an hour or hour and a half, or is this going to push it a little bit? And if this is too private, we can go and talk to the judge privately if you'd like to do that.
No, it's, no, a couple hours.
Okay.
Need to stand up after that.
And, you know, and we're going to be doing this for like 8 to 10 weeks, every day, 5 days a week. Is that going to be tough for you?
Probably.
Do you think it was going to be tough enough that you're going to have trouble concentrating and focusing on the case?
No, I got it. Got a mind.
Well, I don't want to question your mind, because I have oh my gosh, I don't want to say how old she is, because she really good at it. My mother is sharper than I am, and a lot smarter than I am. So I'm not questioning that, but I know I get uncomfortable after sitting for 22 hours. I just want to make sure you're going to be okay. Be okay? Will you let us know if you change your mind on that? Will we bring you back? Promise me. Okay. And then we had juror number 512. Did I get your number right?
Yes.
Let's talk about the same thing. And like I said, because you're so much younger than I am, it's hard for me to believe that.
I get really restless, tingling to my body, restless syndrome, but I have medication that doctor gave me for long overseas flights that I can take. Doesn't affect my ability to think, just makes things not so jumpy.
Okay.
You're okay with that?
And are you going to be able to do this for like 8 or 10 weeks?
Yeah.
You sure? And if there's a problem, and again, the judge isn't going to let me get out with that. If I tell him that my legs hurt and I need to stand up, he's probably not going to let me do that. But for you, I'm pretty sure he's going to do that.
Don't hurt, it just jump.
Okay. Okay, thank you. I want to kind of get into this discussion about graphic pictures. And some of you have talked about some of the media exposure and other things. When you watch TV and you see startling pictures, would most of you agree with me that the reason they show those startling pictures is to get a reaction? Raise your hand if you agree with that. One person agrees with that. Okay. Is there anybody who would give me some other reason why media outlets, podcasts, or any of these personalities display, you know, tantalizing facts or you know, pictures? Go ahead, juror. That would be juror number 250.
Correct. To get more viewers.
Okay. So it's kind of a self-serving. They sensationalize things, they inflate things, and they do it to try to get people to watch their show.
At the root, I would just say.
Okay. Now, if you're shown very graphic pictures, okay, it's going to be difficult not to have a reaction. And go ahead.
I don't know.
You don't think so?
Well, when I was growing up, I've seen a lot of gory videos. It doesn't make face.
Do you think that applies to the rest of these folks?
No, not at all. I think I'm unique.
And juror number 1620, oh my goodness, 1620.
My profession is safety, so I've seen a lot of really, reaction would be just like, oh, but not a reaction to make a decision factor on
Okay, that's really where I'm kind of going. Because quite frankly, we're going to be looking at some very, very graphic pictures. Look at some tough pictures. These pictures are going to hurt your heart. They're going to hurt your heart a lot. These pictures hurt my heart. But as juror number 1623 said, you may have a reaction, but you don't make a decision based on that reaction. Would you agree with that? Okay, does everybody understand that? So when you look at these graphic pictures, you can look at them, observe them, but does anybody think it's fair that when you look at these graphic pictures, you assign your reaction and immediately make Chad responsible for those? Is that fair? Would anybody raise their hand if they think that's fair by looking at graphic pictures and immediately say, well, it's all his fault? Does anybody believe that's fair? Please raise your hand. Thank you. Okay. Now, Ms. Blake was talking about the plane and getting on the plane. And if the pilot makes the comment that he does, you don't know what's going to happen to the plane. If you're trying to determine what's going to happen to the plane, would you call that trying to determine what's going to happen to the plane a guess? Because we don't know. Would everybody agree that that's a guess, or you're speculating what's going to happen to the plane? Would that be fair? Anybody disagree with that? No. Okay. So when you speculate or you guess about things, does everybody agree that could be problematic in a number of ways by speculating and guessing? And I see some heads shaking, and I see some people acknowledging that, and I'm going to pick on 1640 a little bit. I don't want to use pick on. I think what I'm going to say is I want to hear your opinion because it's important. And all of your opinions are important to me, all of them. And please, if I don't call you, it's not that I don't value your opinion. If anybody wants to say anything, please speak up. I want to hear it. But when you're making major decisions in your life, do you ever think that it's a good idea to guess or speculate about what you should do?
Try not to.
Right. And why do you try not to?
I need to remember this, Judge.
1640. Why do you try not to?
If it's a major decision in my life, I like to go with as much concrete facts as I can.
And you could understand how important that is, because if you're making a major decision, whether about yourself or about anybody else, it's extremely important that you make that major decision on concrete facts that you have. Would anybody disagree with that? Okay. 1761, you shook your head and you said, no, I wouldn't disagree with that. Do you think it's important that when you make a major decision, regardless of what it is, that you base it on concrete facts that you have at hand?
Yeah.
Should you guess about other things and speculate and say, well, maybe that kind of thing, or should you really be making it on the concrete facts? Okay, all right. Juror number 657, you sat there very quietly, and I also want to hear from you, because I want to value your opinion. Tell me a little bit about speculation and guessing. Is that important when you're trying to make a decision on important things?
I think you shouldn't just like guess on a whim on something or just think, oh, okay, yeah, I'll choose this or this. You really do need to weigh everything that you have in mind, whether it's been presented to you or you already have knowledge of it. Well, I guess that's kind of a poor way of wording it. But basically everything that you know of properly, that's been presented to you properly, you should weigh that.
Okay. Okay. And juror number 537, can I hear your thoughts on that a little bit?
Yes, it's really important, especially if it's gonna be something that's gonna affect you or affect those around you, that you make the best possible decision based on the information you have. You try to guess or anything like that, you're not taking the facts and you're not taking it and making that decision. You're maybe letting your heart or somebody else's influence cause you to make a decision.
All right. And go ahead, I'm sorry, juror number 657, please.
Sorry, I just kind of wanted to reword what I said, just to make sure I kind of get it across clearly.
Okay.
Basically, when it comes to making any sort of major decision, it's never, almost never a good idea just to guess, on a whim or, just assume, I guess you could say.
Right.
It's always very important to weigh information, weigh facts, before you make, especially a big decision.
And would you all agree with me that it's never a good idea to speculate about facts? That what we should really do is look at what we have at hand and make a determination based on what we have at hand and not guess about other things, other possibilities. All of you agree with me on that? Go ahead. I saw you.
We're talking about we're talking about two different things here, because that's saying about this case, which I agree with, right?
I'm talking about.
But there was also
Hold on.
a personal side.
Hey,
here.
wait. We cannot talk at the same time as each other, so we need to have question
Go ahead,
and
I'm
answer
sorry.
for the court reporter.
He's 438.
Mr. Pryor, if you just pose a new question and then let's make sure to not have that.
And I apologize, Juror. I wasn't talking specifically about the case about speculation. I was talking about major decisions in your life, how you go about making decisions about those. So go ahead.
Well, sometimes I don't have all the facts, like major decisions. It might be a financial decision, buying stocks. I collect all the facts that I had at the time, but there is an element of speculation when it becomes personal. I have to make a decision.
Okay.
So that, I'm just saying there was some questions about personal, and then it went down this case, and I kind of like separated the two just based on questions.
Okay. And lastly, and then well, maybe lastly. I don't judge. I listen to country music. And I enjoy it. Some of you are horrified. And there's a song that I like occasionally play. It's a song that says, everything that glitters is not gold. And it talks about relationships. And I see some heads shaking, 112, 11, 1112 shaking. Tell me what came to your mind when you heard me say that? You know the song?
I think so, and I mean, I agree, I think there's a lot of things that are distracting or that might look really nice or things that you think are good things and then you realize they're not. And the things that probably are worth more gold are things that are tangible, so yeah, I agree with that, there's not always a base value of everything.
And would you agree with me, and all of you agree with me, that sometimes you look at something and it's shiny and it looks great. It looks like a wonderful opportunity. And then when you delve in deeper, you realize that maybe this glittering gold isn't what it's represented to me. And that's juror number 537. Talk to me a little bit. I see you nodding.
Yeah. For instance, if a job opportunity is presented to you and they really hype it up and say, this is going to be so much better than what the place that you're at already. It's gonna be the same thing that you're doing, but we're gonna give you more money, the culture is gonna be better, it's gonna be better emotionally and physically for you. And you go, oh yeah, because you're maybe not super content where you're at, but you like what you're doing. And then you go to this other place and you're doing the same thing and you still love what you're doing, but it's not what they said it was gonna be.
And the problem is that if we're talking about a job, you quit your other job. You move on with your life and you put some investment into something. And you believe all these things, whoever it is telling you that this is gold and you're gonna love this. And then when it's too late, you find out it's not gold, it's focus basin and it's fool's gold. You all know what I'm talking about. That's a real situation. Would you agree? Would everybody agree with that? People fall into that trap very easily. And it's very easy to get people to fall into that and dangle them the gold in front of them. And all of us are susceptible to that. And when you fall into that trap, it's painstaking, isn't it? So, do you agree with that? Especially if it's a job. Folks, I want to thank you. You made this very easy. I hope I haven't inconvenienced you or embarrassed any of you. And please, I want to thank you for your time. It's important that we have a chance to meet each other and talk about these things. And I appreciate the time that you've given me today. Thank you, folks.
All right, thank you, Mr. Pryor. What I intend to do next, let's have the jurors excused. We'll take a mid-afternoon brief recess and start with our individual board dire. However, just before we have the jurors excused, there's two I'll just have stay together with some questions on the juror affirmation. So we've got juror 240 and 265. And if we could have the rest of the juries retire for a minute, and I'll pass to counsel these for their review, and then we'll have a few questions on that, and we'll continue in individual.
Your Honor, I think 265 was already excused.
Oh, apologies, I should have been tracking them. So we'll only need to talk to 240 then.
All right, please. Yes.
All right, juror 240, we excuse the other jurors. I just had a question and wanted some clarification in your juror affirmation form.
Yes.
And you made a notation and said, quote, have watched the jury deliberations. So,
I think I missed selection, but yes.
okay, so let me just clarify that issue. You filled out your questionnaire, and then after that is when you did watch some of these proceedings that were being live streamed or something?
Yes, I was curious about what questions would be asked of the jurors, and I knew that the jury selection was being live streamed, so I pulled it up and watched maybe half an hour of it.
All right, and I appreciate your honesty on that. Did you understand that you were advised not to do that?
I guess I didn't think about it at the time, but I also didn't think that official court business would be an issue. Yeah, I guess I didn't think about it at the time.
Okay, I guess the concern I would raise is if this is a continuing instruction and if we make it more clear, is this something you think you'd be able to refrain from doing and follow the instructions, including not watching any further proceedings either now or when trials taking place?
Yes, I would have it not happen.
Okay. I want to have a little additional board dire from the state and the defense just on that issue, and then we'll determine where we are. And in fact, just in the interest of efficiency here, if we want to just do the individual regard first with this juror, let's just go ahead and do that. The first, I do want to bring up the subject of that with the affirmation. And again, I very much appreciate your honesty in advising the court of that. And I think that does say a lot that you did advise us. And I can understand that may not have been entirely clear and may not have been clear to you that we were actually going to be broadcasting these proceedings. So if the parties are ready to do that, does the state have any questions regarding that comment in the affirmation?
Not with regard to that comment, Your Honor. Thank you.
Mr. Pryor.
Judge, I do have a comment in regards to that, but it touches on what he said in his questionnaire. One of the comments he made in his questionnaire, if the court would give me some latitude. You don't, and you would rather wait, I can wait, Judge.
Yeah, I will. There's some potential bias in here from pretrial knowledge also. So if you want, we could just start with looking at that issue as well.
Your Honor, if we may have just a moment to confer with counsel.
Why don't you do that, and then we'll just take up sort of the full individual questioning of this juror on individual board art.
Thank you.
Your Honor,
Yeah. Okay, we're back on the record now. We had a sidebar discussing briefly with counsel the issue as well as topics raised in the questionnaire for juror 240. The court understands that the parties would essentially stipulate and agree that 240 may be dismissed based on responses for bias at this stage. Does the state move to strike this juror based on that?
We do, Your Honor.
All right, any
That's as
objection?
well, Judge.
All right, well, juror 240 again, thank you so much for your honesty in filling that out. For reasons also stated within the questionnaire about some knowledge of the case as well. We've determined that it would be inappropriate for you to serve in this case, just mainly based on that prior knowledge of the case. And so for that reason, you will be excused. And we appreciate you coming in, filling out your questionnaire and returning today. You may submit your questionnaire to the bailiff there, and you are excused from service.
Thank you.
You're welcome. All right, let's take a recess here, and then we'll come back on the record for further individual voir dire of this remaining jury panel.
All right, please.
Thank you. Please be seated. All right, at this time, we're going to take up additional individual board diary with jurors. We are back on the record on KCR 22-21-1623. My intention in order will be the front row farthest away to my left, and then the back row in that same order. So the first juror we'll have brought back will be juror number 1112. Is the state ready to proceed with board diary?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
Okay, thanks everyone, and we'll instruct the bailiffs to please bring that juror in. Hi, welcome back. We're going to do some individual board questioning with you at this time, juror number 1112. As we get started, the first issue I just wanted to raise was the timing of your appearance, I guess I'll say, and non-appearance. I think it was yesterday. And I did want to know if there was an explanation about how you missed the timing for the first time you were supposed to be here.
Just an embarrassing one. I just completely misunderstood the directions, and I knew I had to check in, and I had my phone, and I was like, oh, I'll just call in, and didn't recognize that it was just different instructions. And so once I found out that I had missed the correct way to log in, and then I missed my number, I called and I apologized and just said, if there's still an opportunity, because I filled out the questionnaire, I kind of did all that prep. Is there still an opportunity I could show up for this, since I already did that prep work? So just me not looking at the instructions fully. So.
Okay, well, and I appreciate the explanation.
Yeah.
And not trying to just put you on the spot on the issue, but we obviously will need to have a lot of instructions followed, timing to be here. And you think generally you're a dependable enough person that we could count on if in fact you were here determining this trial?
Yes.
Okay, well, thank you so much for the responses and the explanation on that. Moving on then, for the remaining issues here, the courts looked at the questionnaire in this case and did see that you've somewhat followed this case in terms of knowing about it, or maybe watched some media about it, you know, some details of it. And I would like to start there with questions of possible bias. On your questionnaire, you said you did have some kind of personal opinion or belief, and one of the ways you stated it was, well, a couple different ways. Circumstances seemed too obvious that he was involved, and it is obvious he was involved in some way. So, and again, your feelings on this, we want to know really accurately where you stand on that, to see if you are or could be impartial in the case based on what you already know. So when you answer that way, do you have some presumption already in your mind potentially about him being guilty?
No.
Okay, and to explain, when you say involved in some way, what first of all, what do you believe he is involved with?
Just because of seeing what's on either the news or in any of the coverage. Obviously he was there on the video, and he was with Lord Vallow. So just seeing that on the media, so I knew that they knew each other. I knew that they, I think, were married. I can't remember if they were officially married, but anyway, so I knew that they knew each other. So from all of the things that were shown on the media, just by knowing that they have a relationship, there's that circumstance that there may be some
involvement with each other for sure. I don't know about the involvement in all of the different pieces of the case. If that makes sense.
Okay. All right, at this point, I want to have counsel inquire further on the issue of potential bias here. So we'll begin with the state and any questioning and then move on to the defense.
Thank you, Your Honor. Juror 1112, and just again, there's no right or wrong answers. Just feel free to tell us the way you see things. Looking at your questionnaire, it looks like you've followed East Idaho News, actual court summaries of Lori Vallow. Does that mean, did you look at some of her trial or listen to some of her trial?
The East Idaho News, my husband's from that area. And so that's probably what piqued our interest. And then somebody told us they're doing summaries of what's happening in the case. And so, yeah, we would occasionally look in that and just see what was going on because of the different ties to the area and things like that. We wanted to see what was going on. It's very covered.
Yeah, there was a lot of media.
Yes.
And so you've also seen the Dateline and the Netflix. So you understand that this defendant has an absolute right to a presumption of innocence.
Yes.
On the bottom of page 15 of your questionnaire, you say, and I think the judge might have already pointed this out, but circumstances and evidence the news showed seem to point a guilty picture, but I will look at the actual evidence. Is it possible that if you were to sit in judgment on this case as a juror, that you would have some of those things you've heard in the back of your mind?
I really don't think so. I'm not one that watches a whole bunch of news stories and things like that, but the one thing I have realized is the media says what they want to say. And by being part of this trial or any sort of a trial, there's so much more evidence I know than what they are going to say on the media. So to me, that's the way the media is across all things, politics, trials, whatever it may be that we're covering. They're going to show what they want to show, and you're only seeing this small viewpoint. So to me, it's easy because I already feel that way about what you see on either social media or even just in the news. So it's easy for me to really just look at, I know I'm going to see evidence in this trial that probably did not even make it into anything else. And so you have to take what's in front of you to really decide, because there should be a lot more than what I even think I've seen. So yeah, I think it's easy.
Should the state or the defendant be concerned at all that because of how much media you have seen, that maybe you're waiting for something to be shown that doesn't get shown, that maybe there's something in those media reports that you think is important and that doesn't end up in court?
No, because I would not say I followed it enough to know what even would be left out or what would be included. It was just definitely a high level, hey, what's happening with this, not knowing or remembering necessarily what all was shown in the media or in all of the different outlets. It was just definitely on a high level, hey, this is going on in our culture right now. So, so no, I wouldn't be looking for anything because I don't think I would have, nothing would have stuck in my mind.
Okay. Thank you for your honesty. Thank you for your answers. Your Honor, given just the nature of what was put in this questionnaire, and with all respect to Juror 1112, the state does have some concerns that just so much has been seen. And so we would move to have Juror 1112 excused for cause.
All right, response from the defense on the motion.
Well, Judge, I really appreciate Judge 112's sincerity. I really do. But my concern, Judge, is unfortunately you watch the Netflix thing. Then you watch the Dateline thing. Then East Idaho News. You watch the summaries. And I understand your explanation about that, but those questions kind of said, did you form an opinion? And you kind of said, well, it kind of points towards guilt. I'm a little concerned, Judge, that, you know, she's gonna be able to look at this stuff, but in the back of her mind, she's gonna say, well, you know, I saw that on Netflix and all of that, so I'm deeply concerned about that, but it's not to imply anything about you. I think I really appreciate your honesty. I really do. But thank you. And Judge, I'm just gonna also move to this.
All right, I've considered the responses here too as it relates to bias and equally share the concerns raised by the defense and the state that there just might be too much already known information about this case, including facts, which could lead to some improper speculation. So again, this is nothing personal at all. We appreciate your candid responses in the questionnaire as well as before the court today. And with the sincere thanks to the court, I will grant a strike on juror 1112 for perceived bias or actual bias, and we will allow you to be excused. So thank you for returning for further questioning. If you please drop off your questionnaire with the bailiff, then you may be excused for the day. We'll next speak to jurors 1623. Welcome back, juror 1623. We've got some further individual questioning for you at this time outside the presence of the other jurors. Beginning with questions about your knowledge of the case. You do indicate in your questionnaire you followed some of the case, you do know some of the details, so this would be the time for us to be able to fully discuss that, where other jurors wouldn't be hearing what you know. But we would like to delve into that. So I don't see anything in particular that I feel I need to voir dire on, but I will allow the state and the defense to ask some questions. One issue I just wanted to ask you about, I guess, in the questionnaire where you talked about what you've seen, you did say state versus Lori Vallow, news reports, and final verdict.
I did, yes, I did watch the final verdict when it was televised.
Okay, so that was televised and you observed that as it occurred?
Yes, I did.
Okay. All right. Did you watch any other parts of that?
No, I did
case?
not. No,
A sentencing hearing?
just the one that was televised at the very end. When the full verdicts came down, that's the only time I didn't watch it any other time.
All right, thank you for the response there. If the state has any more dire on this issue, you proceed.
Thank you. Thank you, Your Honor. Ma'am, I do have a couple of questions. On your questionnaire on page 18, you were asked, what have you heard or what do you know about Tammy Daybell, Tylee Ryan, or JJ Vallow? And you had responded, among other things, that what you hadn't understood was that the children's bodies were found on Mr. Daybell's property, and that Tammy Daybell's body had been exhumed. I just wanted to ask, those are substantial allegations the state is making in the case. Have you inferred anything from that information, anything at all about Mr. Daybell?
No, I have not.
So even though you've heard about those allegations, you think you can set aside,
Absolutely.
additional funds?
Facts are facts. That we presented.
She just doesn't want us to talk over each other, so go ahead with your answer.
No, there's no decision of anything else. Facts are facts for me. And that's what I have to see in order to make a decision.
Okay. Just 1 second, ma'am. And then just on that, in that same vein, on page 22, you noted that you believe that Mr. Daybell had claimed innocence in knowing where the children's bodies were, but then they were found on his property. So you made a point of noting that.
Right.
Is that
It was, I'm talking about when they were there in Hawaii, and he said he didn't know where they were at, but then the news, everybody's saying that it was found on his property. And that I didn't learn anything else past that.
Does that information cause you to infer anything about Mr. Daybell? Would you be more or less likely to believe him if he chose to testify?
No, I would not.
No, I don't have any more questions on this point.
All right, Mr. Pryor.
And ma'am, again, there's no wrong answer. And when you heard all of that about what happened in Hawaii, did you have an opinion that Mr. Daybell may be guilty?
I couldn't make an opinion. Unfortunately, the news doesn't always share everything that they want you to, that you should know. So I can't make an opinion if I don't have all the information in front of me.
And then you watched Lori Vallow's being convicted.
Yes, I did.
Did you, at that point, you obviously had an opinion about, right?
Opinion is not the right word. It's what came down to what the jury found for her statement or for her closing case. My opinions, everybody has an opinion, but I have to have a fact in front of me in order to make the decision, or to the best of the ability to make my decision.
So even if you had an opinion about Mr. Daybell, what it sounds like to me is that you're going to be able to push that aside and still just evaluate the facts. Would that be fair?
Yes, can I add to that? My profession is human resources and safety. So I have to have the facts to make a decision. So I'm always investigating situations down to the final decision. So that's how I make my decisions.
So there was obviously some interest you piqued some interest in this matter. Now, would that be fair?
Yes.
And if I understand, you looked at the announcement of the plea on Lori Vallow. And again, what else did you look at? Remind me again.
It was when they were in Hawaii and they stated they didn't know where the children were.
And you saw that where?
It was on the news.
You don't know which news?
It was Channel 7 or Channel 2.
And you didn't read any newspaper articles?
No.
You didn't look at anything on the internet?
No, I tried to be separated from it, just so that if there ever is a decision, I don't want to be tainted to make the right decision. Where I'm at right now in jury, you never know what's going to happen.
And this is what I'm struggling with, and I'm not questioning you or anything like that, but as someone who, has a thirst for wanting to know what the facts are and wanting to make the right decision. And then I hear, well, as the human resources, I'm trying to discover what's really going on here. So in my mind, that would sort of prompt me to look into this a little bit, because if you were so interested in Lori Vallow and interested in Hawaii, I would think you would have pushed that a little further. And then on the other hand, you're saying, well, I'm not going to make a decision because it sounds like you kind of predicted that you thought you were going to be here today.
No, the media can never, unless you're here, the media is not going to give you all the information ever. So unless I watch the hearings to see all the information that's provided, I can see the news and it's still not the deciding factor.
And I appreciate your explanation. Nothing else, Judge.
All right, thank you. Juror 1623, let me just follow up a little bit on your knowledge of a conviction in Lori Vallow's case, which was previously tried. Where you have that information, do you believe that's going to cause you to draw some sort of inference of guilt to the defendant here in this case?
I do not.
All right, and do you believe you can set that aside and deliberate only on evidence that is provided in this case?
Yes, I can.
All right, and where the jurors are instructed not to communicate with each other about anything they know about the case or until deliberations or even going there, are you committed that you wouldn't be discussing that fact or information with any other jurors if you are on this case?
I am.
Okay. Then on that point, I think that will conclude questioning. There's been no motion for cause, and so the court also feels there's no reason for cause at this point. I don't think we had any indication of concerns as it relates to potential hardship. So I'm going to go on to another topic at this point, unless either side thinks they have any final board ire on the issue.
May I, Your Honor?
Go ahead.
Thank you. And frankly, Your Honor, I don't know that I have more questions, but I think the state would take the position that, and we appreciate the candor and the honesty, that it would appear that there was some significant information that was obtained by this prospective juror on just tracking the case. And that coupled with what she does know about Ms. Vallow's conviction, that the state would just find it appropriate to strike her for cause at this point based upon that information.
All right, what's the response on the motion for the defense?
Judge, I think she's being really sincere, and I really believe that. But my concern is that, again, just having the knowledge of the Lori Vallow case, I think that's what cuts it off for me, and I'm sorry about that. But I think the knowledge of the Lori Vallow verdict, that causes me just to hesitate a little bit. So I guess I would just move for cause, okay?
All right, and I'll indicate I am really wavering on this too. I do believe you as well, that you would be able to set that aside. It is, however, a pretty significant fact that if it were to come out, we don't know if that's going to come out during trial. It shouldn't, but it could. And then in the course of deliberations, there's a real concern that could persuade people against the right of the defendant to have a presumption of innocence. And so with that potential, I do think I'll permit the challenge for cause raised by the state, not objected to by the defense. So very much appreciate your time and your candor and coming back after filling out your questionnaire. Juror 1623 is excused for cause. And if you please drop your questionnaire with the bailiff on your way out. Thank you, ma'am. We'll next talk to 1624. If you're ready to answer this, counsel, I don't know that we had any specific hardship or bias concerns. They did mention something about some doctor and dentist appointments, but didn't say it'd be a hardship. Is that a topic you think we need to go into?
No, Judge, I'm gonna move on from bias and hardship. I think she acknowledged that in her answer at the very top about the doctor's appointments. So I have nothing with bias and hardship to defer to the state.
Your Honor, on this juror 1624, I did have one concern with bias, but it sort of overlaps with the death penalty issue, which is just the comment that this juror wrote that under the death penalty section, that the accused gets time to prove innocence. That sounds a little bit like burden shifting to me. That was something I was going to question this juror on, but we could also do that during the death penalty portion as well, since the juror did make that statement in the death penalty portion of the questionnaire.
All right, thank you, Ms. Beatty. We'll go ahead and take that up. I'll just begin with the questions regarding the death penalty, and you can inquire on that response then. All right, welcome back, juror number 1624. We've got some additional questions for you outside of the presence of the other jurors. I believe you've been provided a copy of your questionnaire, and there's a specific section we'll be discussing within that, starting on page 12. And you could just refer to that. The section is attitudes regarding the death penalty. Do you recall reading through those questions and answering those last week?
Yes.
Okay, and to your recollection, are those answers you provided still accurate in the way you feel about the death penalty at this time?
Yes.
All right, I want to let you know and advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty in this case or some other penalty. And remember, when you're considering that and any penalty, you need to consider it as if it would be done and absolute and carried out in the case. So in thinking about it in those terms, in other words, not hypothetically, I'll just review with you a couple of your answers. You first were asked, do you support or oppose the death penalty? You said support. Is that the way you still feel?
Yes.
Okay. If you don't mind, if you turn to page 13. And on this page, you were given a series of 7 choices to read through and elect which one best or most accurately represents the way you feel. You circled C, and that says, I generally favor the death penalty, but I would base a decision to impose it on the facts, law, and instructions in the case. Is that still the way you generally feel about the death penalty?
Yes.
Okay. Given your personal views on the death penalty, do you believe that the death penalty should be considered or applied in every case where a murder has been committed?
Yes.
Okay. If the court were to instruct you in a case that it was not to be considered for some reason, or the state was not seeking it, would you follow the court's instructions?
Yes.
All right, so if it were not instructed to you, you don't believe then it should be applied in a case?
But if they're asking and
and the state laws allow it, then, you know, then it's no question then.
Okay. So let me just ask you this, is there anything about your belief on the death penalty that you think would either impair your ability or prevent you from being a juror and applying only the instructions the court gives you?
Okay.
And it may have been confusing the way I asked that.
Yes.
Let me re-ask it. Will you follow any instruction the court gives you in accordance with the law in this case, even if that includes the death penalty or to not consider the death penalty?
Yes.
All right, that will conclude my questioning of juror 1624. I'll allow the state if there's any for dire.
Thank you, Your Honor. Good afternoon, ma'am. So in this case, during this trial, you will be instructed that the state has to meet its burden of proof beyond a reasonable doubt. And unless and until we do that, Mr. Daybell is considered innocent until proven guilty. Is that an instruction that you can follow? And you consider him innocent with a clean slate going into this?
Yes.
So if you determine after following the court's instructions that Mr. Daybell is guilty after hearing all of the evidence and deliberating, then you might be in a position to decide based on information presented to you and based on the judge's instructions, whether or not to impose the death penalty, which is a separate decision from whether or not he's guilty. Would you be able to follow the judge's instructions and fairly consider all of the evidence before deciding if you think that the death penalty is appropriate?
Yes.
So as you sit here today, have you made up your mind that the death penalty is appropriate, or are you willing to keep an open mind and follow the judge's instructions?
I would follow the judge's instructions. I've never broken the law.
On the bottom of the questionnaire, on the bottom of page 12 in your questionnaire, there was a question: do you feel the death penalty is used too often, too seldom, or don't know? And you wrote, it depends on the laws. What did you mean by that?
Well, every state, I've lived in several states, but every state is different.
Sure.
And
is that because you would base your decision on what the law is and what the judge instructs you?
yeah.
Okay. I just have another question for you. When on the part of the questionnaire that asks, how do you feel about the death penalty? You wrote, accused gets time to prove innocence. Now, in this case, Mr. Daybell doesn't have to prove his innocence. The state has the burden of proof. And
Oh, yeah, that's.
okay. So could you explain what you mean by that, or?
Well, you know, they get so many appeals.
Oh, do you mean that the accused gets time to appeal? Is that what you meant by that question?
Yes.
Okay.
Yeah.
Okay, so you understand that Mr. Daybell doesn't have a burden of proof in this case?
Right, Fifth Amendment.
Yes, okay. Thank you very much. Your Honor, I have no further questions for this juror. Thank you.
All right, thank you. From the defense.
Hello, juror number 624, where I guess we visit again for a little bit, right?
Okay.
If I understand you correctly, you're in favor of the death penalty, right?
If that's what the state is calling for.
Okay, so if the state is calling, if the prosecutor is calling for the death penalty.
They make the state laws.
Oh, the state laws. Okay.
The state laws.
Okay, so if you're following the state law and it says, well, if you're convicted of murder and there is a conviction, you have two choices. You have the choice to impose life in prison, or you have the choice to impose the death penalty. Would you agree with that? If that's what the state law says?
I thought the jury doesn't do that.
Okay,
I
well,
thought the judge decided, you know, death penalty or life imprisonment.
but if the judge instructed you that you're to decide life imprisonment or the death penalty, and let's say the judge says it's up to you as the jurors, right? Are you following me?
Yeah.
Okay, and let's say the judge decides that you have to do that in Idaho. Your position is you favor the death penalty now, right?
That's,
There's no wrong answer, ma'am. It's okay.
yeah.
Okay, so if you favor the death penalty, if someone's convicted of murder and you favor the death penalty, you start at the point that that person should get the death penalty unless somebody convinces you to impose a different sentence. Would that be fair?
Yes.
Okay, so if we're gonna, if, you know, whoever the defendant is gets convicted of murder, you're a person who strongly believes, and again, there's no wrong answer, that the death penalty is on the table and that person will get the death penalty unless I'm convinced of something different. That is a fair statement of where you are, right?
Yes.
Okay, Judge, I have nothing else. I'm gonna move for cause, Judge.
All right, response from the state?
Your Honor, if I could just ask this juror a couple more questions.
Few minutes.
Ma'am, I'm sorry, I know this process can be a little bit confusing. And maybe in my questioning, I should have made it clearer that the jurors are the ones who decide whether or not the death penalty is imposed. But in this case, should Mr. Daybell be found guilty, it will be up to the jurors to weigh whether or not the death penalty is appropriate. And you'll be instructed that that decision can only be made after considering all of the evidence. And you'll be instructed that you can't actually decide that in advance, but you'll have to consider the instructions from the court. Are you able to set aside any personal feelings or maybe leanings that you have and follow the court's instructions and enter into that discussion with an open mind?
Yes.
Okay. And on your questionnaire, and this may have already been asked, so if it was, please forgive me for asking you again, but I believe on your questionnaire, you indicated that you generally support the death penalty, but that you would be willing to base your decision whether to impose it on the law and instructions from the judge. Is that still correct as you sit here today?
Yes.
Thank you very much, ma'am. Your Honor, the state would object to striking this juror. I don't believe the cause has been shown. I think.
I'll allow one more line of order on the issue before I make a determination, Mr. Breyer.
Thank you, Judge. So ma'am, when you say you favor the death penalty, that's your preference, correct?
Yes.
Your idea is that that's where you would go if someone's convicted of murder, you would say, listen, I'm in favor of the death penalty. But isn't it still your position that in order to avoid you imposing your favor, someone's gonna have to convince you to change your mind about that, right?
I lived in Florida when Ed Bundy was around.
Right. Okay. So your belief is that we impose the death penalty unless you convince me otherwise. Would that be fair?
Yes.
Okay, thank you. Nothing else, Judge.
All right, so juror 1624, I guess to try to summarize your thoughts here, if the state is seeking the death penalty and there was a guilty verdict, would you automatically vote for that, or would you follow the court's instruction and consider all the facts as to whether or not it should apply?
The facts would weigh heavily.
All right, so to clarify then, you would be willing to follow any instruction the court gives you, even though you may favor that as a punishment, and you would follow the law and the instructions the court gives you?
Yes.
All right, the court's going to overrule the challenge as it relates to juror number 1624, and that will conclude the voir dire individually of the juror. So thank you for returning. We'll have you go back to the jury room for further instructions as we talk to the other jurors in this case. Let's next talk to juror 1640. All right, juror number 1640 is returning. We've got some individual questioning for you here. I know we already went through questions about hardship. I did want to note in your questionnaire, you talked about a family vacation planned and paid for May 8th to the 10th. Is that still on your plans, was the plan?
Tentatively, yes, the airlines can be rescheduled if needed.
Okay, so you are not requesting to be excused because that's something you couldn't move?
Correct.
Okay. Council, there was some expression of knowledge of the case in the questionnaire, so I'll commence with the board dire. We'll have the state begin on the issue of any possible bias and then the defense on that.
Okay, thank you. So juror 1640, just again, remember there's no right or wrong answers. Just tell us what you think, how you feel. It looks like you did see some headlines from Idaho Statesman or social media.
Yeah.
What social media would you seen headlines on?
Probably Instagram would have been like the platform, and then the news outlet would have been NPR.
Okay. And would you say that you followed this case closely?
No.
Do you recall if you ever actually read any articles or just the headlines?
I have not read any articles.
Okay.
Just
And have you watched, do you know if you've seen, it looks like you knew something involved in Hawaii. Do you know if you watched anything on TV regarding this case?
I have not watched anything on TV. It was probably just like in conversations with like family members who may have done stuff, and we're just talking about things. But I myself have not watched anything.
Okay. Do you have your questionnaire with you?
I do.
On page 19, question 10E says, would you be able to put out of your mind what you have read or heard about this case and render an impartial verdict based solely upon the evidence presented in this courtroom. And you marked no, but then you wrote, have not read or listened closely to any reporting on this matter. You explain that?
Sure, I probably meant to say yes.
Okay.
Yeah.
So, and just to be clear for the record,
Mhm.
are you telling us today that you can absolutely commit to setting aside anything you have learned about this case and give this defendant the clean slate that he has a right to?
Yes, that is correct. I do not have any, like preconceived notions of anything.
I have no further questions about Ida.
No questions, Judge.
All right, there's another issue we'll discuss next with you then, Juror 1640. In your questionnaire, there was a section beginning on page 12, and that was questioning you about your attitudes regarding the death penalty. Do you recall reviewing and answering that section of the questionnaire?
I do remember it.
Okay, in this case now, we're not dealing in a hypothetical situation, so it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. Remember, any penalty you're considering should be considered as if it is absolute and will be carried out in the case. So with that in mind, I'll note that you check both boxes. Do you support or oppose the death penalty? You said you support and oppose, and note I see both sides, but overall oppose. Is that still the way you feel about the issue today?
It is.
Okay, looking on page 13, you had another response when you were given 7 choices about what most accurately describes the way you feel about the death penalty. You chose D, which says, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel about it?
Yeah.
Okay. So as I understand it, then you do not have any opinion that it should automatically be considered in every case where a murder's been committed?
Yeah, that's probably right.
All right, and you are willing to, despite any personal views on the issue, follow any court's instructions, even if it involved you considering it despite your opposition?
Yes, I agree.
Okay, that wasn't a good question. I apologize. Let me ask you this. Do you think in any way your views may prevent or substantially impair you from serving as a juror here if you are given instructions about the death penalty?
No, I don't think that would impair my feelings. I think I'd be able to carry out a verdict, and my opposition maybe, or feelings of opposition would not be, would not stand in the way.
Okay, so back to your choice D then. You said you think you can put aside those feelings and impose it if that were called for by facts, law, and instructions?
Yeah.
All right, thank you so much for your responses. I'll allow the state if there's any for dire for this juror on the issue.
Just briefly, Your Honor, thank you. Juror 1640. On the bottom of page 12, you wrote, death penalty, in my opinion, should only be an option in extreme cases. Without getting into too much detail, what would be an extreme case?
Yeah, so something that was really horrific, and the facts were presented in a way that showed, like, in my opinion, that individual had done something like to the extreme.
Okay.
Yeah.
And it's fair to say, I think based on what you how you've answered your question, you don't like the idea of giving someone the death penalty, which is normal. I think a lot of people feel that way. And I don't want to retread what the judge has said, but in this case, if there is a conviction, you will get a set of instructions that you have to follow to determine if the law and facts call for the death penalty. And so even though, and we're not asking you what you're going to do because we don't know, but will you commit to following those instructions and the law?
Yes.
I have no further question, Your Honor.
No questions, Judge.
All right, thank you, juror number 1640. That concludes your individual or dire. I'll have you return with the bailiff for further instructions to wait while we talk to the remaining jurors.
Thank you.
We'll next talk to juror number 1761. All right, welcome back, juror 1761. We're going to have some individual questions for you and here outside the presence of the other jurors. Encourage you to let us know everything you can about the questions given to determine whether or not you're able to serve. A couple of things raised in your questionnaire I'll begin with is you did have a couple of concerns about both potential child care and also a long-term training you're involved in. Do you want to, I guess, discuss whether or not either of those would be significantly impacted and distracting to you if you were required to serve for the long term of this trials?
The training can likely, I can get into another cohort of the training. I have to drop out of this one and it would be about a year before I could get back in it, but it won't substantially impact my employment.
Okay, so stopping there, if that did happen and you were required to serve, do you think you'd feel some sort of anger or resentment that you got stuck in jury service, got behind on that, and maybe have that impact your ability to see things impartially?
I don't think it would impact my impartiality or attention.
All right, thank you. Any other concern you may have as it relates to any hardship you may suffer?
If we were to be sequestered, I would, so I have my kids 85% of the time. So I would have to coordinate with their father. I have absolutely no idea what his travel schedule looks like. He travels on vacation.
Okay, and without making any promises, it's hard to predict how long that would be if there were sequestration, but it could be a week, it could be more than a week. I don't know that it would be 2 weeks, but again, you can't hold me to that because it could turn out to be much longer. If that did take place, do you think that would create a real distraction for you worrying about what was going on with the care of the kids?
As long as they have an adult to supervise them, they are old enough they can manage.
Okay, well, I very much appreciate your responses there. There was some other minimal knowledge of the case. I'll let the council go into that if you wish. So I'll let the state commence with any individual voir dire, including topics of hardship or bias.
Thank you, Your Honor. And then just to follow up on that a bit. Yeah, I wasn't sure if I heard what your last answer was to the court, but do you have another adult to be with your children if there's a prolonged sequestration, your husband's or your ex is out of town?
My dad is usually the backup plan. He is traveling for a couple weeks in May. My ex has a significant other who arguably could watch them. I have friends, so I mean, there are people who would watch the children if I were to not be available to watch the children.
So it sounds like that in this regard, you're not concerned about being in service of the jury.
No, I think they would be.
Excuse me. And I guess, you know, when we began this process this afternoon, the judge had asked a question if anything had changed on the questionnaires you completed, and that we had these hardships and you had mentioned them. Is there a reason why you didn't bring that up, or you just didn't feel like it was an issue, or what was your reason for not bringing it up?
Because I had checked, like, if I were to need to, day to day, they're fine, they're old enough, you know, they get themselves to school and home from school and all of those things. My oldest is 18, so arguably he is of legal age. There are people who could, it would be challenging, but it's the same thing if I go away for a weekend, it's challenging to make sure the kids are covered, so it's nothing I haven't managed before.
Okay, thank you. Your Honor, did you want me to go into bias questions at this time as well?
Yes, please.
Thank you. So ma'am, I just have a couple of other questions. I noticed in your application, you are a PhD psychologist, is that correct?
Yes.
Can I ask what field of psychology do you typically work in?
I'm a clinical psychologist.
Okay, so you do evaluations and IQ assessments and those types of things, is that fair?
I've done this.
Okay. So my question is, with that background, if you were chosen to be a juror and you, let's say you heard from experts or mental health folks and you disagreed with them from your observation of the evidence and information, do you think that would likely impact your ability to be impartial and render a verdict?
I mean, the field is relatively subjective as much as we want to say that it's not. So the fun thing about the field is that you have very different perspectives on the same information. So I've learned to not trust my own opinion necessarily in the face of other people who have touched the data, who've done the things they've done.
And then maybe with the opposite situation, maybe if it's a situation where you listen to these weeks and weeks of evidence and information, and then you don't hear anything from anybody about any witnesses or parties' mental health, that you think that there should have been something or could have been a problem, would that cause you any concern?
No. No.
And in your work as a clinician, as a clinical psychologist, have you ever been involved in the criminal justice system in terms of assessing competency or things like that, criminal competency?
Not criminal competency, no.
But well, in any way, the criminal justice system, have you been? Certainly, sorry. Have you done any professional work as a PhD in any part of the criminal justice system?
I have testified in the past as a witness in the capacity of my work.
As an expert?
Yes.
In a criminal case?
It was not, how would you define parental termination, parental rights termination?
So would that have been in a custody capacity as a parenting type of an issue?
It was a situation in which the state was trying to determine if children would stay in foster care or if the rights would, or if they go back to the parents.
Just one more over there, please. Your Honor, at this point, I don't have any other questions on this topic.
All right, thank you. Any questions from the witness? All right, so the next issue we're gonna take up, juror 1761, is in regards to questions you previously answered relating to your attitudes regarding the death penalty. That was starting on page 12 of your questionnaire. Do you recall going through those questions last week and answering?
Yes, yes, I do.
And I'll advise you that in this case, it may be necessary for you to make that determination in regard to the imposition of the death penalty or some other penalty. And remember, when you're considering that, you need to consider it as if it is absolute and will be carried out in the case, if that's what you determine. So as you're thinking through that, I'd just like to review a couple of your answers with you, and then I'll let counsel ask you as well if they wish. You had a couple of choices when it was, do you support or oppose the death penalty? And you checked the box saying you oppose it. Is that generally the way you feel about it?
I am not a big fan, so yes, I would say that kind of at a base level, I oppose it. I also recognize that it's legal, so.
Okay. Going to the choices you had about what most accurately represents the way you feel, and understanding these are not your words, they're words of the questionnaire, but you selected a box or a choice B, and that reads, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Is that still the way you feel as you sit here today?
Yes.
All right, so although you may have some opposition to it, is there anything about your views that you think would prevent or substantially impair your ability to serve as a juror and follow the court's instructions, even if that included that you must consider the death penalty if that were provided in an instruction?
I don't think there's anything that would impede my ability to take the instructions.
Very well. Thanks for your responses. That concludes my voir dire on the subject. Does the state have any voir dire?
Yes, Your Honor. So, ma'am, again, now considering your status as a licensed psychologist when thinking about the death penalty, and I don't pretend to know the answer to this question, is there any possibility or likelihood that a decision to impose the death penalty would have any ethical implications for your licensure with a psychologist? Is there anything out there like that that you might later discover be an issue?
Not for the APA ethics code or the FMC rules.
So as you sit there, you don't feel like there would be any inhibition at all in that regard?
Not
Do you feel like there'd be any inhibition in any regard?
I don't think so.
When you said that you recognize that the death penalty is legal, but you're not a big fan, can you just be a little bit more specific about that position?
Sure. Morally, I think that there are some issues with the death penalty in general, but I also don't get to make that decision. So if I was in a position where I'm sitting in a case and that is part of what I'm being asked to evaluate, if that's part of the penalty, that's part of the penalty.
And so with respect again to determining either guilt or punishment with Mr. Daybell, and if you were to receive an instruction from the court at some point in the trial that mental illness is not a defense in Idaho, but you were to perceive that Mr. Daybell did have some likely mental impairment, would that impact your decision then to either find guilt or to be disinclined to impose the death penalty?
I I don't think that, again, trying to follow instructions, right? That if that is not a defense, I wouldn't hold that into account.
So you're assuring us, the court today, that even though you have these moral reservations about the death penalty and these potential biases at your professional status, that you would set all that aside and that you would listen to the instructions given by the court, consider the facts, and then apply the law. And even if that's completely against your own moral base of taking someone's life. So I'll ask this, as you look at the defendant today sitting here, if you were put in that position, if there is a finding of guilt, and you're sitting in a jury room, considering the evidence and deciding whether or not the death penalty should be imposed, and you're morally opposed to it, you could render a decision to take Mr. Daybell's life.
Yes, if that's what we've been instructed to do, then there's evidence and yes.
Okay. Thank you. Laura, I don't have any more questions.
No questions.
All right, that'll conclude the individual for Dyer then for this juror. Thank you again for coming back, and we'll have you return with further instructions waiting from the marshal for our remaining jurors. Okay, our next juror will be 250. All right, welcome back, juror 250. Give me just a moment. I was briefly reviewing the questionnaire. You may have already mentioned this. If you did, well, you did hold your card up that you had some knowledge of the case, and also you did have some concern in your questionnaire about amount of work PTO, but I think you clarified that and have more information. Could you just reiterate that, please?
Sure. Do you want to start on the information that?
Yeah, in terms of your PTO.
Oh, that, so I thought, well, I do have 3 weeks of PTO, but it's irrelevant because my organization will cover the entire jury, or sorry, I don't know how.
The time of service.
Yes.
Okay, I don't think there's any issue then. Otherwise, you related as to hardship requiring additional board hire at this point. There was an indication though when you raised your card that you know something about the case, so I'll just allow the state to make any inquiry as to whether or not there's bias, and then we'll allow the defense after that. So any questions from the state?
Actually, Your Honor, I did have one question regarding some health concerns that this potential juror referenced about not hearing or seeing things or hearing things at certain frequencies. Is that something we could chat about? Or would you rather talk about that privately?
Sure, go ahead.
Oh, thank you, sir. So some of the evidence that's going to be admitted in this case will be audio or video. Do you anticipate that that would be a problem for you?
No.
Okay, thank you very much, sir.
Well, as long as I can play or maybe turn the volume
And I think we can make those arrangements to turn the volume up.
Okay, we do have ways to make accommodations, if that's an issue. I mean, it should be similar to how we're doing today in terms of volume, what you'd be listening to. But we can certainly make accommodations if needed to for vision, for hearing. So you can continue, Ms. Beatty.
Thank you, Your Honor. In your questionnaire, you talked about a class that you took. Is that something you're comfortable talking about? Okay, a psych class?
Yeah,
Okay, can you talk a little bit about that situation?
the first one or?
The first one, I think that's the one that kind of. Thank you. I'm sorry about that. Can you talk a little bit, the first class?
Yeah, so going to CW, it just is like needing core classes to go along with, your actual course. Like psych was one of them that I picked. And every time I went in there, he seemed to know everything about everyone. He seemed really pompous. He would talk about how humans are so easy to predict. And it didn't sit well with me, with his view on everything. It got to the point where I pay attention to a lot. So I knew that he drank like a 12-ounce sugar-free Red Bull, and it was always hidden behind his podium. And so when he made a comment like that, I said that, hey, you have a sugar-free 12-ounce Red Bull behind you. And so, but I wound up failing that one because every time, at the end of the week, I think it was, you had to go on your online Blackboard, and he would want you to tell him different ways about how God doesn't exist. I didn't think it was appropriate for the course, so I opted out of it, and I wound up failing.
Okay, so you felt like you were put in a position, or did you, I should say, I don't want to put words in your mouth, but did you feel like you were put in a position where you had to compromise your morals?
I'm not going to compromise my morals, but.
Did you feel like he put you in that position?
Like, if I wanted to pass the class and needed to, yeah, that's how I felt.
Sure, okay, understandable. So this is a very different situation that you're in here, but you are going to be given some jury instructions. And those jury instructions will basically lay out the elements and the weight that you're to give to the evidence. They'll lay out the fact that Mr. Daybell is presumed innocent until the state proves that he's guilty beyond a reasonable doubt. And then if you find, well, I guess I won't get into that at this point, the death penalty part, I think the court will address that. But is that some, are you comfortable with following those instructions?
I'm absolutely comfortable with that, and I do believe it, like I said, until proven guilty, so I'm completely behind it. I can separate.
Of course. And if there was some aspect of the law or one of the offenses that just didn't sit well with you and you really disagreed with it, would you feel that, would you find him not guilty on principle, or would you find him guilty on principle?
Oh, okay, I'm sorry, can you repeat that?
Sorry, and I did a terrible job asking that question, actually. So if you either felt strongly that Mr. Daybell was guilty or shouldn't be guilty or should be guilty, but that didn't really comport with the instructions, would you disregard those instructions?
First off, I wouldn't disregard any instruction, but can you define feel that? Is it like?
Sure. Yes. So if you felt in your gut that the law should be different, like you looked at the instructions and you understood what the evidence was, but you felt, I don't like the way this law is written. I think that it should require that the state prove more, or I don't think that the state should have to prove that much. Or, I don't feel like the state met its burden of proof here, but I also really just feel like he's guilty. So even though the law doesn't really allow that, I'm going to convict him or alternatively acquit him based on my own beliefs rather than the evidence.
No, I would follow the instructions of the law.
Okay, awesome. Thank you so much. And I'm sorry to intrude into those questions, but I really appreciate your honesty. Thank you. I have no additional questions. Thank you, Your Honor.
Thank you. Mr. Pryor for the defense.
Just one area that piques my interest. And do you have a copy of your questionnaire, sir?
Yes.
Would you go to the top of page 10? And I'm looking at number 11, it says, do you have any opinions about law enforcement officers that might affect your impartiality or ability to evaluate the testimony of an officer? And you marked yes. Do you see that?
I do.
Can you talk to me a little bit about why you marked yes?
Well, I'd have to structure my thought on this. Give me a second.
Okay.
I don't know that this applies to Idaho officers, as I stated in the beginning of my response there. But I have seen other states online where police officers will lie to protect their own or turn off their body cams or go through with them. So it's kind of a middle ground. I'm not sure how to answer that. That's why I said yes, because there is a little bit of bias on other videos that I've seen that would be in the back of my head. But I have had so many interactions with police officers in this state, and every one of them has been positive.
Right.
So I don't feel that way here.
Not here.
Yes.
But if you hear testimony about videos being turned off and no recordings, is that going to pique a concern for you?
I mean, I don't think that they should ever turn off their body cam while they're in the middle of something. So that it would pique some sort of a concern.
But you don't think that unless you see that sort of situation, that you have a negative opinion of police officers?
On the whole, I don't have a negative opinion.
Okay, that's all I was seeking, is that you're not going to prejudge a police officer just because he's a police officer. Yeah. Okay, Judge, that's all I have. Thank you.
All right, thanks for the responses on those sections. The next issue I want to discuss then, Juror 250, relates to your questionnaire and the section you filled out called Attitudes Regarding the Death Penalty. Do you remember reading through those questions and answering those questions?
Yes.
And having now thought about it for a few days since you filled the questionnaire out, are the answers you made in the questionnaire still the way you feel today?
What page was that on?
It starts on page 12 and goes 12 and 13.
I'd like to confirm. Number 5 on page 13.
Yes.
Well, I didn't quite understand what would bring a death penalty to someone. So that one, being that everyone can change. If somebody was found to have murdered someone, obviously there's law that needs to be followed. So there should be consequences for it. So that's my only alteration. Everything else is accurate.
Okay, and thank you for taking the time to review it. I'll have some more questions about it. Let me preface that and let you know that it may be necessary for you in this case to make a determination in regard to the imposition of the death penalty or some other penalty. And as you're thinking about that and considering it, you have to consider it as if it would be done and absolute and carried out in the case. So if that's where you are approaching the way you think about it, the first question that I'll just ask you about in your questionnaire was whether or not you support or oppose the death penalty, and you check the box saying you support it. So is that still the way you feel?
Yes.
Okay. Another answer you provided was part D on page 13, question 6. You had 7 choices there about what best represents how you feel. And about the death penalty, you said I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, laws, and instructions in the case. Does that still accurately represent your thoughts on the issue?
Well, I suppose in a way, but it would contradict my change to 5. The death penalty would be justified.
All right, and so I can tell you have thought about it. You selected an instruction saying you would follow the facts, the law, and the instructions the court provided. Is that correct?
Yes.
All right, so is there anything about your view on the death penalty that you think would prevent or substantially impair you from serving as a juror in this case if I were to give you instructions about the death penalty here?
I have no objection to it. I had never had a thought in my life about it, honestly. I just know that bad people would have penalties.
All right, and what I'll finally ask you then is, would you be of the opinion that it's going to be appropriate in every case where there's been a murder, or should automatically be considered if there's been a murder committed?
Can you ask that again, please?
Would you be in favor of the death penalty in every case where a murder has been committed?
It's hard for me to answer that because by who? I mean, that's really hard. You'd have to look at the evidence.
All right, so going back to your previous response, then you are indicating you will follow the law, facts, and instructions in this case if you are provided those.
Yes.
All right, that concludes the court's voir dire for this. Sure, does the state have any voir dire?
I don't believe so, Your Honor. Thank you very much.
No questions, Judge.
Okay, juror number 250, that concludes our individual voir dire. You can return, please, with the bailiff. We'll get through the rest of the jurors and then give you further instructions. Next up will be juror 438. All right, juror number 438 has returned. There's a couple of issues in the questionnaire we just want to address with you individually, both relating to prior case knowledge as well as, I know you talked about or requested a hardship for some travel plans you had, but also expressed a desire to perform your civic duty, which we appreciate. I think where I'd like to begin then with this particular juror is just some questions about your prior knowledge of this case or any related case. You did, in your questionnaire, have a response about someone being tried and convicted and being tried, I believe, in Arizona. And here, without other jurors present, if you could just explain in some detail what you know about that and what information you have.
It's just what I've heard on the local news as of late, that Lori was going to Arizona for a second set of trial. I don't know all the details of it, but that's all I really heard.
Okay, and I noted, because the response was in a question talking about some other individuals, but when you say Lori, who are you referring to?
Lori Daybell.
Okay, I just wanted to clarify that point, and I'll have the attorneys at this point do their board diary, beginning with the state. Who will be doing that?
I will, Your Honor.
Mr. Wood, if you'd like to inquire as to any potential bias, and you can go into hardship as well.
Okay. Just going off what the judge just spoke with you about, it sounds like you're aware that, Lori Vallow or Lori Daybell was convicted in Idaho. Did you follow the case or closely? Do you know any of the details of what she was convicted for?
No, I do not.
So your knowledge is just limited to the fact that she was convicted of something.
Correct.
And you understand, you understand that this defendant has an absolute right to a presumption of innocence. And would you in any way hold the fact that she was convicted of something against him?
No.
So even knowing that, you can set that aside and give him an absolutely clean slate to begin with.
Yes, I can.
You did mention the hardship.
Mm-hmm.
Tell us about that.
I wanted incentive at work. I'm a diehard Detroit Lions fan. Born and raised in Michigan. The draft is only going to be in Detroit one time for the rest of my life. So I put it on there since coming to grips with everything, I somewhat have come to peace that I may not be able to go. That this would be a priority over that.
Okay.
My brother's going to make out really well.
I was just gonna ask, you have someone you can give that to and feel good about that, or at least okay about it?
He feels good.
And I don't want to make light of the situation at all. Do you think will that in any way affect your ability to give both sides of this trial a fair trial?
No, because the first and the second and third round are all prime time. So
Okay.
I would like to think I'm going to be higher.
Okay. I'd like to speak with you for just a moment about some things you put on your questionnaire on page 9. And if you can turn to that, and then if you can just look at that and let us know if that's something you sort of talk about in private.
Yes, we'll talk about that private.
Your Honor, I wonder if we can speak about these issues in camera or have the public
Excuse for that portion.
excuse for this portion.
Let me just briefly sidebar with counsel and see. All right, counsel, with this particular juror, we've got one other juror also that have some more personal matters we want to discuss outside the presence of the public. So we are going to suspend for that time frame the broadcasting of the proceedings, as well as clear the courtroom of everyone except required and necessary personnel to remain on the record and discuss matters that to which these jurors are entitled to their privacy. So I'm going to request that our marshals do clear the courtroom. If the clerk sees the broadcast at this point, and we will come back on the record with additional board dire publicly once we've concluded that with these two jurors. So marshals, if you please take care of that now. Without a break? Yes, sir. Okay, thank you. All right. Let's have juror 512 return. All right, juror number 512, thank you for returning. This will be the time for your individual for dire. I know it's been a long afternoon. Thank you for hanging in there with us. We wanted to address a few more topics outside the presence of the jurors. At this time, I don't know that I saw anything I thought needed further voir dire on for hardship or bias. Does the state have any questions on either of those two topics?
Just a couple of quick ones, I hope, Connor. Ma'am, I just want to go to the hardship section of your questionnaire. And these are probably very fast questions, but you had noted that you were concerned about your daughter having a knee surgery, your availability to take care of her children. Is that not a concern anymore?
It's a possibility, but at the rate that the doctors are moving towards that, I'm betting that we can make arrangements. We'll have enough advance for you.
So you feel comfortable, there won't be any kind of
I
hardship.
think so.
And then you also mentioned some personal doctor's appointments that.
Yeah, they can get in.
I'm sorry, could you ask the question?
You also just mentioned some personal doctor's appointments, but those are okay now.
Yes, those are just checkups and then I can move those. But we will need to be done before July 15th.
Okay, is that the trip to Europe?
Yes,
Is that a prepaid trip by any chance? Or?
I paid for it already, if that's what you're asking, yes.
I don't think anyone's projecting this trial will go that far. Thanks for letting us know. No, I don't have any more questions.
No questions, Judge.
All right, thank you. So juror number 512, the next issue we're going to discuss with you relates to your attitudes regarding the death penalty, and that is contained in your questionnaire starting on page 12. Do you recall reading through those questions about the death penalty and answering them in the questionnaire?
I remember.
All right, as you sit here today now with some time having passed since you filled it out, you still feel the same way, and are your answers accurate?
I think so. I think it's the same. I've thought about it frequently off and on over the decades.
Okay.
And
So when we think about it, it's generally hypothetically, we're in a different situation here. In this case, it may be necessary for you to actually make a determination in regard to the imposition of the death penalty or some other penalty. So remember, when you're thinking about that in answering these questions, any penalty you consider should be done as if it is absolute and will be carried out in the case. You understand that?
yes,
Okay.
and we can comment.
Yes.
I think I wrote in here, but just to make sure that you understand that I know that there are guidelines and rules that establish that as an option. And that's what I feel comfortable following, guidelines and rules. Okay, so it would go past my personal feelings
Okay,
and be based upon those that you would address to sort them.
all right, you are kind of tracking right along with where my questions would go, so I appreciate your responses there, so I'll just note that when you were asked if you support or oppose the death penalty, and only given those two choices, you said support, is that right?
Yes.
Okay, and then when there was a little more detail in an answer, there were 7 choices you had about what most accurately represents the way you feel. You selected a choice that says, I'm generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. So does that still accurately represent the way you feel? Okay, so given your choices then, would you be in favor of the death penalty in every case where a murder has been committed?
No.
All right. Is there anything about your views on the death penalty that would prevent or substantially impair you think, from serving as a juror here and following the court's instructions?
Don't think so.
All right, so going back to your response in part D, you would be willing to follow the court's instructions on the death penalty, whether that was that you should consider it or you should not, or anything else the court instructed on that topic?
Can you repeat the question just to make sure I got it?
Yes, are you willing to follow all the instructions once you receive the facts in this case?
Yes.
All right, that would conclude the court's voir dire for this particular juror on that topic. Anything from the state?
No, Your Honor.
Nothing from the defense.
All right, thank you for completing a questionnaire and coming back. We've got one more juror to talk to individually, and then we'll have you return here shortly. All right, final juror we'll discuss voir dire on individually is 537. Does the state intend to ask any questions on bias or hardship?
The state does not, Your Honor.
Defense does not.
Okay, thanks, counsel. I'll just put that on the record now that the parties pass additional voir dire on 537 on hardship or bias questions, and the court will inquire as it relates to the death penalty issue. All right, juror number 537, thank you for returning. You're the final person we're talking to in this group, so thank you for your patience today. We've reviewed your questionnaire, and there's just one final topic we would like to address with you individually, and that is as it relates to your answers on attitudes regarding the death penalty. Do you recall reading through that section of the questionnaire and answering those questions?
Yes, I don't remember exactly what my answers were, but I have it in front of me. Got it?
Okay, it may be helpful for you to reference it while we discuss it. So if you do have a copy there, you turn to page 12. All right. So when answering the questionnaire, it might have just been a concept to you, but at this stage, I want to advise you that it may be necessary for you to make a determination in regard to the imposition of the death penalty or some other penalty. And when you're considering that, consider that any penalty you're thinking about could be done and absolute and carried out in the case, or consider that it would be done, I should say, and absolute and carried out in the case. So you were given a choice on page 12 about whether you support or oppose the death penalty, and you didn't like having only two options, so you made the third option and said neither. Can you explain your thoughts in answering that question?
Well, when I said neither, I am not strongly for it or strongly opposed. I know there's a huge arc in terms of what you believe and what you think you can do, can't do. I don't have a really strong opinion. Do I believe that it's okay? Is it reasonable? I do believe that it's a reasonable consequence. I don't oppose it, as in, I don't think that I would never stand up against it and say that's absolutely unthinkable. We should never have that as a consequence, because there are going to be some cases where that's just what happens.
Okay, and I appreciate your comments on that. If you look at page 13, you listed some other thoughts there also. I'm just looking at your responses on number 6, and it looks like you maybe vacillated back and forth between C and D choices and ultimately went with D. But you had 7 options about what most accurately represents the way you feel. And where you landed is, I am generally opposed to the death penalty, but I believe I can put aside my feelings against the death penalty and impose it if it is called for by the facts, law, and instructions in the case. Considering back then, is that still your attitude towards it today?
I still feel like I'm maybe in between both C and D. I understand that it is and can be a consequence to some actions, but I'm not, again, I can see that there would be cause for it. I know that it's a legal option, I know that it's a consequence, but I don't think that I don't have any preconceived notion of whether or not that's good or bad, whether I'm opposed or for it. That makes
Okay.
sense.
Part of that instruction that I'm looking at, not instruction, I'm sorry, the choice was, would you follow the facts, law, and instructions given to you in the case? Is that
Absolutely.
okay? So I can tell you thought through the topic quite a bit, and let me just ask you a final question. Would anything about your views on the death penalty you think prevent or substantially impair you from serving in this case and following the court's instructions as it relates to the death penalty, regardless of what those instructions may be?
Absolutely not. I would follow the instructions based upon exactly what I was given.
All right, that will conclude the court's voir dire on the topic. With this juror, does the state have any questions?
I don't, Your Honor. Thank you.
No questions from the defense judge. Thank you.
All right, juror 537 then. That concludes our individual voir dire. If you'll give us just a moment, I'll have you return with the other jurors and we'll bring you back into the courtroom for one more brief instruction, and then we'll be concluded for the day. All right, we can have the rest of the group about that.
All right, great.
Thank you. Please be seated. All right, ladies and gentlemen of the jury, you are turning now. We went through the individual voir dire. This concludes voir dire for this group. In order to make sure everyone's charts are lining up with who's still here and who's not, you do us a favor, and those remaining jurors, please raise your red card and just hold that up here for a few moments while everybody's allowed to take their notes. All right, with that, you can go ahead and put those down. I'll ask now that that's been confirmed, does the state pass this small group for cause?
Yes, Your Honor.
Does the defense pass for cause?
Yes, Your Honor. Thank you.
All right, thank you. So ladies and gentlemen of the jury, you have been passed for cause. We're continuing to question these groups of jurors until we reach the necessary number of jurors for the attorneys to exercise their peremptory challenges. You'll be instructed to contact our jury commissioner, Randy Rutland, who's going to provide you further instructions about when he will be returning, and there will be a time you'll return. While you're waiting for that, please remember to follow the court's instruction to not investigate this case, look the case up, go and find information on the case. If you happen to see anything being reported about it passively through news, etc., try to make an effort to not listen in so that we can keep you as impartial as you are at this time, and also avoid talking to anyone about the details of the case. As it comes to the topic of discussing when you may serve and that you may serve, of course, that's okay to talk about with friends, family, employment, etc., but just refrain from discussing any detail or fact of the case. And with that, we appreciate your continued service. You'll be advised when to return, and we'll see you back whenever that takes place. So with that, are we okay to conclude for the day with this group from the state?
Yes, Your Honor. Thank you.
From the defense, Your Honor. All right, thanks all for your time. Please rise for the jury.
Come this way, please.
All right, we'll be in recess for the day, council. We're intending to follow that same schedule tomorrow with a group at 8:30, another at 1:30. Is that acceptable for the state?
Yes, Your Honor.
For the defense?
Yes, Your Honor.